Your Lordship.
My lord, there is defect, my lord, defect with regard to my lord valuation statement. In absence of that, my lord, the requisite court fees has not been assessed, my lord. And since there is some urgency in the matter, my lord, that I need my lord need to correct my lord, entitled to incorporate my lord the valuation statement.
100.
100, my lord. And another defect is there, my lord, with regard to my lord delay. Section 5 application of limitation act.
Let these matters appear as to be mentioned on Monday. We'll do that and
Well, my lord, matter will be taken up. If it is taken up tomorrow under the heading to be mentioned.
tomorrow we sit singly.
At 2 p.m., my lord, Mr.
No.
Chairman,
No.
but otherwise, my lord, it will get.
No, we sit singly tomorrow.
My lord, today at 2 p.m., my lord,
Today at 2 p.m.
2 p.m., my lord, I shall inform Mr. Mukherjee, Conman Mukherjee is appearing for the other side. That is
Inform him, come at 2.
2, my lord.
Durosh matter. Yes.
My lord, may I be permitted to mention one hearing matter for inclusion, my lord?
Hearing no.
Lord, item number 106, my lord, of today's list. My lord, the matter is fixed tomorrow for ex parte hearing, my lord. It's a probate proceeding, my lord. I am the intervener, purchaser of a property from a legal heir, my lord. Now, tomorrow, if the matter is heard in the court below, my lord, this appeal will become infructuous, my lord.
You
No,
should
there
have
is no
filed some application for injunction or
No,
something.
that application is there, my lord. Matter is listed before your lordship, my lord. Well, there is no
Why
caveat,
didn't you mention the application then?
my lord.
Why didn't you mention the application previously?
My lord, application is listed, my lord. Application for stay, my lord, is there, my lord. Listed today.
Item
Item 106, lordship.
106 is under the heading hearing.
Order 41 rule 11 application.
Oh, acha.
There is no caveat, my lord. I will not take my lord more than 2 minutes, my lord.
We'll take this matter up after the 2 p.m. the other matter.
Grateful, my lord. Deep lord.
My lord, may I mention a matter for inclusion in the list, my lord? It's FAT 241 of
What's it?
2020.
A hearing?
My lord, the matter was last taken up for
Application or hearing or what?
my lord hearing.
No.
Application for inclusion.
Yes.
With the leave of my lord Justice Kumar, may I mention one matter pertaining to my lord Justice Bhattacharya?
Yes.
Single bench, my lord, an application for recalling or
Hand over.
modification. May I seek your lordship's?
No. We go serially.
Sorry, I beg you.
One application for state.
Yes. Application. Yes. Yes.
For application for inclusion.
Hand over. Yes.
Lordship, may I seek your lordship's? Kindly, this is a 2014 appeal against
Hearing.
It's a hearing. Or
Forget it.
Lordship, may I just canvass the urgency once? I'm a septuagenarian woman. My pension.
You are a?
I'm a septuagenarian woman. My pension is being denied. I am struggling to keep the wolves out of the doors, your lordship. This was heard substantially by a bench
Hand over.
Justice.
Hand over.
If I may have my lord's Justice Kumar's leave to mention a matter before Justice Bhattacharya. My lord, this is a matter on the original side. My lord's pleasure was to pass a decree in an admiralty suit when my lord was sitting singly, my lord. My lord, we seek to draw up and complete the decree, my lord.
Yes, there's a problem regarding the decree. One of the parties is not a signatory.
My lord, may I indicate, my lord, what had happened? My lord, it was an admiralty suit filed in REM. The registered owner of the vessel came forward, offered the settlement. My lord, it was settled based on which.
As per the settlement, defendant number 2 is to pay. He is not a
My lord,
signatory.
defendant number 2 is not to pay, my lord. It is a registered owner who is to pay. My lord, I'll indicate what. My lord, why
Let
that
it come under the heading to be mentioned tomorrow.
Grateful, my lord. Grateful.
Call. Origin said. Accordingly, FAT 151 of 2016 is allowed on contest, thereby setting aside the impugned judgment and degree dated such and such. We hereby allow the probate application of the appellant, thereby granting probate in favor of the propounder appellant in respect of the last will and testament of late Prabhat Kumar Sarkar dated such and such. The consequential ministerial acts shall be performed in the testamentary court for grant of such probate to the appellant at the earliest, no address to cost, interim orders if any stand vacant. Mr. Ali, was your client terminated in the meantime?
Lordship.
Yes.
In view of the above discussions, appeal being FMAT 59 of 2025 is allowed on contest.
Mike,
The order dated February 11, 2025, passed by learned Judge Fifth Bench City Civil Court at Calcutta in title suit number 196 of 2025 is hereby set aside. Accordingly, an ad interim order of temporary injunction is granted, restraining the opposite party, respondents, their agent, servants, or any persons acting on their behalf from continuing with the disciplinary proceeding against the appellant Asim Kumar Samanto, including any further steps by the newly appointed inquiry officer, Mr. Suranjan Kundu, as of today, or from the stage it had reached immediately before its conclusion. If concluded in the meantime, whichever is applicable, until the final disposal of title suit number 196 of 2025 pending in the trial court. In the event the appellant has been terminated in the meantime as a result of the disciplinary proceeding being decided against him, such order of termination shall remain stayed till disposal of the suit and shall also be subject to the final outcome of the suit. Learned Judge, 5th Bench, City Civil Court at Calcutta, is requested to expeditiously hear and determine title suit number 196 of 2025, giving particular attention to the validity and enforceability of HR manual, including the aspects of Executive Council's approval and statutory registration under the West Bengal Society Registration Act 1961, as well as the allegations of bias and violation of natural justice. The respondents are directed to file their written statement in the title suit within a period of 4 weeks from the date of this order, if not already filed, especially addressing the detailed contentions raised by the appellant regarding the validity of HR manual and the allegations of bias and procedural irregularity. Other directions are commonly.
Grateful, so it is stayed till the immediately before the conclusion. If already concluded, it has been, and the termination remains stayed. করে দিয়ে তারপর সই করে দেবো পাঠিয়ে দিই। ঠিক আছে, হ্যাঁ হ্যাঁ
একটু পরে সই করি, একটু কারেকশন আছে।
থ্যাংক ইউ। দিয়ে দিন, পাঠিয়ে দিন।
My lord, in item number
আপনি এদিকে এদের দিয়ে দিন, এদের দিয়ে দিন। হ্যাঁ, এই কারেকশন আছে, কারেকশনটা পিএকে করে রাখতে হবে।
My lord, in item number 3, I am appearing on the behalf of the appellant, Your Lordship. The matter has came before the Lojima court, my lord. The defects had been cleared, Your Lordship.
Pardon?
My lord, the matter has been came before the Lojima court, my lord. The defects have been already been cured, Your Lordship. My lord, with paper book directions may be given, Your Lordship.
Let us just check up. What was the defect?
My lord, the
of rupees 4 rupees.
my lord, talabana of rupees 4 rupees, Your Lordship.
Along with the writer.
Along with the
Talabana
right
has
of
not
notice
been
form.
put in as yet. Postal cost and Talabana has not been put in by you.
My lord, it has already been complied, Your Lordship. It has
When?
been instruction. It has been complied on. My lord, we have to take instruction.
Then counsel for the appellant submits that the Talabana and written up notice form has already been put in. Full stop, next para. The office shall ascertain the veracity of the same. Full stop, if not already put in, comma, the appellant shall put in the same within a week from date. Full stop, next para. The trial court record shall be called. This appeal arises out of what?
My lord, arise of a matrimonial suit, Your Lordship.
The trial court record shall be called for by special messenger as the cost of the appellant, also to be deposited within a week. Full stop, next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you. Give your name. Yes.
Lordship, this matter was last
You're for the appellant.
Lordship.
You have not put in the Tolabana written up notice form.
Lordship,
You have to put in that. File it to, do it within a week. We find from the office report dated June 26, 2025 that neither any Tolabana nor postal cost along with written up notice form for effecting service of notice of appeal on the sole respondent has been put in by the advocate. For sub next para, the appellant is directed to put in the said requisites within a week from date upon which notice of appeal shall be served on the respondent. Do it within a week.
Lordship.
You have to put in the requisites for service of notice on the respondent. Have you understood?
Yes.
Give your name. Yes.
The Lord, in reply, I will not take long, I will
Yes.
be very short.
Written notes. Very short reply and written notes.
Yes, written notes I have made ready, but Your Lordship, I'm seeking only 1 day's time.
Very well. You just complete the arguments formally.
I have prepared it.
You have prepared a written notes of arguments.
I am not engaged in this matter.
Very well. Yes, please continue.
Yes. Now, my lord, straight away I take the arguments which were made by Mr. Banerjee, my lord. Mr. Banerjee has said that once the license deed, parties were governed by the license deed. The license deed contains a clause that the construction has to be done within a period of...
Take the microphone a bit closer.
Yes.
Yes.
One of the best few points which have been taken are that according to Mr. Banerjee, since the license deed was executed, therefore the clauses of the lease deed can, the preconditions clauses as contained in the brochure cannot be looked into. That was one of the argument. The second argument which I could have understood that the clause 5.3 of the license deed contained the specific time frame within which the construction was to be made, and there was no effort on the part of the appellant to make construction. Therefore, KMD had rightly terminated the contract. Then the third point was that...
Ms. Agarwal need not place all the points separately. You just mention the point and give your answer to that. Just be brief on that. First point, please answer first.
First point, I'll answer first.
That the license deed overrides the previous brochure clauses.
Yes. Now, to my
take a point, answer it, and move on to the next.
Yes. Now, my lord, in the present case, my lord, it was all along, my lord, it is an undisputed fact that all along it was agreed between the parties. In fact, the notice inviting tender was to execute the lease only. The offer was made for that only. As would appear from the license deed itself, my lord, the recital part and the clauses, that the parties had agreed to execute the lease deed, but as the title, according to the KMDA, the title was not clear. As such, for the time being, the license deed was executed, which was to be converted into a lease deed. This proposition is not disputed. This is an admitted fact. This would appear from the license deed, as also from the deposition of the DW2 on the two different occasions, my lord. In my written note, my lord, I have indicated it in detail, my lord, that this was the position. Now, my lord, when my learned friend, in support of its contention, had relied upon a judgment
Yes.
Yes.
Yes, Ms. Agarwal, what is
Yes, my lord.
Clause 5.3.
The first judgment which is cited was 1977 SCC Online Delhi, ILR 1978 Delhi 292. In the case of Chandulal, etc., versus Municipal Corporation of Delhi.
Yes.
My lord, this judgment, in fact, my lord, facts are in one way, if I argue, my lord, paragraph 15, is that it goes in my favor. But that judgment, my lord, says that the intention of the parties is the real test for ascertaining the character of a document. It is beyond challenge that a document gives only a right to use the now in that case, my lord, the intention of the parties was to create license only. A kiosk was given by to the allotted at the Red Fort to the allotee, and it contained several clauses, my lord. In clause 15, there was a right of terminate. It was only for a period of 11 months. And it also contained a clause that if the allotee fails to vacate the premises upon the expiry of the term of license, then the authorities were entitled to throw away the goods and articles, my lord. All these powers were given. So from the construction of that document, my lord, the court came to the finding that it was a pure license only, and by no stretch of imagination that could be construed as the lease or the tenancy in favor of the allotee. My lord, therefore, my lord, the judgment which has been cited by my learned friend, as reported in 1997 SCC Online, page 292, my lord Chandulal, is not applicable in the facts of the case. However, paragraph 15 of the said judgment, my lord, if I read the question accordingly, is whether the various clauses of the document in question, when read as a whole in any manner, carve out an interest in the demised property in favor of the petitioners. Although a person who is let into exclusive possession is prima facie to be considered a tenant, nevertheless, if the circumstances negative such a conclusion and show that no tenancy was created, the person in possession would not be held to be a tenant. It is right saying that the intention of the parties is a real test for ascertaining the character of a document. It is beyond challenge that if a document gives only a right to use the property in a particular way, but its possession and control remains with the owner thereof, it will be a license. In such a case, the legal possession remains with the owner of the property, the licensee being permitted to make use of the property for a particular purpose. It would therefore be seen that for the permissions, the licensee's possession would be unlawful. Exclusive possession does not militate against the concept of license if the circumstances negative any intention to create a tenancy. My lord, in the present case, my lord, in fact, the three judgments which I had cited before your lordships, my lord, in support of my contention, that is Associated Hotel, D'Souza, and Delta International, my lord, all the three judgments, my lord, are on the issue that the real intention of the parties has to be gathered from the nature of the document, and if the test which were given was that if the right to enjoy the property has been given, the power to an interest has been created in favor of the allotee or the lessee, like the power in the present case, my lord, the right has been given to give sublease or assign. My lord, this cannot be treated as simpliciter and a right for a license. A license to use means no possession, exclusive possession is given to the allotee. But a right to sublease can be given only in the facts of the case when the lessee is put into the exclusive possession of the property. Then, my lord, the
Yes.
then, my lord, clause 6(1) of, if I shall I take the document or my lord just argue? Clause 6(1) of the deed of license itself says that the licensee is entitled to hold and enjoy the property without any interruption during the tenure of the license, my lord. And so from these, and there is one of the later, my lord, 2nd of April 2003, which I indicated in my written notes, my lord, issued by the corporation, my lord, KMDA, which says that the property was given to me on an outright basis. But the term of the use outright, my lords, indicate it was not a simpliciter license. Though, my lord, in fact, the brochure which I had shown to your lordship, clauses 1 and 2, clearly indicates that initially it was for a lease for 99 years with an option to apply for renewal for a similar term, and then power to sublease. Then, my lord, when the deed of license was executed, even prior to that, my lord, we had indicated that the letter of allotment which contained the clause 10H, that you cannot sublet or transfer without the permission of the KMDA, upon our objection, even after execution of the deed of license on 22nd May 2003, by a letter dated 9 June 2003, KMDA had granted the power to sublease, sublet, or assign by a letter of 9th of June 2003. And then, my lord, the outright basis, and, my lord, the lease deed itself says that it will be converted, license deed itself contains the clause that it will be converted into the lease deed. And, my lord, there are correspondences galore between the parties, my lord. The letters which we have written to the KMDA stating that it will be automatically converted into the lease deed prior to the execution of the license deed, and subsequent thereto, my lord, have not been disputed and or denied by the parties. There is no reply to any of the letters, no controverted. Then the further in this context, my lord, I would the deposition of the DW2, my lord. In the deposition of the DW2, my lord, I have quoted this paragraphs or the two dates deposition in the month of 11th March 2014 and 4th April 2014, wherein, my lord, the DW2 has clearly admitted that the real intention between the parties was to grant the lease, but the license was granted. And in fact, it has been admitted that the documents relating to the land were not handed over to the appellant. And in fact, the documents which have been disclosed in course of evidence, my lord, the deeds, would demonstrate that in the year 1996 itself, the KMD had title to the property. Therefore, my lord, this why the such clauses have been inserted in the document, my lord, is not explained, my lord. The special secretary, my lord, while passing the order of cancellation, my lord, has written that the appellant has never pointed out that the title of the land is not clear or there is a defect in the title. My lord, this was not required to be pointed out, my lord, because, my lord, it is the authorities concerned who had represented to the appellant that we are executing the license deed as the title is not clear, and this fact will be borne out from the deed of license itself. Therefore, there was no reason as to we should point out. In fact, subsequent to the execution of the deed of lease, my lord, license, we have written number of letters calling upon them to execute the lease deed. In none of the letters they have said that yes, title on the land is clear and we will execute the lease deed in your favor. My lord, this clearly goes to show that from very inception, my lord, the authorities concerned had not acted very fairly, my lord, and having suppressed the fact that the title of the land was with them. I proceed with the contention that the title was with them. My lord, then in that event, my lord, it was incumbent upon them to execute the deed of lease and not the deed of license, and the deed of license should be treated. Though the deed of license was executed, my lord, but the real intention between the parties was to create lease in favor of the appellant, my lord. My answer to this is this. Then, my lord, another judgment which he has cited, but I'm not showing your lordship the judgments or those judgments, my lord, which I had already placed before lordship on the earlier occasion. Then, my lord, another judgment which my learned friend has cited is a judgment reported in 1999, Volume 2, Supreme Court Cases, page 13. Indu Kakkad versus Haryana State Industrial Development Corporation Limited. My lord, this is a case, my lord, where, my lord, the court, my lord, did not decide the issue whether the allotment could have been cancelled in the facts of the case. The court had in fact, taken into consideration two issues, my lord. Firstly, that the allotee itself, by a letter, had indicated to the authorities that it was not possible for the allotee to continue with the scheme, and he has abandoned the scheme. That is mentioned in, my lord, paragraph 20, paragraph 14. My lord, just I read it. The allotee who received the notice sent a reply to it in which a plea was made for helping the allotee to set up the industrial plant. The allotee has practically admitted that it had to abandon the scheme for establishment of a plant. Now, this is one point, first point. And the second point on the consideration of which the court had dismissed the application of the was that the case was not instituted by the allotee. In fact, the allotee, after being unsuccessful in proceeding with the scheme, after abandoning the scheme, had transferred its allotment, assigned its allotment in favor of a third party. And that third party, my lord, had come before the court seeking enforcement of the contract. Such content, the court said that no, such assignment and transfer of the allotment by the allotee was without the consent of the corporation. Therefore, the transferee or the assignee has no locus standi to come before this court and claims performance of the contract, my lord. Kindly see paragraph 20 of that judgment. Here the agreement was entered into between the corporation and the allotee as a sequel to the request made by the allotee to give him an industrial plot for the purpose of setting up an industry. The corporation reciprocated to the request on being satisfied that the allotee was able to carry out the obligations so as to accomplish the purpose of allotment. The assurance given by the allotee that he shall start construction of the building for setting up the industry within a period of 6 months and complete the construction thereof within 2 years from the date of issue of the allotment letter was verified and found acceptable to the corporation. And then only the corporation has chosen to enter the agreement with the allotee. It is a matter of confidence which the corporation acquired in the promise made by the allotee that the latter would perform such obligation. If the allotee evacuates from the scene after inducting someone else into the plot without the consent of the corporation, it is not legally permissible for the inductee to compel the corporation to recognize him as allotee. Viewing the assignment from the aforesaid angle, we are in agreement with the conclusion of the High Court that the petitioner has no locus standi to question the validity of the order of resumption. Hence, the impugned judgment is unaccessible as from that angle also. But on this score, my lord, the writ petition was being dismissed, my lord. In the present case, my lord, it is not a case, my lord, from the various documents which I had placed before lordship, that sincere efforts were being made, my lord, by the appellant to set up the industry. There are documents galore, my lord, wherefrom it would be evident. Apart from the premium amount, which to the tune of 8 crore, which was paid by the appellant, my lord, several other expenditures were being incurred. Plans were prepared. It was considered by the Municipal Building Committee. Detailed scrutiny report of the executive engineer building was prepared on 7th of January 2008, my lord. And in between, my lord, for the purpose of completing the process of setting up a processing unit, my lord, the various licenses were applied for. The report of the MBC had directed the appellant to obtain clearances from various departments. All such clearances were being obtained, my lord. And there are a high tension supply was being obtained for the purpose of construction. All steps were being taken. It was because of the plan being not sanctioned by the corporation, my lord, because of the status of the land, my lord. I have indicated in my note, my lord, the documents to satisfy that this we had sought for the corporation, requested the KMDA to clarify the status. Though our name was recorded in the record of the KMDA as licensee, my lord, but on it without the clear status relating to the ownership of the property, my lord, the corporation was not willing to clear the plan, my lord. And in fact, plan was not rejected by the corporation. After the hearing was conducted by the authority concerned, my lord, on 7th of January 2008, the document has been made as an exhibit, my lord. It is disclosed in the proceedings 7th of January 2008. It is prepared by the corporation only, my lord, that it was in the final stage of the process, my lord. And my lord, in the present case, my lord, in my written notes, I have indicated, my lord, that for the purpose of construction of the building plan, it was an obligation, my lord, which was reciprocal. It was not simplicity which was dependent upon the appellant. My lord, before I shall show, my lord, some of the provisions from the municipal building rules, my lord, where my lord, it has been clearly laid down, my lord, that when an application for building permit under section 393 of the KMC Act, my lord, has to be accompanied by various documents, my lord. These documents are, my lord, site plan. And my lord, I have shown to your lordship that the site plan, revised and correct site plan, was given to the appellant only on 7th of December 2004, 1.5 years after the plan, the deed of license was being executed. Then, my lord, it is also a condition precedent, my lord, under section rule 16 of the building rules, my lord, that area tax are to be cleared. Until unless the tax clearance certificate is attached, my lord, the plan will not be accepted by the department. It will not be processed. This KMDA, in terms of the clause of the brochure and the license deed, my lord, from the date of allotment, it was for the appellant to make payment of the municipal taxes. However, there were existing area taxes, my lord, which were to be paid by the KMDA only. KMDA had deposited the tax only in the month of March 2005. The tax clearance certificate was issued on 7th of March 2005. In fact, appellant, my lord, in order to process the expedite the process of sanction of plan, my lord, had deposited a sum of rupees 15 lakhs with the KMC, which was deposited in the suspense account on 23rd November 2004, my lord. And thereafter only he could submit the plan, my lord. Therefore, my lord, and my lord, thirdly, my lord, in accordance with rule 39, my lord, if I give your lordship the books, I have got only one copy.
No,
It's not
did
required.
not rely on new things, yes.
Rule 39 of the building rules, my lord, if a plot of land is more than 500 square meter, my lord, a certificate from the and no objection certificate from the urban land ceiling authorities is required, my lord, if the plot of land is vacant. So, my lord, the NOC which we were sought for from the KMDA, but if the KMDA certifies that the land belongs to KMDA and it is a government plot, my lord, then the appellant could not have to obtain the certificate from no objection certificate from the urban land ceiling, and the NOC from the KMDA only would have been sufficient. For this reason, my lord, by a letter of June 2006, my lord, which my learned friend has shown that after they had called upon us to show the status of the plan, we had written the letter. It is not so. That certificate was being required as sought for by the corporation and NOC, but which was not even given till date by the KMDA. Well, these were the reciprocal obligations, my lord, which they were required to fulfill. Further, my lord, I had already submitted. My learned friend in his course of argument, my lord, had placed only 2 of the letters, my lord, which were written by the appellant with regard to the obstruction being caused at page 32 and 34 of the paper book, my lord. These 2 letters were prior to the execution of the deed of license. And he completely, my lord, overlooked or ignored, my lord, the subsequent letters, even up till 9th of August 2004, my lord, when there were legal proceedings pending, there were different claimants. In fact, the RTI application which we made before the corporation, that in fact various parties had claimed ownership in respect of the land and made their objection. As a result whereof, my lord, the mutation certificate and the assessment roll copy which was required for processing the plan, my lord, was not given to the appellant, my lord. These factors, my lord, admittedly, my lord, it is an undisputed position. The KMC had given the possession of the land to the appellant free from all encumbrances, my lord. It was not sold on as is where is basis. So, my lord, whatever the obstruction and hindrances which the appellant had faced, my lord, this also had to be taken into consideration while computing. If I, for the sake of argument, I assume that period of 3 years was applicable, and I had to complete the work within a period of 3 years. Therefore, my lord, with all these objections and non-compliance of the obligation on the part of the KMDA, my lord, it was not possible for the appellant, my lord, despite the best endeavor being given, to complete the project within the period of 3 years, my lord. And this fact was known to the KMDA because, your lordship, from very inception, because from the letters which have been written thereafter, my lord, the municipal building committee, my lord, municipal building committee, my lord, the process is this, that when a plan is being submitted, then it is placed before the municipal building committee for scrutiny. And upon the basis of this recommendation of the municipal building committee, that the plan is thereafter forwarded to the mayor in council. They may accept the recommendation of the municipal building committee, or they make some changes in the recommendation of the municipal building committee, and thereafter, subject to fulfillment of other clauses, compliances, my lord, the plan is being sanctioned. My lord, if I show to your lordship that municipal building committee, my lord, consists of Rule 37, my lord. It's very important, my lord.
Did not rely on new provisions
Yes.
now. Just
Rule
whatever is
37, my lord, contains,
within
my lord,
that framework.
apart from the commissioner and an officer of the corporation, commissioner as a chairman and other officers
But
of the
you knew all these things when you entered into the license deed.
My lord, I knew, but KMDA nominee was there in the municipal building committee.
Yes.
My lord, I am not saying for that intention. I am saying that municipal building committee consisted of one of the officer of the KMDA.
Maybe.
And my lord, he was aware of the building plan being submitted. The order of the KMDA, my lord, the respondent number 2, my lord, says that the building plan was not even prepared. Soil test was not conducted. No step was being taken, my lord. Cannot lie on the basis of the fact that MBC had the representative of KMDA, my lord. I cannot say that I was not aware that the plan has to be scrutinized by the MBC. The process is required to be undertaken. But however, KMDA cannot say that the KMDA was totally ignorant of the fact that what step the appellant had taken in the matter. In that context of the matter, my lord, I am showing this. My lord, this is with regard to this issue of it also covered, my lord, the issue of delay. In fact, my lord, I had shown, I will not repeat, in the brochure, there was a clause that if lessee was to commence the work of construction, not completed within a period of 3 years, and if there is any delay in commencement, my lord, the authorities were entitled to compensation. My lord, there was no time limit given.
But there was no such provision in the license deed.
License deed does not contain such provision. The letter of allotment does not have any provision with regard there to it completely. The license, my lord, to this I had already argued that when the license deed was executed, my lord, they were, my lord, in the complete domain of the situation, my lord. The authorities were the granting.
Not that it was a commercial decision you took.
There, I took commercial decision.
Commerce, we cannot say absolute domain.
I will not say.
Because of not entering into that.
I had proceeded with the clause with the hope that the lease deed will be executed.
Your hope was dashed when you entered into the license deed. But you entered into the license deed knowing fully well the commercial implications, miss.
Yeah, I had, but my lord, the clause 5.3, my lord, does not say that time was the essence of the contract. The term which my learned friend
It has to be completed. And another clause says that if you are in violation of any of these breach of any
clause 7.1
termination.
Clause 7.1 that in breach of any of the covenants, my lord. But it also says, my lord, that in accordance with the municipal building plan, my lord, and subject to approval and clearances and permissions from the
That is
other
right.
authorities.
That is right.
My lord, it cannot be read in isolation.
Right.
We cannot pick and choose one line, my lord, and the other. And my
So
lord,
that completion has to be read in the context
the
of
entirety. And then, my lord, my learned friend himself has shown a clause, my lord, from 7(3) or 4, which says that the relaxation or indulgence shall not be taken. So, my lord,
relaxation was not asked for.
we,
That also-
my lord, mere fact that I initially I did not ask for does not mean that the authorities were not aware that these were the difficulties and hurdles which were being played. The authorities were not aware of the fact that we are proceeding with the work.
They may
When
be
we are,
aware, but if you don't ask for extension, they
No.
don't grant extension.
my lord,
They were obviously aware of everything.
when my learned friend has pointed out a letter of May 2005 6, my lord, given by the KMDA, asking the appellant to show the approval and the status of the building plan, my lord.
Obviously, yes.
When they are asking for the status of the building plan, my lord, and when we are asking for the tax clearance, my lord, when we are asking for the issuance of the site plan, revised site plan, all these things, my lord, indicate that we had and the obstructions being faced in raising the boundary wall, in carrying out the work, my lord, and the letters which have been given, my lord, will clearly go to show that the facts were being brought to the knowledge of the KMDA, that these difficulties were being faced. And my lord, when the SOCO's notice was issued, prior to the issuance of the SOCO's notice, my lord, there is no letter given by the KMDA that you are not proceeding with the work. The SOCO's notice, my lord, when we give reply, my lord, by letter of 8th of January 2008, my lord, we had annexed all the documents. My lord, the order will show, my lord, that the documents which have been submitted by the appellant were not being considered at all, my lord. Only one document which has been picked up and chosen was the application made with the West Bengal Pollution Control Board on 10th March 2006. Apart from that, my lord, in fact, the order goes to show with regard to the land title. It says that I have not prepared the building plan even, my lord. That was total non-application of mine and non-consideration of the document. In that, our later, my lord, in the last line, my lord, you will find, we had, after explaining all the facts and circumstances, my lord, we had requested the special secretary to enlarge the time. My lord, that was before cancellation. By that time, the deed was not cancelled. It is not that subsequent to the cancellation, my lord, we have sought for time. So, my lord, this is one of the document is there, my lord, explicitly where we have requested the KMDA to extend the time. And there are, my lord, apart from that, my lord, there are several documents and letters, my lord, and it is accepted by the KMD also. The parties were not only communicating through the written mode. There were representations in the physical, oral representations and telephonic conversations also, my lord. There are several letters which would show that it was not that the KMDA was not intimated of the position, my lord. My lord, mere fact that within the period of 3 years, my lord, a written letter was not formally given to seek extension of time, my lord, cannot be treated to be fatal in this case, or treated to be the breach of the covenant when other steps have been taken, my lord. And lastly, special secretary, my lord, ought to have considered the prayer that was made in the letter of 8th of January 2008, my lord. And my lord, in this case, my lord, my learned friend has Lord, I would like to place. Well, in fact, the Wilson was not a very happily worded judgment, though paragraph 42 goes in my favor. The Honorable Supreme Court had accepted it. But one judgment, my lord, I would like to place.
New judgment?
New judgment.
No. No.
My lord,
Not in judgment. No. We cannot prove. You have given sufficient time to you. Just complete your argument in a nutshell and you'll
my
find
lord, the Hind construction, my lord, it has 3 bench
we are
judgment.
heavily burdened with, we cannot have that luxury. Sorry. Please just
But
complete
I
your,
shall give, I'm giving up.
you have given several days to Ms. Agarwal. No new judgment. Just conclude your arguments, please. Just
My lord,
conclude
that
your
is a very relevant judgment, my lord.
Maybe.
But in point of law, my lord, is
Sorry,
only
Ms.
one
Agarwal, no.
judgment only I would like
No,
to
no,
correct.
no. Not in rejoinder. Just complete your argument and just get it over with. So that you can move on to the next matter.
Just give me a minute.
Yes, Ms. Agarwal, should
In
you?
one second,
Yes.
Lordship, I'll finish. And my lord, the judgment of Radhakrishna Agarwal, which my learned friend has shown.
Radhakrishnan, yes. Categories were divided.
Categories were given.
Private,
My lord, my learned
contract
friend.
may not be that.
My lord, in fact, your lordship's judgment, which I had cited, my lord, though I have brought the copies of those judgments, my lord, which have been referred into your lordship's judgment of reported in 2018.
This is Supreme Court.
No, this is Supreme Court, but your lordship
My
had,
judgment sitting singly
No,
does not
no.
have any bearing on.
your lordship notified.
No, Ms. Agarwal, no new judgment.
Your lordship judgment had taken into consideration two Supreme Court judgments. One was Dwarkadas Marfatia and Mahavir Auto Cells.
There probably you may have a good point because although that judgment was 77 judgment was cited, but the law has evolved
And
after.
in fact, 77 judgment, my lord, why I'm
It has
saying
to be on a higher footing.
footing. And 77 judgments were, my lord, taken into consideration in these two judgments, where, my lord, the courts have, Supreme Court itself has held, my lord, that in contractual matters also the conduct of the authorities has to be fair, my lord. And in fact, it can go into the contractual matters also, my lord. In 1993 volume SCC, Mahavir Auto
1977, this was a proposition for the first time raised by them.
by
On
them.
that you can cite judgment
Very well.
because that judgment was on something which you did not argue. They argued for the first time. So you have a right of cite any one judgment. Just
Very well.
any current Supreme Court judgment, one of the current judgments. এই পয়েন্টটা ফর দ্য ফার্স্ট টাইম ওরা ইয়েতে নিয়েছে যে স্টেট ইকুয়ালি ইয়েতে করবে না তো নিলে ওকে রিপ্লাই দিতে দেবো Ms. Agarwal, be quick. Every day we are facing allegations from advocates who are not including matters. We can't be held guilty and at the same time held captive by.
My lord, I am not taking too much of time.
Advocates have to be fast if they want inclusion in the list.
But I'm just finishing.
We cannot be held guilty both ways.
I'm putting it.
We are not very slow on the uptake, so you have to be very fast on the.
Yes, 1993 volumes.
Got a copy of the judgment?
Yes, my lord, I'll give you.
Give us.
SCC page 752.
Give the full citation for your learned friend.
Yes, Mahavir Autos. I've given full citation. Mahavir Auto Stores and others. I'll give him a copy also. Versus Indian Oil Corporation and others. But I'll not take the entire judgment. Only two paragraphs I would like to place.
Paragraph?
Paragraph 12 and 20, my lord. These. In fact, my lord, Radhakrishna Agarwal was relied upon, and thereafter the court had come to the conclusion, my lord, in paragraph 20, my lord. Paragraph 20, having regard to the nature of the transaction, we are of the opinion that it would be appropriate to state that in cases where the instrumentality of the state enters the contractual field, it should be governed by the incidence of the contract. It is true that it may not be necessary to give reasons, but in our opinion, in the field of this nature, fairness must be there to the parties concerned, and having regard to the large number or the long period and the nature of dealing between the parties, the appellant should have been taken into confidence, equality, and fairness. At least demands this much from an instrumentality of the state dealing with the right of the state not to treat the contract as subsisting.
Equality and fairness.
Equality and
Right.
fairness. But similar, my lord, view has been taken by the Honorable Supreme Court, my lord, where Radhakrishna Agarwal has been distinguished, my lord, Dwarkadas Marfatia, my lord.
Right.
My lord, I found that, my lord, Hindustan construction judgment, my lord, showing it was, my lord, in fact, it has been dealt with in Wilspun also, my lord. that, my lord, time has,
Give the citation, the second citation to him. You have given a copy.
I've
Yes.
given him a copy, my lord.
Which paragraph, Ms. Agarwal?
Okay, just let me come. Paragraph 32, my lord. Just a second. 21 is one of the paragraph. Paragraph 21, 22, my lord. Paragraph 21, we are unable to accept the submissions being a public body when in respect of its dealing with its tenant, it must be in public interest and infraction of that duty is amenable to examination either in civil suit or in writ jurisdiction. Then, my lord, in paragraph 22, my lord, Radha Krishna Agarwal, the judgment which was cited by learned friend has been taken into consideration. It says our
Petition has been rather distinguished.
distinguished, my lord.
Yes, yes.
That is what I'm saying. In
20,
support of the, in fact, the reliance was placed
Right.
on Life Insurance
This
Corporation.
is not the correct position. That is said.
Yes.
Right.
Yes.
Para 21, 22.
Then paragraph 27, my lord. My lord, the last line of paragraph 27, if a governmental policy or action, even in contextual matters, fails to satisfy the test of reasonableness, it would be unconstitutional, my lord.
Right.
So, my lord, I'm relying upon
That
this.
is what we indicated to Mr. Banerjee also,
Yes,
that
yes.
that position has been diluted. Sir.
Diluted.
Very good.
And
Anything else?
no. My lord, these are all, my lord, I would like to submit, my lord. In fact, in my written notes, I shall briefly deal with all the arguments. But if your lordship would have allowed me to cite that Hind construction judgment, my lord.
On what point?
On the time of the essence of the contract. But that, my lord, very well. But
Yes, any reply to these two new judgments? That is a settled position of law. Government also has to be on very high footing.
And to it,
So that we won't rely on Radha Krishna.
the question of unreasonableness does not appear from the action in the facts of this case. So
Concluding
these two.
So Monday, both of you will be filing a written notes of arguments. Monday.
My lord, I am extremely sorry, my lord. I could not prepare that. No.
Monday?
My lord, one on facts, my lord.
No. No reply to reply.
There will be no end.
Hard learned hearing is concluded and the hearing is concluded, pushed up. The learned counsel for the parties shall file their respective written notes of arguments on July 14, 2025, when the matter shall be listed under the heading to be mentioned. Thank you very much, both of you.
Deeply obliged, my lord, for the patient.
Thank you, sir. এটা to be mentioned থাকবে সোমবার তারপরে Yes.
My lord, I appeared for the appellant, my lord.
Yes.
My lord,
I was arguing.
Mr. Chatterjee, my lord, resumes his argument, my lord. My lord, may I place, my lord, just for 5 minutes only, my lord. There are two wills, my lord, executed on the same date. My lord, on the other day I have submitted, my lord.
Yes.
My lord, in the impugned will, my lord,
that is that my lord will find that in the LCR, that is the trial court records, my lord, that the page number 311, the line number 4, it states that this is my first and the last will. And the second will also, my lord, will number 6 dated 7th of January 2024. It is appearing at LCR, my lord, at page 345, line number 5. That was executed in Salt Lake. It also says that this is my first and the last will. There I have executed no other wills. Malat, both have been both from the record. First, Malat, I will be citing Malat in relation to that Malat the judgment Malat 2021 volume 11 SCC page 209 Malat Kavita Kanwar's judgment Malat. It has been cited number of times before the Lordship Malat. You are hearing Malat the probate appeals Malat. Malat since 2021 volume 11 SCC page 209 paragraph 25.1 to paragraph 25.4 Malat. Malat, just that the since this deed was not Malat exhibited, rather Malat the propounder itself gave the copy to the court Malat. The court has considered that document Malat, just to dispel the doubts Malat. That has come, and they have not, so far as the second will is concerned, they have not said that they were unaware of that will, Malat. Second point is that, Malat, if we have gone through the evidence of the trial court records, Malat, it says, Malat, so far as the evidence of both the witnesses, PW1 and PW2, Malat, there are inconsistent statement, Malat. So far as the execution of the deed, Malat, where PW1 says in paragraph 27 of the affidavit, Malat, that he was not present at the time of execution of the will. While Malat at the cross-examination, he says that he was present at the time of execution of the will. The second point is that will was read over and explained to the testator. The PW2 Malat, while giving his chief, says that Badol Noshkor, that the testator read the will of his own. That he was not read over and explained, that is not there. He read the will of his own. In the cross-examination, just the opposite version has come, that he says that he was read over and will was explained to him by the advocate. Other thing, Malat, which was pointed out by the Lordship Malat to the respondent Malat, no statement is forthcoming that Onup, the other witness, had put the signature and in presence of the testator after witnessing the execution. That is not coming from any of the Malat evidences. That is in my humble submission, Malat, section 3 of the TP Act, Malat, amino attestandy Malat has not been followed, Malat. So far as that, Malat, I will be placing a judgment, Malat, AIR 1969 Supreme Court, page 1147, para Malat 7 and 8. It says AIR 1969 Supreme Court, page 1147, para 7 and 8. It says that the witness should put his signatures animo assistendi, that is for the purpose of attesting that he has seen the executed sign. Well, that is not forthcoming from the evidence, Malat. And so far as the deed, Malat, which was produced, Malat, by them, Malat, we have filed an application to take it as an evidence, Malat, because they have accepted that deed. So far as the will is concerned.
That document for the purpose of?
Be taken as evidence.
The other will?
Other will, Malat, because it is them, it is they who produce that copy of the will. Although the CD was produced in the court, Malat, but the copy has been produced by them. Malat, another thing, Malat, I was humbly submitting, Malat, if my lord direct, Malat, to produce the original will from the registrar, Malat.
It's not there. Yes, it is there.
Oh, it has come now.
Would you like to have a look at that?
Malat, these are my submissions. Let him make submissions.
No, my lord, first of all, my lord, they have filed an application, my lord, under Order 41, Rule 27 at the hearing stage, my lord, to bring that will on record, my lord, by way of an additional evidence or, my lord, new evidence, if I say, my lord, in the present proceeding. My lord, to this, my lord, a legal argument, my lord, I would like to advance, my lord, at this stage, why it should not be allowed. Well, I will come to that later when my lord, after making my argument on the subject, my lord. why, my lord, on hearing why it should not be allowed. Now, my lord, if my lord takes up, my lord, on the last occasion, my lord, I had cited 3 decisions, my lord, trying to canvass my point, or my lord, on the point that, my lord, duty of the propounder, my lord, to show that the will was executed with the testator by the testator, and my lord, being, my lord, same being proved, my lord, which is the foremost condition. My lord, first condition, the testator's voluntary action has been in the will, and my lord, there is no undue influence on that. Now, my lord, if that is before the court, my lord, the second limb, my lord, comes to, my lord, on the proof of the, my lord, suspicion. There is no suspicious circumstances surrounding it. Now, my lord, to the extent of suspicion circumstances surrounding it, my lord, kindly takes up, my lord, the written statement for a moment, which they have filed. Lord, kindly takes up, there was an amended written statement filed by them. That is at page 22 of the paper book.
Yes.
Now, my lord, kindly takes up paragraph 9A first.
Yes.
My lord, these are the facts of the opposite parties, my lord, which they have narrated, my lord. A, that the deceased Bajol Chandra Noskar was our father, that the said deceased was survived by 2 sons and 5 daughters, that is 2 sons, namely Aurobindo Noskar and Shukumar Noskar, both married against his will, and as such the said deceased Bajol Chandra Noskar lived separately from 2 sons accompanied by his wife and younger daughter, and he used to maintain his family out of his own covered funds. My lord, I pause here for a moment. My lord, it is their stand that the father was living with the daughter because, my lord, the sons have married against his will. And, my lord, though they were living with the daughter, my lord, the father used to maintain out of his own income. So, my lord, from this, my lord, one thing is clear, my lord, the man, my lord, who has made the will, my lord, is a man of a strong willpower with all the attitudes, my lord, under the sun to maintain himself out of his own income. My lord, his mental strength or strength of will, my lord, is not in dispute. Now, my lord,
Yes.
now, my lord, paragraph B that I said, this is Bachelor Oscar used to live separately with his wife and younger daughter. So, my lord, it is only with the younger daughter, my lord, the father used to live, no other daughters. In a hut separately from main drawing house, which was wholly occupied by his 2 sons. Let's see is important that while living separately with the deceased Badal Chandra Noskar, his wife died on 18th August 2002, and since the day of demise of his wife, the mental and physical condition of the said Badal Chandra Noskar deteriorated, and the said Badal Chandra Noskar had got no physical and mental strength to do his personal work. At that relevant time, opposite parties used to maintain the day-to-day livelihood of their father, that our father, since deceased, never voluntarily received any type of assistance from his son, and he never received any food from his son. So, Millard, even if this paragraph, Millard, is there after the death of the wife, Millard, his father lost his mental capacity and the daughter maintained the father. Millard, then also Millard kindly sees the mental capacity of the father, that he was voluntarily not accepting anything against the son, if I take this paragraph to be true. So therefore his mental alertness was always there. But there is no dispute on the deficiency of mental alertness. Now, my lord, 9D is the paragraph, my lord, which they say, my lord, why the will, my lord, is surrounded by suspicious circumstances now.
Yes.
That in the night of 4th of January 2004, the petitioner, along with his another brother Aurobindo Noskar, assisted by their son Kaushik Noskar and Anup Noskar, came to the hut where the deceased resided with his younger daughter, and started calling by the name of their father, and asked his younger daughter Nomita Noskar to open the door. The Nomita Noskar, being scared, told them that she will not open the door, and on hearing the same, the said son, along with their sons, break open the door and stole it to beat the younger daughter of the deceased, and they thrown out all the household articles outside the premises, and they ousted Nomita Noshkar from the house, and they lifted our father forcefully and shifted them to their house just beside where the deceased used to reside in the hut, and they put the said deceased completely in their seizure by putting lock and key. That I'm reading over, my lord, that since the night of 1st of January 2004, we, the opposite parties, never got any access to our father, as the petitioner, along with Aurobindo Noshkar, let us to see our old ailing father, our father subject to ill treatment in house of the petitioner, and Aurobindo Noshkar and opposite parties were never given access to meet his ill health till his death on 11/12/2004. My lord, I will take this paragraph, my lord. In their cross-examination, my lord, they say they had all the access to the father, my lord, while residing in the house of the, my lord, the beneficiary or the executor or these brothers. Now, my lord, if this is the case, my lord, till 4th of January 2004, my lord, the father was with all its mental alertness residing with the daughters, younger daughter only, not daughters. Then, my lord, the daughter must have certain documents to say or bring before the court to show that the father was suffering from certain illness, which would indicate the father was not in the state of good health or good mind. My lord, nothing has brought forward. This is first, my lord. Secondly, my lord, this written statement has been affirmed by, my lord, one of the daughters, not the younger daughter. He has not affirmed. My lord, if my lord takes the affidavit portion, my lord, my lord, affidavit is shown by.
But it was filed on her behalf also.
No, that's why the affidavit was
She did not
on behalf.
contest.
She did not depose even.
Did not contest also.
No.
All right.
My lord, affidavit portion in my lord sees Shumita Noshkar shows the affidavit, and my lord, he says this statements in the amended written statement are true to her knowledge.
Younger daughter is an appellant here.
Younger daughter is appellant, my lord.
And opposite party is D2F. She was included in that.
He was all those 5 daughters.
Then this was filed also on her behalf.
But the statement,
he might not have affirmed it.
The deposing, my lord, who has signed says it is true to his knowledge, her knowledge. But this cannot be true to her knowledge. This is only true to the knowledge of the younger daughter.
Really?
Now, my lord, and in this, my lord, the younger daughter, at the time of evidence, my lord, the younger daughter, my lord, doesn't come and depose before the court on this. So, my lord, this is absolutely a personal knowledge which should be proved by the person who had the personal knowledge.
All right.
Now, my lord, kindly takes up paragraph F.
Yes.
That our father, the deceased herein, was a reputed law clerk of Shalda Civil Court, and he got every knowledge of writing and reading, and the said deceased used to draft deeds, plains, written statement out of his own during his lifetime. That said deceased was capable of writing and putting his signature in each and every document. During his lifetime, the deceased sold many properties as vendor, wherein he has signed in each and every document. My lord, kindly marks this. My lord, during his lifetime, my lord, he has sold properties. My lord, even after the death of the, my lord, mother, my lord, properties were sold. My lord, from this statement, my lord, comes into picture. My lord, he was of all mental alertness, and moreover, my lord, the person who is executing the will, my lord, he is in the field, my lord, where he knows, my lord, what is a will, where he is signing, and where he is going to sign, my lord, in the registry office. My lord, he knows
his LTI all the same.
Yes, he has put his LTI, my lord. He goes to the registration office. My lord, in the cross-examination, daughters admit, my lord, the father went to registration office, but forcefully. So, my lord, suspicion is that forcible action. Now, my lord, kindly Now, my lord, kindly takes up H. I'm skipping over G, my lord. That after taking the deceased in their custody, forcefully the petitioner in and with Aurobindo Noshkar, Kaushik Noshkar, Anup Noshkar, collusively prepared the alleged will and put their LTI. So therefore, my lord, this is, my lord, they say assert, my lord, this is not the LTI of the father. This is the LTI of the Anup Noshkar or some other person in the alleged will and took a pseudo person to the registry office and got the will registered. That although advocate Krishnapada Sarkar was shown as scribe of the said will, yet he did not prepare the will. He only signed as scribe to the alleged will without knowing its contents. The said advocate had reputation in identifying signatures of deponents in affidavit, signing in deeds, will, etc., and not an advocate who was accustomed with pleadings. Now, my lord, paragraph A, my lord, again on the assertion, my lord, the father was a literate person, law clerk of Shalda Court, my lord, then kindly turns over L. Now, this is where the deceased prior to his death and subsequently upon execution of the alleged will, dated such and such, also executed and registered another will, thereby appointing his two grandsons, Anup and Kaushik, as executor and beneficiaries, and the said will was allegedly executed on 17th March 2004. But I'm pausing here for a moment. Milord, in the written statement, Milord, the second will now, which they, Milord, try to bring on record by way of an additional evidence, Milord, it is this will, Milord, they were aware at the time of filing of written statement. Now, Milord, in this paragraph also they admit, Milord, if I may read in the that manner, Milord, or there is no other manner to read, Milord, execution by father, Milord, is admitted. The only question, Milord, whether forceful execution.
The second will was neither probated nor proved nothing.
Nothing. And the
Was the executor in that will? You produced that?
Yes, Milord, we brought before the court.
Why did you bring that before the court?
Milord,
What was the occasion?
Probably because of this, Milord, we also brought in record by way of Firisti. Probably, Milord, I was not there, Milord. What played in the advocate's mind, Milord, there.
Who was the executor in that will? Because you are trying to produce
executor the
same propounder. Yeah.
No, probably not.
Same propounder.
Someone else.
No,
and Milord, trial court has, Milord, looked into that. And Milord,
that is why we were thinking so much. Otherwise, we would not have even heard you on this.
Kaushik was the executor.
Kaushik is not his. You didn't take probate. He didn't take probate of that.
No, Kaushik has not filed for any probate of that.
Well, please continue.
And the said will was alleged and registered before the ADR Bidhannagar such and such. That by the said will of the deceased Badal Chandran, all his previous wills were cancelled, revoked, and as such the present will has got no existence in the eye of law and present suit is not maintainable. Well, I'm skipping over. Now, Milord, paragraph M, Milord, is important, Milord, that the deceased Badal Chandran Noshkar was a registered lawyer and also drafter of various documents during his lifetime. He was assisted by his son Shukumar Noshkar, who also adopted all the skills of drafting, preparation of documents, and the said Noshkar being not very much sure as to the grant of probate of the will of Badal Chandra Noshkar, knowing it to be false and manufactured by him collusion with his brother Aurobindo Noshkar and his son, brother-son and said Shukumar Noshkar, in order to illegally grab the property of the deceased Badal Chandra Noshkar, prepared a draft copy of general power of attorney in his own handwriting in favor of him and his brother Aurobindo Noshkar regarding the same properties as covered on the alleged will, but the said Shukumar Noshkar failed to finalize the same. The said intention of Shukumar Noshkar or Aurobindo Noshkar clearly shows about their intention to anyhow grab the property of the deceased Badal Chandra so as to disentitle the present opposite parties from inheriting the same. So, Milord, this is the Milord entire written statement where execution stands admitted, forceful, and Milord, Shukumar Noshkar is one way or the other admitted. He was, Milord, one of the son who professed this profession of the father, and father is the guru, if I may put it in that way, because he learned all the skill from the father or guru, Milord, and the guru, Milord, my lord, gives to him the properties, my lord, as a beneficiary. But this is not something, my lord, very strange thing happening. My lord, his son, father is also a guru and father loves him. Now, my lord, kindly takes up, my lord, the daughters, my lord, who has deposed. Kindly takes up page 68 of the paper book, my lord.
Yes.
Lord, first cross-examination, the first, second line, my sisters shall not depose in this suit. So no other sisters will not, he says that no other sister will depose. Then, my lord, kindly turns over the next page, my lord, 69. And, my lord, first line is also important, my lord. She doesn't identify her signature in the affidavit on chief. My lord, she says, I cannot say.
Where?
My lord, cross-examination, first line, I cannot say where I put my signature on my affidavit in chief today.
Yes.
Then, my lord, kindly turns over, my lord, the next page, my lord. First line, I last saw my father on the date of his death, but not alive. Now, my lord, the father in the will says that my daughters, my lord, do not take care of me, or the daughters have married separately out of against my will, my lord, and that is also coming from the cross-examination. Yes, the daughters have gone, my lord, in marriage into love marriages, my lord, and two marriages, my lord, without having a proper divorce, my lord, under law. So, my lord, father's, my lord, pain, my lord, against the daughter, my lord, in the will is reflected. My lord, a question was put forward, my lord, by my lord to me. My lord, while looking at the deposition of the grandson, one of the attesting witnesses, that the relation between the daughters and the father was cordial, my lord, it was stated. So, my lord, on that, apropos, my lord, the statement in the will by the father. So, my lord, the daughter says, I have never seen my father alive, only at the time of his death.
She last saw her father on his day, upon his death.
On his death, but not alive. Then it, but not alive
Yes.
is there. So, my lord,
If on his death, one cannot be alive.
yes, but my lord, I say, my lord, during his lifetime also the
That
daughter.
she does not say. This does not say that. I last saw. The question was when you last saw your father. She says, I last saw my father on his death, but not alive.
Yes, then my lord, kindly sees the
She
distance.
must have seen him many times alive from her childhood.
Yes, from childhood, definitely.
If your statement is to be taken, then she
From
never saw her
childhood.
father alive.
No, not from
No.
childhood.
Last saw is the keyword here.
Very good.
Last saw after his death.
After
maybe.
his death. Now, my lord,
Immediately before his death, their allegation is that he forcibly took him. So obviously they did not see him.
very well. My lord, if that be so, my lord, then the
That does not prove anything.
contradictory.
At least does not prove what he was saying.
My lord, apropos this, my lord, why I say this, my lord, I am trying to draw that, my lord, why the father's, whatever father is written.
That's given in the will itself.
That's given in the will.
If the will is not manufactured, then everything comes.
Everything comes.
If it is manufactured, everything
Yes,
goes.
yes.
As easy as that.
Yes. Now, my lord, kindly turns. My lord, firstly, page 69, the distance of the residence kindly is 2 minutes walk. Now, my lord, kindly turns to page 70. My lord, kindly remember 2 minutes walk.
Yes. What about the 2-minute walk?
My lord, why I say this? My lord, the second paragraph of page 70, not a fact my father never accepted the aforesaid marriages. And we both sisters were not allowed to visit our father's house. This is with not a fact. So, the suggestion is whether were you visiting the house? Answer would be in affirmative. They were allowed to visit. So,
This says they were allowed
they
to.
were allowed to visit. So,
Double negative, yes.
Yes. So, in the written statement, they say forcefully taken there, and we were absolutely debarred.
In para 9E, they say no access.
No access.
Very well. Yes.
Now, my lord, in the same paragraph, my father executed and registers 2 wills prior to his death. This is affirmative statement. So, my lord, she admits execution of 2 wills by the father. I do not obtain certified copy of the LS deed executed by father on 16/7/2004.
Right. This may be very important. 2 wills.
2 wills.
Very well.
Now, my lord, the last paragraph of that page, my lord, I would not trouble my lord with reading with the entire. It kindly says.
She admits the allegations made by the father in the will.
Yes.
Marriage, divorce.
Marriage, divorce. My lord, and my lord, by the divorce by the panchayat. My lord, a person, my lord, kindly remembers he is a law clerk. My lord, he knows, my lord, divorce by a panchayat is not a divorce under law.
Yes.
Now, my lord, kindly turns over to page 72. My lord, first 2 lines keep over. Again, admission, my lord, I will show, my lord, in page 72.
Yes.
First line skip over. My father executed 1 will. My father executed 1 will on such and such in favor of his 2 sons, namely Shukumar and Aurobindo. Thereafter, on March 24, executed another will over the self-servant in favor of grandsons, that is in favor of Onup and Kaushik. Similar to execution of 2 wills is always admitted. 1 will has never seen the light of the day, and this will of which the probate has been granted is being contested here.
Right.
Now, my lord, he also says, my lord, this is to order 41.
We'll come back. The 2 wills will admit. Yes.
Now, my lord, kindly comes to page 73 for once.
73, yes.
Now, my lord, in the second paragraph or the old paragraph, which starts with though I saw a sale deed. Though I saw a sale deed dated 16/12/2003, but my father always put his signature. But in this deed, I find the thumb impression. So, my lord, he recognizes the thumb impression. I find the thumb impression correlating with, and this deed was also, my lord, brought to the notice of the trial court. In the judgment, my lord, trial court has dealt with that to obviate the suspicion that why a man, literate man, and my lord, my evidence, my hands were shivering or my lord shaking at that age.
She merely says it's not a genuine one, but it's a registered sale deed.
Registered sale deed. And court has also circumvented or my lord sided away the circumstances suspicion by this. Father was executing by thumb impression at that point of
Understood.
time.
Yes.
Now, my lord, then my lord, kindly 3 lines bottom, my father was forcibly came to Barashar. So, my lord, it's always father has executed, gone to registry office, but my lord, adjective is added forcefully. So, my lord, in this cross-examination and admission by the daughters who are disputing, my lord, or my lord, raising a suspicion, my lord, one thing is beyond doubt proved that father was mentally alert, because there is no document from their side when they say father was till, my lord, 4th of January 2004. Father was all along with them, any medical certificate or document to show that father was not mentally well. Rather, in the statement, the strong will of the father has always been portrayed in the written statement. And the voluntary acts of the father in not accepting anything from the sons and maintaining the family out of his own income.
Yes.
So, my lord, if there is no undue influence, my lord, in the sense of overpowering the will,
right,
my lord, then, my lord, and the execution being admitted, my lord, execution by the testator, by the attestating witness has also been proved, and by this evidence has also, my lord, there is no doubt to that. Now, my lord, if this circumstances go, if there is no evidence now,
so we should not go on the technical thing that one of the testators a strict compliance of 63.
Yes, my lord, that is 2010-14 mathematical
Well,
precision.
well, well.
Now, my lord, kindly to, my lord, then that point, my lord, when it was raised. 54.
You have got your own written notes. You are arguing from written notes.
My lord, mine noting in handwritten.
Show us that, the length of that. Yes.
Small, not big. My lord, kindly takes up
yes
1954 2 Supreme Court cases, page 800. At a page 800, 54 to SCC page 800. Kindly takes up.
Yes.
My lord, paragraph 3. My lord, what was the question before the Honorable Supreme Court? Here probate was granted and the grant remained. Now, my lord, the fact of the respondent took the matter in appeal to High Court, and that was heard by G.N. and such. Before them, the appellant did not contest the correctness of the finding of additional district judge that the testator had testamentary capacity when he executed the will. The two contentions that were pressed by him were: one, the will in question were executed by the testator under undue influence of the first respondent, and second, that it was not validly attested and therefore invalid. Now, my lord, in these two questions, before taking my lord to the relevant paragraph, my lord, the will in question, my lord, if is looked into, my lord, is complied with all the provisions of section 63. There are two attesting witnesses. It is being signed. The attesting witnesses.
Your case.
In my case.
Yes.
My lord, there is the attesting says we have attested.
Everything else is there.
And you must attest what was argued by Mr. Sen, my lord.
Only
now,
apart from Onu not
yes,
saying that.
Yes,
only apart.
Now to that, my lord,
Yes.
paragraph 30. Kindly turn.
Paragraph 13.
Lord, may I just place it, my lord?
Yes, please.
it was also argued for the appellant that there was no proof that the will was duly attested as required by Section 63 of the Indian Succession Act, and that it should therefore be held to be void. PW 1 and 2 are the two attesters. They stated in examination in chief that testator signed the will in their presence and that they attested his signature. They did not add that they signed the will in presence of the testator. This is where the question here is also. The C, section 63C, the attestators did not say, or the ONUP did not say, I have signed in presence of the testator. Now, my lord, may I just proceed? They did not add that they signed the will in presence of the testator. Now, the contention is that in the absence of such evidence, it must be held that there was no due attestation. Both the courts below have held against the appellant on this contention. The learned judge of
This is pat on the point.
Yes.
Pat on the point. We have seen it. Pat on the point. Yes.
So, my lord, if the suspicion circumstances goes,
strict proof is, I mean, in the sense that every component.
Every component.
Well, not only suspicious, that the otherwise it was the same sitting and all these things.
Yes. 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 Absolutely.
Yes. This is absolutely pat on the point.
Now, my lord, if I may then, my lord, sum up this part of my argument that since 1954 the courts have laid down in 2006 also the duty of the propounder. My lord, if I can show the due attestation by the testator, due execution by the testator, the voluntariness, my lord, I discharge my owners, which is 2006. Now, the caveators, my lord, the daughters who allege forceful action, my lord, burden was shifted upon them to prove that forceful action, or to show that there was anything which suggests that the father was not in that mental capacity. My lord, these things are not forthcoming. So therefore, my lord, with regard to the genuinity of the will, my lord, there is no dispute to that.
All right.
My lord, this is (2024) SCC Online SC page 981. (2024) SCC Online SC 981. But
Yes.
this is on the point, my lord, the fact that the forceful action could have been proved by the younger daughter by deposing.
Yes.
Because from her residence, my lord, this has happened. And, my lord, the statement, if I, my lord, recall in the written statement, that the brother called the younger daughter by her name to open the door. So this is something very personal. Now, my lord, this paragraph 9 says, my lord, this is quoting this old 2005
Paragraph 9.
Paragraph 9. Justice Sema's judgment, my lord, on the power of attorney holder deposing. Now, my lord, in Jankidev such and such, it is held that a power of attorney holder cannot depose for principal in respect of matters of which only principal can have personal knowledge. So, my lord, even if the other daughter authorized to depose, my lord, as in the affidavit portion.
Authorized personal knowledge.
Personal knowledge, absolutely personal knowledge. So, my lord, this is not even seen the light of the day, this factum.
We have said younger daughter has not deposed, that is sufficient.
That is
Why judgment triggered? How can I,
now,
by virtue of power of attorney, adduce evidence? That's too well settled.
Yes. Now, one decision, my lord, of our Honorable High Court, relying upon this 2006-13 also.
But don't repeat judgments unnecessary. Like this last judgment was absolutely unnecessary.
Very. Then, my lord,
no,
this is
necessary reciting.
Necessary means, my lord,
on the same point, several judgments is not
same
required.
points, my lord, this was very worst facts, my lord, where the one of the attesting witness has become hostile.
Cite.
My lord, in that case, this honorable court has granted probate. This is reported in 2022 SEC Online, Calcutta 2736. Now, my lord, paragraph 41, 42, 43. My lord, the facts where, my lord, one of the attested witness has turned hostile. My lord, he has deposed against. In that case, my lord, this 2006 was considered, and to some extent, I would say 2010-14 was also followed by the first line. In such cases, proof with mathematical certainty cannot be insisted upon. So, my lord, what was looked into by the Honorable Court was, once it is proved that the testator has executed voluntarily and there is no, my lord, overpowering situation, my lord, that is enough to cause the say that the will is genuine. And the remaining part, my lord, takes a backseat. May I just place, in such cases, proof with mathematical certainty cannot be insisted upon on an holistic assessment and consideration of the entire matter. The cumulative effect of apparent unusual features seems to have been tempered, and the judicial conscience can also be said to be satisfied with regard to the fact and evidence on record. Being duly signed by the testator in sound state of mind, the court must be vigilant and not lightly strike down a will, fair and rational on its face. The will being registered with the register, the shroud of suspicion is also less significant. The proof of testamentary capacity and due execution of the will, and the will truly represents the testator's intention having established, it can be safely concluded that the extent of evidentiary burden has been successfully discharged by the executor in the nature of suspicion raised by the caveat surrounding the execution of the will. The testator, testing the case of both the parties on the anvil of balance of probabilities as is applicable in civil cases, with special reference to the legal requirements to prove a will, it must be held that propounder has successfully stood on its legs and discharged the burden of proof that the will has been validly executed and is genuine document. Consequently, the executor propounder is entitled to grant of probate on the ground that the execution of the alleged will is not shrouded in suspicion. In such view of the facts, the present case appeal has been dismissed. Not conquered by the other judge. My lord, facts are very bad in this. If my lord looks into the facts, only thing was proved that the person whose will, or the deceased person whose will is to be looked into, it is shown that he has done it. You know, otherwise it was absolute other section 63 has gone for a toss. Now, my lord, in this fact, my lord, my only submission, my lord, with regard to is that once a person who is dead now, my lord, if it is shown, my lord, voluntarily he has done something, and there is no circumstances or a pleading to that extent or proof that overpowering situation is coming forward, my lord, then, my lord, there is nothing, my lord, to grant probate of the.
Achha, Mr. Chatterjee, how do you explain the execution of two wills on the same date?
Now, my lord, to this.
Because that's a thing which, that's a question
Yes,
which was raised.
Yes, yes. Now, my lord, two wills, my lord, on a same day. My lord, this one will has never seen the light of the day, though, my lord, having for the moment, my lord, that will was presented for probate. My lord, it is under test.
Achha, it was presented for probate?
No, no. It
the second
never
will was
presented for a probate.
You produced it, you admitted the existence of that
my lord,
will.
he pleaded, I produced it. So, my lord, now, my lord, the question is, my lord, even on that today, my lord, court, they have not crossed on me on that. Or
So doesn't it cast a doubt on the will? Either of the two is genuine, and you can never be sure which one is genuine.
Now, my lord, to that, if my lord sees the written
Twice
statement,
on the same day I signed two wills saying this is the first and last will, and give properties to
trial
different.
court, that's why trial court.
Property different.
Yes.
Show us the properties were different.
Yes. My lord, I showed that the measurement of the properties differed, though the dark numbers remain the same.
As a measurement was different.
Different.
We'll take note of that.
So therefore, my lord, that way, my lord, the trial court has, my lord, looked into that aspect. No, the other will, if at all.
Trial court just said the other will dealt with different properties.
Because their case is with regard to the same
but
property.
Mr. Shen touched on that point and said no, the same property.
No.
And you say the measurements are different.
Measurement, I've checked up.
Even if the dag is same.
Dag is same.
Very good.
And my lord, I would say, my lord, the reasoning of the trial court, if my lord sees, is from page 103 of the judgment.
Otherwise, it's yes.
Yes, my lord, trial court has absolutely looked.
One of the plausible views you are saying. We should not substitute
Yes.
our view.
Yes. Now, my lord, the other thing, the 2003 deed, my lord, of thumb impression, just adding on to that, my lord, this cross-examination happened in 2013. My lord, today, Mr. Sen, my lord, brings an Order 41 Rule 27 application before this court. saying to bring the will, the other will on record by way of additional evidence. But, my lord, in the trial court, my lord, in his pleading, he says the execution of the two wills. There is no doubt. Two upon the grandsons. So, my lord, he had always the opportunity to bring that will on the first. Second, 2003 deed, sale deed, which had the bearing of the thumb impression. My lord, that till date has not been challenged. At least we cannot find any challenge to that by my lord, declaration that that deed is bad. This is not my father's deed.
So he's trying to bring on record the deed or the will?
No, I'm saying, my lord, the action, my lord, today to bring in, my lord, documents should be filed because he, despite knowing these things, my lord, have never assailed before any court at any point of time. So, my lord, if that action, my lord, action of the parties, my lord, Order 41 Rule 27 is in negative term. A court should not allow unless that circumstances, my lord, prevail. Now, my lord, this circumstance, my lord, in the case, my lord, or substantial court, if my lord takes Order 41 Rule 27 for one. আমার বই দাও না দাদা আমার বইটা রয়ে গেছে শুভঙ্করকে বলতো আমার বইটা আচ্ছা ঠিক আছে বললাম বইটা দিতে
একই বই
No, my lord.
You're citing it to show negative language.
Yes.
And Order 41 Rule 27 AA.
A and AA, both. Both doesn't apply in his case. B, if at all, my lord, Mr. Sen could have argued, B applies in my case. Because B says the language is.
B could apply.
Yeah, the appellate court requires any document to be produced or any witness.
B will have overriding effect on both A and AA.
Yes. So if A and A.
Why A should not apply, Mr. Chatterjee?
A, because the court from whose decree the appeal is preferred has refused to admit in evidence. So, my lord, despite that the document being on record, it was never tendered into evidence. So, no question of admitting into evidence.
Right.
AA is, my lord, seeking to produce additional.
A we know.
B now.
B why not?
B because, my lord, this substantial cause to, my lord, the other substantial cause, my lord, is, my lord, cannot be used to fill up a lacuna. Why I say, my lord? If you had a knowledge of those wills.
If it's a clear AA case, then B cannot be resorted to override that.
Yes.
I mean, just because it's.
Yes, my lord, I have a decision on this also, my lord.
This will be the last decision you are citing.
My lord, I'm just handing over. My lord, this is reported in AIR 1968 Supreme Court 406. My lord, this is a 3 judges bench decision. Kindly turns to, my lord, paragraph 7, but I will not read the entire. Just before paragraph 8, the previous paragraph,
yes.
From bottom 8 line stop, the document relied upon.
We do not think.
Yes. My lord, just prior to that, my lord, the document relied upon, my lord.
Very good. Yes.
The document relied upon was admittedly in the possession of the appellant, but they did not rely upon it before the High Court. It was said at the bar, the importance of the document was realized by those in charge of cases. We do not think that the plea would bring the case within the expression other substantial cause in Order 41 Rule 27 of the Code of Civil Procedure. We therefore decline to allow this additional evidence to be brought on record. There is accordingly no written evidencing the consent or authority of entering into a contract in their own account, but I'm not reading over. So, my lord, the documents which were there, my lord, was available to them. They had not done that. Now they cannot be, my lord, taking substantial cause to bring that on record. So,
what is the reason cited by them to produce that now? I mean, they want to rely on that for
substantial.
What? They want to rely on that for what?
Not just application
to show what? Probably to harp on the suspicious circumstance that 2 wills were executed on this.
Yes, my lord. They say, my lord, the situation was the said hidden will. It was never hidden. It was before the court.
Hidden in full public view.
Hidden in full public view.
Yes.
And, my lord, to that. Yes.
Very. Thank you. Yes, Mr. Sen, answer.
All the points
Oh, you are for?
respondent number 2, my lord.
Oh, absolutely. Yes.
Just not
You are
add
for respondent number 1.
I'm for the respondent number 3.
3. Yes, Mr. Banerjee.
Following 3. All the points are covered. Not a few facts I'll add. Not to be already covered.
Yes.
Sorry.
You are for 2, you said.
I'm for 2.
Yes.
So Mr. Sen has heavily relied upon the documents filed by way of Firisti. Documents before the court should have considered the other will.
Yes.
I'm not disputing that. Not documents were filed. In that bunch,
Just speaking about the other will.
the other will, which was filed by way of a Firisti, which
Yes.
was before the court.
Right.
And he says the cross will that casts a doubt. Same bunch of documents, but a deed was also produced by us, which is considered by the court at page 107 for the proposition that there was a prior deed where LTI was there.
That
So,
sale deed which was tendered to
sale deed which was tendered. So there was a prior sale deed. The court has relied on that deed to come to the finding that it is explained. LTI, there's a previous deed also where LTI was given to explain that proposition. I add one thing to that, my lord. If your lordship sees the dates, my lord, the other deed was, my lord, of dated 16th of December 2003. Now, in their written objection, they have said that 4th of January 2004, father was taken away from the custody of the daughter.
Then prior to that.
Now, my lord, if that be so, then entire story falls apart. If on 16th of December 2003, he went to the registry office and deed is registered, he was in custody of the daughter, then how is that possible? Father is not it's not part of the record, my lord. If
that sale deed was not exhibited, Mr. Banerjee.
No, it was not. It was produced along with the same bunch they are relying upon. If they are relying on the other document,
not relying on the bunch, they are relying on a particular.
Fact is this: that was a prior deed when the father was in the custody of the daughter. So, if the father was in the custody of the daughter and he executed a deed with LTI, then the story that on 4th he was taken away and after that through coercion something has been done, that story falls apart.
No, but before that this was done, this sale deed was executed.
Yes, 16th of December.
That sale deed was in favor of third party.
But with
so he might
LTI,
have
with LTI.
The story does not fall apart. He might have executed the sale deed on 16th of December and taken away forcibly on 4th of January. 16th December, you said 2003 was the date of the sale deed.
LTI?
That was not during the period when he was forcibly taken away. So he might have executed that sale deed on 16th of December and taken away forcibly on 4th of January.
Then, my lord,
that the story of taking away forcibly does not fail for that.
No, but on that the LTI story of LTI.
Yes.
LTI falls apart because there's a prior deed where also father executes with LTI. So page 107, if your lordship kindly comes, my lord. Page 107 bottom. I'm just reading how the court has dealt with this point. The burden lying on the applicant will be discharged or at least lessened if it could be proved that the testator testatrix on some earlier occasion also executed deeds by affixing thumb impression. Or judgment is relied upon.
Yes, that you have seen also.
Court records that a sale deed was executed prior to execution. So, the ratio of the judgment is relied upon and it is held that LTI is not so suspicious in the facts and circumstances. This is not one thing. Next is, my lord, the point of two wills, my lord, already explained by Mr. Chatterjee that there's difference in the quantum of land, although that's the same. And I'll just add, my lord, that devolution is in the same branch. Had there been, my lord, any contradiction in the two devolutions, my lord, it would have been given rise to suspicion being mutually destructive. Intention is different. But devolution in the same branch.
Same persons.
No, say not same persons, but sons and grandsons. One deed is in favor of the sons, one will is in favor of the grandsons.
So the sons of those sons only.
Sons of those sons. So devolution in the same line, not contradictory to each other. So that is not such a success.
So no useful purpose will be served in your favor.
Even if that is no purpose will be served. Even if that is granted, the same branch gets the benefit of the will. So it is grandsons are getting. If this is
Your sons are getting.
my sons
I mean, the beneficiaries of the other will, their sons are getting.
who were the attesting witnesses, they are getting. So it is not mutually destructive. Now, my lord, (63C) they have not relied upon.
But the second will, which is which
But
they are now
now
producing, that by that the grandsons get.
grandsons get. Same branch, no contradiction, not mutually destructive. Now, on 63C, my lord,
Yes, and
firstly, on 63C,
Is
firstly, I would submit that my lord, their stand in written objection is that he was not taken at all. Some impostor was taken. Your lordship has seen their written objection.
alternative case was there. He executed under force or under that
Taken
9F
at all.
or something.
So, my lord, that is not, it cannot be an alternative. He was-
Exactly. We saw
it
that.
becomes if the case
Either
is that
forcibly taken and
not
he put his
taken at all,
LTI
yes.
or
so it becomes mutually destructive. So the case of 63C becomes mutually destructive to the other case made out. And secondly, in cross,
yes.
in cross, my lord, there is no clear suggestion that the second witness's signature in presence of the testator is not proved. No clear suggestion.
But it's your onus to prove.
My onus to, I'll come to that, my lord. On that, my lord, your lordship has seen, my lord, the examination cross also, pages 60 and 63 I'll place, and the, my lord, chief, which is, my lord, affidavit in chief, which we have taken down, my juniors, my learned friends junior has taken down the chief. I'll just place a few portions and rely on a judgment, my lord, which of the Honorable Apex Court, which says that even if it is not specifically stated that the second witness has also signed in my presence, one witness comes. From the attending circumstances, court can come to the finding.
One has been cited. Don't
One-
cite the common
That is-
1954 has been cited.
54. 2010 also cited by Mr. Chatterjee, my lord, on the same proposition that court has to see, my lord, totally to come to the conclusion.
Yes.
It's not this judgment is very specific on this issue. One witness has not stated that I have seen the other witness sign. Court says from the entirety of the evidence where
No, here one witness has not said that he has seen the testator sign.
in this case, my lord, one witness
In the site, in this case, the case we are hearing.
he has not said that the other witness has signed in presence of the testator and the testator has signed in presence of the other witness. That statement.
No, did he say that the testator, he saw the testator sign?
Yes, that is there.
That is there.
Second witness is not proved. That is
All
there.
right, all right.
So on that, my lord, Mr. Chatterjee has not relied on 2010-14. I'm just reading, your lordship did not open two paragraphs of that judgment. Paragraphs 21 and 23.
54.
No, this is not 2010, volume 14, SCC 266.
He has not cited that.
He cited his previous day, he has cited.
Yes.
Paragraph 21, I'm reading.
Para 15 to 21 he is cited,
Yes, cited.
and 23 particularly.
Deals with this point, my lord, that court will take overall evidence, even if there's no statement to that.
Para 21 we have also marked.
21 I'm reading. 21 says, from the fourth line, the deposition of Sri Vilas PK, in our opinion, satisfies this. No, I'll read the. This brings us to the third requirement, namely the will must be attested by two or more witnesses, each of whom has seen the testator signing and affixing his mark to the will, or has seen some other person signing in the personal in the presence and by the direction of the testator. The deposition of Sri Vilas Tikhe, in our opinion, satisfies this requirement also, in as much as the witness has in clear and unambiguous terms stated that not only he, but Sri Manoj, the other attesting witness to the will, was also present at the time the testator affixed his signature on the will. It is noteworthy that the above statement has not been questioned in cross-examination, nor any suggestion made to the effect that while Sri Vilas Tikhe, the witness may have been present, Manoj was not so present at the time the will was signed by the testator. As a matter of fact, the witness has made a categorical statement that Manoj met the testator in the court and was taken along and that not only at the time of signing the will by the testator, but even before the registrar, Manoj Kumar was present. Same as not this case. I'll show you that those parts of the evidence. And 23 says, then on relying on this, as was observed by this court in Venkatachala Iyengar versus BN Thimmajamma, in the matter of proof of documents, as in the case of the proof of wills, it is idle to expect proof with mathematical certainty. The test to be applied is the test of satisfaction of a prudent man. So this, now let same proposition is reiterated with similar facts in 2013 Millard. This 2013 volume 7 Supreme Court cases 490. Dr. Miller, kindly come to paragraph 19, Millard. Paragraph 19, Millard.
Yes.
Page 9. In Jankinayan Bhoyer, this court has explained the interrelation between section 63C of the Succession Act 1925 and section 68 and 71 of the Evidence Act 1872. In that matter, only one attesting witness to the will was examined to prove the will, but he had not stated in his deposition that the other attesting witness had attested the will in his presence. The other attesting witness, though alive and available, was not examined. The court noted the relevant facts in paragraph 5 of the judgment as follows. The judgment is quoted. I am just skipping this because ultimately conclusion is later. Then on this background, court held at the end of paragraph 6 of the judgment that it is true that although a will is required to be attested by two witnesses, it could be proved by examining one of the attesting witnesses as per section 68 of the Evidence Act. It is also noted in paragraph 9 that one of the requirement of our of due execution of a will is its attestation by two or more witnesses, which is mandatory. In paragraphs 11 and 12 of the judgment, the court noted the relevance of section 71 of the Evidence Act by stating that aid of section 71 can be taken only when execution of the document to prove it by other evidence. Only when the attesting witnesses who have been called deny or fail to recollect the execution of the document to prove it by other evidence. Section 71 has no application when the one attesting witness who alone has been summoned has failed to prove the execution of the will and the other attesting witness, though available, has not been examined. In the facts of the case, therefore, the court held that attestation of the will as required by section 63 was not established, which was equally necessary. In the present case, we may note that in paragraph 21 of his cross-examination, P. Basavraje URS has in terms stated Mr. Mallaraje URS and Srimati Nagammani, myself and one Sampath Iyengar were present while writing the will. One Mr. Narayan Murthy was also present. In paragraph 22, he has stated that Narayan Murthy had written Exhibit 3 in his own handwriting continuously. The fact that M. Mallaraje was present at the time of execution of the will is not contested by the defendants by putting it to PW2 that M. Mallaraje was not present when the will was executed. As held by a division bench of the Calcutta High Court in the matter concerning a will, in paragraph 10 of AEG Carapiet, it is held wherever the opponent has declined, the Carapiet principle is not explained that it has to be put specifically. As noted earlier, not fourth line, Lord. As noted earlier, the will was executed on 24th October. The fact that the will is signed by Srimati Nagammani in presence has also been proved.
In our view, placed from there, that is a relevant portion. The question is put, can the signing of the will? Paragraph 20 continued.
Paragraph 21. The issue of validity of the will in the present case will have to be considered in the context of these wills. It is true that in the case at hand, there is no specific statement by PW2 that he had seen the other attesting witness sign the will in presence of the testator. But he has stated that the other witness has also signed the document.
No, start after the question mark. Above facts on record, question mark. Paragraph 20.
Paragraph 20.
Before paragraph 21. In our view, in the facts of the case, last 8 lines from the bottom.
In our view, in the facts of the present case, the omission on the part of PW2 to specifically state that the signature of M. Mallaraje on the will which he identified was placed in the presence of Srimati Nagammani, and that her signature, which he identified was also placed in the presence of M. Mallaraje, can be said to be a facet of not recollecting about the same. This deficiency can be taken care of by looking to the other evidence of attendant circumstances placed on record, which is permissible under Section 71 of the Evidence Act. So this is not the principle that other evidences can be looked into.
Yes, yes.
And
Need
in
not be
this case,
strictly.
my lord, in this case, my lord, page 60, I'll just show my lord, the lordship just takes note of page 60. This is the evidence of my lord, PW1.
Yes.
Executor, he says, my father has put his LTI in the will first, and his name was written to the pen of my nephew Kaushik Noshkar. Aurobindo Noshkar is the father of Kaushik. Kaushik and Arup Noshkar had signed on the will after the name of my father was written by Kaushik. The witness Anup Noshkar is my son. This is in cross-examination. No suggestion that other
This
witness...
Arup should be Anup. Arup should be Anup.
No.
Or Arup is Arup.
No. Anup.
Arup is Anup.
Anup. It should be Anup, my lord.
Yes.
So he states that in his evidence. Then kindly come to page 63, my lord. The evidence of the attesting witness, Kaushik.
PW1 was one of the attesting witnesses.
No, he was the executor. Executor. Then PW2, my lord.
Yes.
He states that both have signed. Page 63. Is the, my lord, chief. Kindly come to the third paragraph, my lord.
Yes.
Third paragraph. Badal Chandra Noshkar was my grandfather. He executed a registered will prior to his death. I was witness of the said will. This is the said will, and this is my signature on the will. This will was written as per instruction of my grandfather. It was scribed by learned advocate Krishnabada Sarkar, since deceased. It was typed by one Amar Ranjan Majumdar, a typist of Barasat Court. The will was read over to my grandfather by his advocate. My grandfather executed the will by putting his thumb impression in my presence as per instruction of my grandfather. My grandfather was quite hale and hearty at the time of execution of the will. He could sign, but due to old age, he executed the will by putting his thumb impression. My cousin brother, Anup Noshkar, was the other witness to the will. So the other witness he mentions. Then I put my signature as an attesting witness as per instruction of my grandfather. Thereafter, learned advocate and typist of the will signed on the said will. After that, the will was taken to Barasat Registry Office. Then, Lord, kindly skips this, Lord, kindly comes to cross-examination. Cross-examination, kindly, Lord, skips, Lord, 4 lines, Lord. My grandfather was a registered Mohora. Real Lordship was got cross-examination.
Yes.
My grandfather was a registered Mohora at Barasat Court.
No, this is which page?
Page 64, my lord. Cross starts at 64.
Yes, yes.
4th line, Lord,
Yes,
cross-examination. My grandfather was a registered Mohora at Barasat Court. Anup Noshkar is the son of my uncle Sukuman Noshkar. All the properties involved in the will were owned by my grandfather at the time of execution of will. I cannot say some of the properties involved in the will were already vested during lifetime of my grandfather. Not a fact that my grandfather disposed of some of the properties.
Anup Noshkar was the other attesting witness.
Next. Anup.
Anup was the other attesting witness.
Kaushik is deposing Anup. Then, my lord, at the time of execution, there was no outsider in the execution
That Mr.
of
Chatterjee
will
also
except
placed.
myself,
Mark.
Anup Noshkar, my father, uncle, learned advocate, and Mohora. So in cross, he says that Anup was present at the time
Like
of
your this judgment.
in this judgment. And apart from that, my lord, he has taken note of, my lord, the chief of the attesting witness. The chief also categorically states, my lord, the sequence of events. The chief, my lord, we have taken note of.
Chief of
Lord Kaushik, which was filed on affidavit, my lord.
It's not there here.
It is not part of the paper book, my lord. So we have taken. May I?
Do you have a copy? You should have taken out copies.
No,
You should have got it typed and
we have got it.
you have, Mr. Shen. Thank you. But you may not have so many copies. Do you?
This is Kumar and my lord Kaushik.
Thank you.
This is Kaushik.
Kaushik.
Thank you very much. The 2 copies. No, you have given 2 copies. What is the other one? Or the other witness?
Kaushik, my lord, it is.
Thank you very much. Thank you very much. Yes.
Apart from the cross, my lord, page 63, if your lordship sees.
Which paragraph of
his? 5, my lord.
5 years.
That said will, dated 7/1/2004, was drafted by Sri Krishnabada Sarkar, advocate of Barasat Court, as per instruction of Sri Badal Chandra Noshkar in presence of me. And thereafter, said draft of will typed by Amol Ranjan Majumdar, typist of Barasat Court, in presence of me, and thereafter said Badal Chandra Noskor read the typed copy of the said will, and after satisfied the contents of the said typed copy of will, said Badal Chandra Noskor asked me to take the LTI in all pages of the said typed copy of the will, and accordingly I took LTI of said Badal Chandra Noskor in all the pages of the said will, in presence of Anup Noskor of Pathorghata, attesting witness number 2, Krishnapada Sarkar, advocate, Barasat Court, Amol Ranjan Majumdar, typist, Sukumar Noskor, and Aurobindo Noskor. And thereafter, I also identified the LTI of said Badal Chandra Noskor in all pages of the said will, in presence of the said witness, in the chamber of said Krishnapada Sarkar. At the time of execution of said will, said Badal Chandra Noskor was in good health and sound mind. Said Badal Chandra Noskor voluntarily and willingly put his LTI in the said will, and was found him to put his LTI in the said will
Yes.
at all. Thereafter
Put their
said-
signature, respective signature in presence of me.
Thereafter said Anup Noskor of Pathorghata
And the others
Krishnapada
put
Sarkar
their
put
respective signature in presence of me.
So that is clearly stated. So I say in these tax notes requirement is proved. So, the other points Mr. Chatterjee has covered. I need not add anything, only this lot. So if they rely on the will, other will, then they should also then I can rely on.
Same Philistine does not mean that you have to rely on our-
These are my submissions.
Thank you very much. Yes. Mr. Shen.
Kindly,
No fixation. Today we'll finish it.
if you,
Why?
some facts are to be stated. Kindly, I will take short 10 minutes only.
Part-heard matters, we are held up in the other matters due to this. You don't want to carry so many part-heard matters, Mr. We have already concluded, forced Ms. Agarwal to conclude a matter.
This is the last part. This was the last part in the list.
No, there will be more part-heards. Today itself, maybe there will be.
On the next day,
No, we don't want to carry.
I will submit written notes and complete my argument. But that will take time.
No, we don't want written notes complete today.
No, written notes. Well, your lordship on the other day observed.
Heard learned counsel appearing for the, you are for the respondent number 3. Heard learned counsel for the respondent number 3 and learned senior counsel appearing for respondent number 2.
1 and 2.
1 and 2. Respondent numbers 1 and 2. Pushed up on the prayer of learned senior counsel, he has also been designated. Learned senior counsel appearing for the appellant. The matter is adjourned till July 17, 2025 for rejoinder arguments, which are learned counsel for the parties are requested to file the written notes of arguments on the next date. You come prepared with yours? And Mr. Shen, you give an idea to them, you cannot go behind what they have argued in your rejoinder, but also give them an idea of what you will be saying so that they can put it in the written notes also. If you want to add anything like আজকের ইয়েগুলো কোথায় গেল? হ্যাঁ, আমার একটা সেট নিলেন, ওটা দেখি। আজকে যেগুলো সাইড করলে সেগুলো এক জায়গায় ঢুকবে, ওরকম ভাবে নিলে হবে না তো। এটাও ঢুকিয়ে নিন, এটার মধ্যে ছিল। Yes, Mr.
I beg to appear for the appellant, Lord. Right. Effectively, there is no respondent, Lord, in these proceedings. Lord, what had happened is that, Lord, probate proceedings was dismissed for default. Then, Lord, a restoration application was filed. Even at the restoration stage, Lord, nobody appeared.
By the delegate himself.
It
It was rendered contentious.
No, it was marked as a contentious cause. Evidence was being taken.
So why do you say respondent? There is no.
Lord, at some point they stopped contesting, and at that stage, Lord, the substituted
It was fixed for expert hearing.
it was fixed for evidence at that stage, Lord. There was a default in the part of the propounder
Yes.
from appearing, and
But the other side has been notice has been
Yes,
served. Notice
yes,
of the appeal has been.
substituted service was done pursuant to your lordship's
Good.
order. And in fact, it was substituted service also, my lord, before the court below.
Good. It was dismissed for your default.
It just dismissed for default, my lord. The propounder was not keeping well. In fact, there was a lack of communication between the advocate and the propounder. She was a lady.
Can you see the impute judgment first?
Yes, my lord. Please kindly, my lord, see the judgment, my lord, which is at page. No, a minute. At page 67. In fact, the restoration application which was filed along with section 5 application, the section 5 application was dismissed. Therefore, my lord, the restoration application was not considered. That is the stage, my lord, at which there was some delay.
So section 5 allowed, consequentially.
No, section 5 dismissed.
Sorry, dismiss. Consequentially,
Restoration.
order 9 rule 9 also goes
Goes.
against.
This is the stage. My lord, this is the order which starts at page 67.
You blamed the learned advocate that was
That was, my lord,
that also we are also say of the same opinion. It has become a common trend.
Lord, basically, my lord, that was the ground, Lord.
Yes, but the court is rather right, Mr. Kaur. Court says that further reveals that the advocate had undertaken a lengthy hearing. Then he stopped taking steps. Inferred that you had stopped
Lord,
giving
kindly,
instructions.
Kindly, my lord, assign, Lord, all blame. After all, Lord, this is a probate proceedings. It's a proceedings in rem. It's a proceedings in rem. This is actually, my lord, when there are
wishes of a deceased person.
Wishes of a deceased person which has to be given effect to, and Lord, there are two legatees, Lord, who are ladies. Unfortunately, they are the ones who were, Lord, pursuing. The third daughter, I think, who was excluded, she was contesting at some point. Lord, the blame should have been taken on the person, Lord, herself, because, Lord, there were COVID time in between 15th March 2020 to 28th February 2022 was, Lord, also, Lord, COVID time. And, Lord, this is what happened. Lord, in fact, the evidence is complete.
What was the delay in filing?
Delay was, your lordships, kindly give me section 5 application. I'll just show your lordship. But I think, Lord, the delay was about 82 days. No. It is the application, just section 5. Just show me the section 5
This is a plausible view, otherwise, Mr. Court.
Lord, it is. I'm not saying.
Allegedly, you went back to the same advocate. Then also you waited good number of days before going to another new advocate.
Lord,
Is the explanation for that? Nothing. Let us see your section 5.
Lord, section 5 is at page. Section 5 page to what? Kindly give him 1 minute.
Yes.
Lord, section 5 is at page 131 to 136, and the order 9, rule 9 application is at page 121. 131, if your lordship's kindly.
No, that is the order.
That is
something else.
Oh, sorry. The lordship wants to see the application. I'm sorry. Application to the
Page 41.
page 40. Yes. Page 41. নোটটা কোথায় গেল? জ্যোতি নেই আজকে, খুব মুশকিল হয়েছে। নোটটা কোন লিস্টে? মারাও ব্যাপার কি? In fact, Lord, the executrix is dead.
Months passed.
Yes.
850 days.
850 days. There was a delay, my Lord.
When was it dismissed for default?
It was dismissed for default. I'll give your lordship the date.
Yes.
It was dismissed for default on 7th November 2019.
And this was filed on February 2022.
Yes.
That was prior to the COVID period.
But the
6 months before the COVID
Yes,
started.
yes. In
Not
between
6, 4 months.
4 months. Yes.
And also February 2022 is much after the last relaxation given 2021.
No,
Another say 4 months.
February 2022 is the last date. 28th of February 2022 was the
relaxation was extended till then.
Till 28th February
February 2022 পেজ 278 লেখা
No, judgment তো নিয়ে আসতে বলেছে।
এই তো জাজমেন্ট এনেছি
হ্যাঁ।
আর এটা অ্যানেক্স করা আছে এই 28 ফেব্রুয়ারি উইদিন টাইমে ফাইল করে দিচ্ছি
In fact, Lord, my learned friend has annexed that judgment also, but yes, 28th February 2022.
No, but you're saying that is
উইদিন টাইম
Lord, in fact, Lord, nobody would be prejudiced. Lord, we are willing to, Lord, withdraw also. Lord, unfortunately, the applicant is no more there. She passed away in the meantime. There has been a substitution. So, Lord, we are prepared to, Lord, withdraw or express an apology.
Mr. Kaur, tell us the name of a good either government organization or non-government organization which does good work.
He's got.
You tell us, have your pick.
Lord, I think legal services.
Legal
High Court legal services.
Good. Learned Senior Counsel, the present appeal arises out of an order, Mr. God, please take your seat. Out of an order whereby an application for condonation of delay in filing a petition under Order 9, Rule 9 of the Code of Civil Procedure, for restoration of a probate suit, was dismissed. And, consequentially, the petition under Order 9, Rule 9 was also dismissed. First of next para, it transpires that a probate application was filed by the original propounder / executor, which turned contentious subsequently. Full stop. However, thereafter the probate proceeding was not being contested seriously. Full stop. In the meantime, during the stage of adduction of evidence, the probate suit was dismissed for default on November 7, 2019 due to non-appearance on behalf of the propounder. Full stop. Next para, learned senior counsel appearing for the appellant submits that although certain averments have been made in the application which touch upon the conduct made in the application under Section 5 of the Limitation Act, which touch upon the conduct of the erstwhile learned advocate of the executor, comma, such allegations are not of such a serious nature. Full stop. Next para, that apart, comma, it is candidly submitted that in the event this court is so pleased, comma, the appellants are willing to dilute such allegations and or take back the same and take the blame upon themselves. Full stop. Next para, in that regard, comma, learned senior counsel's contents that even irrespective of the conduct of the erstwhile learned advocate of the executant, comma, a substantial chunk of the relevant period of delay was covered by the pandemic restrictions. Full stop. Next para, whereas the dismissal for default took place on November 7, 2019, comma, the application under Section 5 of the Code of the Limitation Act, as well as the application under Order 9 Rule 9 of the Code of Civil Procedure were filed around February 28, 2022, comma, till when the COVID relaxations granted by the Honorable Supreme Court from time to time were prevailed. Full stop. Next para, learned senior counsel submits that apart from the fact that the pandemic restrictions intervened, comma, it also ought to be considered by the court that the nature of the LIS is not in personam, but the outcome of the same would be a judgment in rem. Full stop. Next para, as such, comma, the limited drawbacks of the executant in not being able to pursue the probate proceeding duly ought to be diluted and taken and looked at on a broader perspective. So next para, upon a perusal of the impugned order, comma, we do not find as such any gross illegality in the same. Full stop. The learned testamentary court proceeded on the premise that it has become a trend to cast blame on the advocates. Full stop. Also, it was considered that the petitioner waited a good number of days before approaching another advocate. Full stop. The learned trial testamentary court also refused to accept the contention of the petitioner to the effect that the petitioner, comma, after knowing about the dismissal for default, had gone back to her former advocate. Full stop. Next para. However, comma, although such deductions are plausible, comma, those also tread tier EAD rather into the realm REALM of conjecture. Full stop. Next para. There was no written objection to the Section 5. Full stop. In view of there being no written objection filed to the applications for condonation of delay and restoration, comma, the doctrine of non-traverse ought also to have been taken note of. Full stop. Even apart from that, comma, we do not find that any serious allegation of such a nature that casts a blemish on the learned erstwhile advocate has been leveled. Full stop. Next para. Even if it is assumed that there was some negligence on the part of the petitioner stroke executor in conducting the probate proceeding at the relevant juncture, comma, such we do not find any malafidis which can be attributed to the executor for such lack of diligence. Full stop. Next para, that apart, comma, we agree with the contention of learned senior counsel appearing for the appellants that a substantial part of the delay was covered by the pandemic relaxations. Full stop. Next para, also, comma, we have to take into account the fact that the nature of the present litigation is not one in personam, which would merely affect the rights of the parties to the litigation, but has an aspect of a judgment in rem. Full stop. In respect of considerations in rem, comma, the outcome of the legal action would bind the world at large, and as such, comma, are of wider ramification that the mere fallibilities of individual parties. Full stop. Next para, also, comma, we take into consideration the fact that a probate proceeding is merely in the nature of seeking a ratification stroke sanction from a court of law for implementing the last will and testament of a deceased person, comma, who is no longer in the world to espouse his stroke her own cause. Full stop. Next para, seen from such perspective, comma, we find that it would be unjust to restrict our considerations merely to the lack of due diligence on the part of the executor. Full stop. Next para, as such, comma, in view of the above considerations, comma, we are of the opinion that sufficient cause for the delay had been made out. Full stop. Accordingly, FMA 1454 of 2024 is allowed, comma, thereby setting aside the impugned order bearing order number 21 dated August 28, 2024, passed by the learned additional district judge 10th court at Alipur district South 24 Parganas in miscellaneous case number 90 of 2022 within bracket arising out of origin OS number 03 of 2007 bracket closed. Full stop. We hereby allow the application for condonation of delay in filing miscellaneous case number 90 of 2022, and as a consequence, comma, in view of our above observations, comma, allow miss case number 90 of 2022 as well. Full stop. Next para, accordingly, OS number 03 of 2007 is restored to its original file and number. Full stop. The learned testamentary court shall now proceed to hear and dispose of the said probate proceeding from the stage till which it was from the stage which it had reached immediately prior to the dismissal for default of the same. No address to cost.
Much obliged to your lordship.
Expeditiously quoted.
Lord, wherever
No
the-
cost. Yes.
No, I'm much obliged, Lord.
Yes.
Wherever the word executor appears, it should be executrix.
Oh, thank you.
Wherever, Lord, in the
ওই
judgment,
control find করে না executor টা execute.
execute.
And what else?
Oh, wow. No, it's absolute. Sure, it will take it.
All right.
There is a defect, my lord, which I must cure.
Today, my lord, this has been, a notice is being served, but I have not brought also the brief. on that.
I'll not be asking for anything that will prejudice my learned friend. My lord, there is a error. My lord, I have not put in the valuation statement, which is why the stamp reporter has given a report saying that the adequacy of the stamp fee given, stamp duty given is also unable to be assessed.
Section 5 is before us.
Yes, that
It has
is
been
also-
allowed.
No. That's also pending.
Why is it appearing as then? Oh, this is appearing in order 41 heading.
Yes, order for job. But my lord, I must cure the defect first.
But I
Kindly-
cannot
Give you that liberty right now.
Huh?
But after almost 1 year, my lord, this appeal has
You could
been
have done that when you.
Lord,
when you
there-
took up the-
My lord, I also indicate my lord the urgency. Now, my lord, I am my lord on the verge, my lord, of a threat of being evicted from the
No, not
property.
that. We are not taking up the appeal on merit.
Yes.
So for
Kindly,
this,
my lord, allow me, my lord, to cure the defect, my lord, put in, my lord, the valuation statement, my lord, in the memorandum of appeal.
you
as
could
well
have done that when you took up the
as should
matter.
have been done. Should have been done.
Why did you mention out of?
But since otherwise matter.
The matter is being taken out of turn on the prayer of the appellant, whose of learned counsel appearing for the appellant seeks to cure the defect inasmuch as the valuation statement has not been given in the memorandum of appeal. Full stop. Leave is granted to the learned advocate on record for the appellant to insert the valuation statement in the memorandum of appeal during the course of the day by carrying out the necessary correction thereto.
And my lord, may a returnable date be also fixed, my lord, or my lord, may we mention, my lord, after the defect is cured and
No. You have given a copy of section 5 to them.
yes, my lord, everything has been served. Everything has been served. My lord, may a returnable
Should
date-
have appeared as then.
Matter is appearing in the list.
That's
Should
true.
have appeared as application.
That's true.
Anyway, whatever. No.
My lord, may it appear as an application on any?
No, as it is appearing, it will retain its position.
My lord, would it be my lord's kind pleasure to indicate a date, my lord?
No. আচ্ছা অনুদিতা বলছি এই সোমবার থেকে না সামনের সপ্তাহটা অর্ডার 41 গুলো আগে order 41 matters first before the applications. We occasionally reverse. This is under order 41.
This is my lord under application heading now? Oh, under order 40.
So that's why you
Oh.
look morose.
Oh.
Yes.
Grateful.
Yeah, thank you.
Grateful.
Hey, please, your lordship.
106 থেকে 2 PM যেটা দিয়েছি না Yes.
The subject matter of the challenge is the order dated 30th April 2025,
This is appearing as order 41.
order 41, Lord, by which, my lord, the appellant's
Sorry, please repeat the subject matter of challenge is.
The subject matter of the challenge is the impugned order dated 30th April 2025, by which the appellant's petitioner's application under order 22 rule 10 read with order 1 rule 10 read with section 151 have been rejected.
Order 20 rule 10 is applicable.
Applicable. Now, my lord, an application for grant of probate was presented by the opposite party. That application is at page number 19 to 23. My lord, amongst the list of the legal heirs, which is at paragraph number 10.
So what was the premise of rejection?
No,
This is in connection with the probate proceeding.
Probate proceeding, my lord.
You are the propounder.
No, I am not the
You
proposer.
are-
I
you
am
are
the purchaser. I am the purchaser of the property from the legal heirs whose name appears in the probate application. By a registered deed of assignment, I purchased the property.
So you are held not to have caveatable interest.
I have the caveatable interest, my
No,
lord.
you are held not to have caveatable
Yes,
interest. That's
my
why
lord.
rejected.
And not only that, my lord, this particular applicant, I mean the person who had applied for the probate, is also seeking a decree of eviction from a competent civil court of law instituted by these two legal heirs who have transferred their interest in my favor. Subsequently, by an order of civil court, that decree is also transferred in my favor. All these facts were brought to the knowledge of the learned trial court. Learned trial court had held
Mr. Patwari, the consideration of addition of party in a civil suit is different from a probate proceeding.
order 22 rule 10, my lord. I will be relying, my lord, on similar proposition, my lord. I will be relying on the
What
judgment
you
of
are saying is that Mr. Patwari, in a civil suit, order 20 rule 10 also, you have to have caveatable interest
Yes,
in a probate proceeding.
yes.
Which is not there in a civil suit. Civil
Yes,
suit,
madam.
once you step in, you are
Yes.
automatically added.
My lord, my humble submission is that when admittedly, if my lord will kind enough to see one application for probate,
Very well. Let us see that.
my lord.
Now, probate application not necessary.
No, I am just showing it, my lord, to show the list of class 1 legal heirs, which according to the propounder, had the deceased has been died without
So
any will,
they had to be citees.
they had to be citees, and they were contesting.
They were contesting. Now you have purchased from some of them.
No, from these two particular person who were
Contesting.
If my lord may permit me to rely, my lord, one judgment of this honorable court, AIR 1932 Calcutta,
Have you got a copy?
Yes, my lord. 730. May I hand over, my lord? Paragraph 2 and paragraph number 7 are exactly, my lord, the same proposition.
Yes.
May I place, my lord?
Right.
The appellant happens to have purchased, my lord, may I?
Yes, yes.
The appellant happens to have purchased one of the properties.
We don't get the name of the judges here.
My lord, judge's name of the judges. My lord, it's not there.
That does not appear in.
No, I've got a printout from Indian Kanun, my lord.
Indian Kanun.
AIR 1932. Name of the judges is generally
the judge's name have to be there.
Yes, my lord. It's not there.
I mean, if the judge's name is also not there, it's difficult for us to. Let us check up one minute. Yes. Para 2.
Para 2, my lord.
Yes.
The appellant happens to have purchased. Is it telling, my lord? It's not telling, my lord.
Yes, happens to have got that.
The appellant happens to have purchased one of the property disposed of by the will at an auction sale held in 1918 in execution of a decree for rent thereof, which was obtained by the landlord. This decree had been obtained by the landlord in a suit land against one of the daughters of the testator. The other two daughters having died before on the footing that she was the sole heir of the said testator. It should be pointed out here that under the will, all the properties were to vest in 3 daughters after the testator's death, and in case any of the daughters predeceased him, her sons and heirs would get the share. The district judge observed in his order, he is not a legatee, he is not an heir, and he has derived no interest in the estate from the deceased himself. To permit him to contest the grant merely on the ground of subsequent derivation of a title to some of the deceased's property would be to introduce an issue which a probate court has no jurisdiction to determine. It is a mere question on a question of title raised by a stranger on a transaction subsequent to the testator's death, and this is not within the scope of the court sitting in probate. Now, this honorable court, my lord, in paragraph number 7, my lord, last paragraph, my lord.
Yes.
A purchaser from an heir after the death of the testator has a locus standi, and to have it is not necessary for the objector to show.
Just give us half a minute. And we will follow from your
Last paragraph, my lord. Paragraph 7.
7 years.
A purchaser from an heir after the death of the testator has a locus standi, and to have it is not necessary for the objector to show that he had an interest in the state at the time of testator's death, as relied on Komalan Lochan Datta versus Neelratan Mandal, so and so. So also it has also been held that an assignee from an heir of the testator after the latter's death has locus standi to apply for revocation of probate already granted, relied on so and so. For these reasons, we hold that the second contention of the respondent, as also the view which the learned judge has proceeded, must be overruled. This result The result is that the appeal succeeds, the order of the court below is set aside, and the application of the respondent for letters of administration should be dealt with on giving the appellant an opportunity to contest the proceeding. So, my lord, here also, my lord, I'm sorry, my lord, I should have carried AIR. Sorry, my lord, should have.
Sometimes Indian Canon, we have found cases where there are some discrepancies. It's not your fault, I mean.
My lord.
But we are not finding out this portion. Let us find out this portion. We have to satisfy ourselves also.
My lord, similar proposition, my lord, has been held by the Honorable Madras High Court. My lord, it's a report.
If we have a Calcutta division bench, then we'll go by this.
My lord.
If you have a Calcutta division bench, we'll go by this. Why go on to Madras? Let us just complete this. Just
my lord.
Must be the same. Just we'll. Yes.
Lord.
Yes.
I'll first show, my lord, the application.
Oh, got it.
My lord.
So let us see the impugn order once.
My lord, my lord. My lord, may I please, my lord?
Yes. Just a relevant portion.
Yes, my lord.
The probate case evaluative execution is.
Now, the reason, my lord, why the application was rejected, my lord, start from second page, last paragraph. In a probate case. Now, though facts have been correctly stated by the learned trial court, but the reason have been cited from the last third paragraphs. The petitioner of the present OS, as my lord got that, refers to the decision of the Honorable Supreme Court reported in so and so. In this case, it was held that the plaintiff cannot be forced to add parties against whom he does not want to fight. Now, this Vishwanath Ghosh opposite party had contended before the learned trial court that since the plaintiff does not want to add a party and since the plaintiff are the master of a ship, they cannot.
Dominus litis is not, principle is not
my lord.
applicable in that rigor.
My lord.
But you have claimed, your vendor also claimed through another will.
Yes, my lord. In the registered deed of assignment, my lord, there was a subsequent will of 1997. Now, that is there, my lord, in the...
that will has been probated.
That has been probated, my lord, and on that basis, my lord, my vendor had obtained a decree of eviction. That decree I have also annexed, my lord.
Achha, suppose your vendor was not equipped with a will, even then he would be an heir.
Yes, my lord. As a class 1 legal heirs, my interest comes.
A prima facie case for hearing of the appeal on merits has been made out inasmuch as the application for addition of party, for substitution / addition of party under Order 22 Rule 10 of the Code of Civil Procedure filed by the present appellant, who is a purchaser from one of the heirs of the testator,
two of the heirs of a testator. Two heirs.
Achha, from purchaser from two of the heirs of the testator, filed in respect of a probate proceeding, was refused on the ground that the appellant does not have the locus standi to be so added. So, next para, learned counsel for the appellant relies on the judgment of Nobin Chandra Guho versus Nibaran Chandra Vishwas and others, reported at AIR 1932 Cal 734, to argue that in such cases, a purchaser from an assignee, a purchaser / assignee from one of the heirs can be deemed to have a caveatable interest. Next para. Accordingly, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal and the question as indicated above. There shall be stay of all further proceedings in OS number 47 of 2019 pending before the learned additional district and sessions judge, 7th court at Barasat, district North 24 Parganas, till disposal of the application. The appellant shall serve a copy of the application on the respondent, indicating that the application shall next be listed for hearing in the monthly list of August 2025. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date.
Extremely good.
Thanks. Well argued, Mr. Patel.
Yes, extremely,
Yes.
extremely good. Yes.
Yes.
Great to know.
Thanks.
এটা কার এই তোমার দুই দুই
Ratrishil. If you have a Ratrishil, then this is the matter.
I'm leading him,
State respondents, my lord.
but he will do it.
State
It is that
respondents.
matter, my lord, where section 107 and 108 of the Evidence Act
Yes, yes.
for the declaration of death.
Yeah, for the state.
The state respondents.
On the very first date, my lord, the learned
Take your
judge,
seat. Yes.
Yes.
your lordship,
Mr. Chatterjee, you can also take your seat. Yes.
at page 66 of the paper book, if your lordship kindly once looks at the judgment, I'll take your lordship, my lord, to the paragraph 12 of the plain relied upon, my lord, by the learned judge.
Oh, section 80 that.
Yes, section 80. My lord, at paragraph 12 of the plaint, it is alleged that the that GD was lodged on 16th of October 2023 before the Oshi Shampukur PS, and no steps have been taken by the authority till date. Then paragraph 15 of the plaint, it is stated that the defendant number 4 KMC was approached for mutation, but it
So
advised.
as the relief in the plaint, which is
My lord, kindly takes up the plaint once. My lord, it starts with, my lord, page 1. My lord, kindly takes up relief, my lord, directly at page 12.
yes, what do you have to say? Section 80, no scope of section 80, no relief against.
Probably in the first order, my lord, we have received this just few minutes back, but my lord, in your lordship's prior order, your lordship probably had, my lord, thought about this, that whether if no allegation is made or no relief is claimed, whether, my lord, section 80 notices.
He has fought for a declaration of the death of his predecessor
My lord, I have, my lord,
under
Right.
section 107.
I have tried to, my lord, on that line make some research, my lord. I have found an old judgment of our High Court only, which says that it may not be required.
It is not required, cannot be required. If there was some contrary judgment, we would have the arduous task of distinguishing that.
Yes. But since I found only one judgment, I could
So you're
found
passing
which, my
judgment
lord,
right now.
it's reported in year 1962, Calcutta 625.
Thank you very much. Yes, for the fairness. Heard learned counsel for the heard learned senior counsel appearing for the appellant as well as learned counsel for the respondents. Who's up next para? The brief conspectus of the appeal is whether a notice under section 80 of the Code of Civil Procedure is required in a suit for declaration of the death of the civil death of a person within the contemplation of sections 107 and 108 of the Evidence Act. Full stop. Next para. The learned trial judge, comma, while dismissing the suit, no, sorry, while rejecting the plaint, under order 7 rule 11 within bracket small d of the Code of Civil Procedure, comma, held that the suit was palpably barred by section 8 by non-compliance of section 80 of the Code of Civil Procedure. Full stop. A bare perusal of the plaint shows that the plaintiff stroke appellant sought, he was your father or who was he?
Uncle or granduncle?
Kamaleshwar?
Niece.
Very well.
Kamaleshwar was your
Where the plaintiff sought a decree for declaration of the civil death of one Kamaleshwar Mullik, full stop. Now, sorry, comma, along with other omnibus reliefs, full stop. Since such a suit is in the nature of a legal action in rem, comma, since it affects the world at large, comma, we are of the opinion that the reliefs sought are not confined to the respondent to the defendant authorities. Full stop. Next para, that apart, comma, by its very nature, comma, the suit did not claim any relief as such against the defendant authorities, but such defendants were made formally as parties, comma, as the nature of the suit is one for declaration which is not adversarial in nature. Full stop. Next para. Hence, comma, there arises no question of prior service of notice under section 80 of the Code of Civil Procedure in such a suit. Thus, the very premise of the impugned order and deemed decree is erroneous in law. Accordingly, FAT 419 of 2024 is allowed on contest, thereby setting aside the impugned deemed decree dated December 3, 2024, passed by the learned judge, 10th bench, City Civil Court at Calcutta, in title suit number 249 of 2024, and restoring the said suit to its original file and number. The learned trial judge shall now proceed to dispose of the suit on its merit and in accordance with law. We make it clear that we have not touched on the merits of the contentions of the parties in the suit, and it will be open to the learned trial judge to decide all questions independently and in accordance with law without being unduly influenced by any of the observations made above. There will be no orders to cost.
Not only one, it's not niece, it's granddaughter.
We have not stated that. We have left that.
I am saying on behalf of the corporation, but I am not a necessary party. Your lordship's last order that was indicated.
Some direction for expeditious trial.
Suit of?
Since suit, my lord, it's
which year?
Suit initiated
Forget
2020.
Forget it.
Without unnecessary adjournment, at least not a time bound direction.
Courts are too hard pressed. Convince Mr. Chatterjee on that outside the.
That's why
the ground realities, both of you.
That's why I did not indicate.
We understand it, Mr.
Please.
Thank you. Thank you. Yes.
My lord, I am for the respondent in item number 10, my lord. And 9 I have not received, my lord, the copy of this. Since
there's no caveat, my lord.
Yes. What is the matter?
9 he has no audience, 10 he will have an audience.
This is at the order 41 stage or hearing stage?
My lord, order 41. My lord, refusal of grant of interim order. Your lordship will remember in item number 10, my lord, your lordship has passed an order of stay with regard to, my lord, a purported notice. Now, similarly, my lord, in item number 10, lordship had granted us leave to file a supplementary affidavit to bring on record the subsequent events. Now, apropos that, my lord, we had filed an amended plaint. The amended plaint was filed and a fresh injunction application was moved to not to give effect to a notice dated 10th of June 2025. Now, my lord, prior to, my lord, placing anything, my lord, lordship will kindly first have a look at Rule 4B, that is page 98 of the concerned rules.
No. What is the nature? Just give us the background.
I'll tell you.
Suit is for what?
The suit is for declaration. Your lordship will find the amended plaint at page 53 and page 64 are the prayers, my lord.
By 53 and 64?
53 it starts, my lord.
No, 64 will do.
64
We're just on the prayers.
Yes.
What is the nature of injunction you have sought? This in line with 2?
Yes.
What is the allegation against the resolution?
Lord, I say that today the allegation is, that is why I said your lordship will kindly consider
98, very
Rule 4B. Because Lord, Rule 4B clearly stipulates, my lord, kindly.
Yes, 4B.
Yes, kindly have a look at, my lord, page 98.
We are there. Lifetime of executive committee.
Yes. The lifetime of the executive committee shall ordinarily be of 2 years from the date of its installation, but shall not exceed 3 years by any means. So, my lord, post this, the authority is defunct of any powers to, my lord, issue any notice.
They have crossed 3 years.
Yes. Now, my lord, the admission on their part, your lordship will find, is at page 47. That the CAC was formed on 15th of May 2022.
They filed a written statement or written objection to your.
No, they have not filed anything. It's still in the ad interim stage, my lord.
Page?
My lord, page 47 of this application, my lord, your lordship will find. The admitted position, my lord, they also admit.
Acha. Unable to hold GPM.
The very first paragraph, my lord.
Yes.
Council was held on 15th of May 2022 at Dr. Ambedkar National Center.
Right.
So, my lord, if we take at best 3 years, then 15th of May 2025, the committee has expired. So now, my lord, kindly sees the impugned notice. Page 49. Lord, now kindly comes to page 49. This is a notice dated 10th of June 2025. That is the after the period has already expired.
So what should be done? This body will be in limbo without a body. Somebody has to call an election.
Now, my lord, kindly comes to the
Rules.
agendas. Now, why I am placing.
What is the provision in the rules for this? If they overstep, they will have to only call the election.
Yes, they will have to call, but there perhaps with the deepest of respect, I submit there has to be an intervention of the court as well.
Why do you say that?
Straight jacket, my lord, they cannot. Because
but somebody has to, under the law, somebody has to. All court does not feel in.
I'll show the rules.
Shows that provision.
Because, my lord, you kindly lordship have a look at first the notice. Who has issued it?
Yes.
It is the president.
President, yes.
President.
Of a defunct body, you are saying.
Of a defunct body. Now.
Is there any scope of administrator or something like that in the rules?
Not particularly. That is why, my lord, I say the court has to interpret. But what are the agendas, my lord? Kindly have a look at it.
Yes.
Why I am aggrieved? The first agenda.
Show us.
As per Rule 4.1 of the bylaws of the council, to fill up the vacancies in the CEC by way of co-option and not by way of election. There lies the difficulty, my lord.
Co-option is also one of the.
But not by way of election. Because
so co-option is also
called.
Co-option is one of the recognized methods in the rules.
Rules. That is there.
But by a valid body.
But by a valid body.
So co-option is at their choice. It will be selection.
Yes, they will select their own candidates. There will be no election.
You see, unless there is an election, at least with the intervention of the court.
I am beseeching your lordship for the court to call an election by way of an administrator. That will cut short everything. The suit goes, everything goes.
What do you say?
My lord, I concede to the submission of my learned friend, my lord.
Expired.
However, my lord, previously, my lord, the executive committee continues for 4.5 years, my lord. That is matter of record, my lord. That is matter of.
Two wrongs don't make a right.
My lord. For that reason, my lord, I am saying this thing. And my lord, the fact remains, my lord, the general secretary has been restrained by the order of the court, my lord, at the behest of some of the members, my lord, instituted a suit, my lord, before the London City Civil Court, my lord, and there is one injunction order.
Secretary means the present appellant.
No.
Item number 10, my lord, is talking about.
I am on item number 10, my lord. Why this, my lord?
Item number 10 is against what? Same.
No, it's in earlier notice.
Similar, my lord. Earlier notice, my lord, that is impugned in that suit, my lord.
So
now
two suits, two appeals.
Two appeals, my lord. Now, my lord, what
argument will be the same? Let us see.
I have a single suit, two injunction application, two refusals without application of mine.
As the same, both arise from one suit.
Yes.
First injunction regarding first notice, second injunction regarding second.
Single suit.
Yes.
Here, my lord, single suit, my lord. Two different orders, my lord. Initially, my
two
lord,
different notices, two different injunctions, two different orders.
Yes.
But arguments will be same. What is your
My
argument?
lord, because my lord, pursuant to my lord's direction, my lord,
Yes.
there is a order of injunction, my lord. We have decided not to proceed with the previous notice, my lord.
Fair enough.
That is there in this also.
In 10, my lord. In item number 10, my lord. In respect of item number
10 is from the same suit.
Same suit.
But you issue another notice.
We have issued, my lord, another notice, my lord.
So you will go on issuing notices, we will go on
And
saying.
yes, my lord.
This will go on. Give a solution.
Yes, my lord. For that reason, my lord, kindly appoint administrator, my lord, who will, my lord, take.
Choose an administrator. Choose an administrator, both of you.
Yes, my lord. Another thing, my
Will
lord.
appoint both of your advocates on record as
whether,
suffice, my lord.
my lord, whether the suit is my preliminary point, my lord, the suit is not maintainable.
Why do you say
because
that? Internal.
The person, my lord, who has filed this suit, my lord, has not sought for, my lord, relief under order 1 rule 8, my lord. He is espousing cause of others members of the council, my lord.
Anybody aggrieved, any member aggrieved can take up.
But it is not his individual right, my lord. My lord, kindly consider that.
Every individual member has a right independently also. Why not?
My lord,
To point out irregularities before the court.
yes, my lord. That my lord.
Not in his capacity. He is not representing anybody.
There is a stalemate condition, my lord.
He is a member that's admitted.
That is
But he's also a member of the defunct.
Member of allegedly defunct my lord committee. It is not my lord defunct.
Is he an alleged member of the alleged defunct committee or a member of the alleged
Member
defunct?
of the body, my lord,
Body.
council of the, but not.
So he is valid.
He's.
But you are invalid.
I am
As we
not
both will
invalid,
agree
my
to
lord,
this?
because
Don't
my lord,
interject
because
into
of
it.
the, my lord, what I am submitting before your lordship, my lord, there is a suit filed by another person's, my lord, and
Forget about that. That will become infectious.
Sir, my lord, the general secretary has been restrained to operate the bank account as well as to give effect, my lord. Before expiry of 3 years, there was a resolution, my lord, to hold a general body meeting on 23rd February, my lord. That has been stayed.
General
And
secretary has been restrained from doing what exactly?
from my lord giving effect to the notice for holding my lord general body meeting on 23rd May, as well as my
General
lord to
secretary will
operate
not
the-
do that.
My-
Administrator will not do it, as you said.
Administrator, my lord, it is required, my lord, because unless my lord the bank is
my point.
operated, my
Who
lord.
should be an administrator? Tell us.
My lord, I leave it up to your lordship.
Both the advocate of records, my lord, so that the fairness remains.
My
Both the
lord,
advocate.
some third party.
One of the advocates on record is shying away.
My lord, I leave it up to your lordship. My lord,
Your lordship
my
appoints
lord, kindly
anybody.
appoint somebody who will look after each and every. Will be
Where is
But
expert
we want to
this.
proceed with the election. We want a fair election and fair governing
For
body.
that reason, my lord, this
Not any
notice
co-option
in
or any
accordance,
other option.
if my lord holds this is a defunct committee, my lord, then I have no case, my lord. Otherwise, my lord, if my lord consider the merit of that impugned notice, subsequent notice, which is subject matter of item number 9, my lord, then my lord, I can show to your lordship, my lord, that is a valid notice, my lord.
Why?
Because my lord, if my lord kindly consider, my lord, the rules once, my lord, that is 77, 78
Yes.
page, my lord.
Yes.
My lord, kindly take up the item number 10 matter, my lord, because
Refer to the rule numbers so that we can
rule is there, my lord. That is, my lord,
refer to the rule number.
rule 6,
Rule 6. All right.
rule 6, 3, Roman 3, my lord.
Yes.
4, Roman 4, rule 4, B, my lord, small b.
Roman 4, small b, yes.
My lord, in absence of general secretary, the executive committee shall elect any one assistant general secretary as the general secretary. My lord, in absence, according to them, my lord, since the tenure has expired, my lord, there is no committee, no valid committee according to them, my lord.
So the
But
executive
somebody has
committee
to
which
take the
will
call. Somebody has to take the call, my lord.
executive committee shall elect. There is no executive committee in the eye of law. That is the difficult.
That is the, my lord, since we are functioning, my lord.
We can
consider-
appoint an administrator and we'll request the existing body and all the members to cooperate with that administrator.
And lordship will fix a date for the election because election.
So
is
that,
something
within a
which
time
has
we'll
to be done.
fix a
My
time
lord,
span.
Otherwise, the
that
body
it
will
is
not be
fixed on
constituted.
12th, my lord. All the members from different parts of the
That is
countries
the
are
scope of
coming.
my suit and
my
appeal.
lord. And if my lord holds primary
12th of what?
12th
This month.
Yes, my lord.
That is
Which
what
is
I'm
subject
saying.
matter
That
of
cannot be
challenging
done.
item
Because
number
then
9,
these
my lord.
agendas will come.
Well, please, if you interject, we can't hear it.
I'm sorry.
Please take your seat.
My lord, 12th July, my lord, which
Yes.
they have challenged, my lord, before the court bill, and which
12th June,
12th July, my
by 12th July, by dint of your notice, they are
notice,
coming.
my lord. There is, my lord,
Notice itself is invalid. How can we permit that
prima
to?
facie is holding that the committee is defunct committee. And my lord,
The notice
by-
is also bad because the executive
but
committee
my
cannot.
lord, by that time, before expiration of that tenure, my lord, 2 meetings were called for, and 2 were stayed by one by your lordships, my lord.
So what?
And previously on.
So we are consistent on staying your illegal notices.
My lord, in that event, my lord, there will be.
You don't issue one single further notice because you are defunct.
If that authority
You
has
are
not been
defunct
challenged
by the
in
rules.
that authority has not been challenged, my lord. For the first time, I don't know, my lord, what is challenged under item number 9, my lord, but 10, my lord, that authority has not been challenged, my lord. Only thing they have stated.
10 is
that
a
since
10 is
the
the same suit.
same
In the suit itself,
yes,
they
my
have
lord.
challenged.
In that case, they have not challenged the authority of the committee, my lord, present committee, my lord.
Let us come to the
I have challenged. I'm sorry
the
to
prayer
interject.
portion.
Show where you have challenged. Only they have stated, my
Please
lord,
come to page
since
64.
the general secretary has already retired, my lord, he has no locus, my lord, to remain as assistant general secretary, my lord. However, there is a provision, my lord, for appointment of general secretary from the 12th assistant general secretary, my lord. And this can be done by way of this, my lord.
You
General
please
Counsel.
come to page 65.
65.
Have you got a copy of the
This
plaint?
one, no,
Plaint you must have.
Plain must
So
have.
come to the prayer portion of the plaint, internal page 13 of the plaint. Internal page 13, 1B, IB.
This is a decree for declaration that the alleged notice dated 25th.
No,
But he
IB
does
is not
have it,
notice.
I'll hand over. At that
My lord,
moment,
this is
I'll just ask my lord.
IB.
IB, my lord.
decree of declaration, the central is formed.
Specific declaration.
My lord,
Therefore, that is there, that subsumes the other reliefs.
that is subject matter of trial, my lord. My lord, what I'm humbly submitting before your lordship, my lord, that is subject matter.
Why
After holding
take
a
these
trial-
technical points? Let
Let
the
me-
entire matter be over. You won't have to litigate on and on.
Because since the bank operation is prohibited, my lord, therefore everything is in stalemate condition. For
General Secretary, bank operation is prohibited by the General Secretary.
General Secretary. Now the treasurer, my lord, he has filed a suit. He is a party to one
Maybe.
suit, my lord. President has the capacity, my lord, to call for the meeting, my lord. My lord, kindly,
President of a valid body.
my lord is prima facie.
You are admitting that it has
Time has expired. my
term
lord.
has
I cannot
expired.
improve.
The rules are admitted.
But
What
I
remains
cannot
in
improve
the
that, my lord. But still such time, my lord, there might be some arrangement, my lord. It cannot be, my lord, without any person.
It is not there in the rules. We specifically asked both of you to show us the rules. Is there any provision? There is no
Therefore, my
provision in
lord,
the rule.
after expiry of 14th May, my lord, of 2025,
Yes.
there
There is nothing in the rules. In the interregnum, what will happen if you don't call that?
my lord, for that reason, this is there, my lord.
What is there?
This notice is there for holding, my lord, meeting on.
Precisely. Who is issuing that notice?
The president of previous. Otherwise, there will be no other person, my lord. Since rules doesn't provide for any other alternative arrangement in the meantime, my lord, only the person remain who is entitled to call for who has right to call for the meeting, my lord.
You are asking you are seeking a co-option. How can you co-opt? Co-option is selection.
My lord, we can strike down that for the purpose. We can change the, my lord, with instruction, my lord, I can come back.
We can do this, no, because
May I humbly submit?
we are saying this, answer to that first, that the present General Secretary who is there, who has been acting till these 3 years, under the aegis of the administrators, they will be conducting an election. A general body meeting and election.
Sir, today there is no general secretary at all.
Got already retired.
He has already retired from service.
Administrator, without the help of the present office bearer, he won't get access to anything.
The acting president, so-called acting president, who has
All
been
the
acting
records,
illegally.
all the audit
The
reports,
moment an
everything is lying
administrator
with
is
Who has
the
issued the
committee, my
notice? Who has issued the notice?
President, my lord.
President.
President of the committee, my lord.
Then the president will hold the meeting.
Yes, my lord.
Very well.
Yes,
President
my
will
lord.
hold an
Except
election.
The administrator, the election.
Election has to be done by a general body meeting.
Yes, my lord.
I'll show the laws, my lord.
Very well. We'll frame a timeline. We'll frame a timeline within which we'll appoint administrator.
My lord.
A timeline within which the administrator shall conduct the election through the president.
Through the president.
The erstwhile president and
My lord.
the present the last office bearers, everybody will cooperate.
Yes, ma'am.
But the administrator has to be a bit senior person then.
My lord.
A bit
Otherwise,
senior.
somebody who don't
Who
know
would be able to control your
yes,
people.
control over the
And these are bank employees, they are senior people.
Yes, my lord.
It has to be a bit more senior. Suggest somebody senior's name, some senior's name.
Anybody your lordship chooses, my lord.
No, we don't know. I mean, somebody who, I mean,
No, somebody who can devote time. That is the most important thing.
Yes.
Otherwise, seniors,
Yes.
lordship knows.
some senior who can devote time.
Some
You can
senior who can devote time.
find out. Will
May I suggest the name of Mr. Owen Banerjee, my lord, in that event?
So Anbanj will be fine. I don't think.
Banerjee will be fine, but Owen Banerjee will be able
Yes,
to
but
devote
be
time on
busy,
time
my
or
lord.
not.
Even
Yes,
then he
Very
can.
busy.
He engages
he's
some
busy.
matters, my lord. That I
Very
know, my
busy. Very busy.
in some banking matters, my lord, I know.
Senior, not busy.
Participate.
Very difficult.
Yeah.
That's what I say, my lord. Senior, but who is efficient, but is not busy.
So find out a name.
কাকে বলো না, কাকে দেওয়া যায়?
All seniors are busy, of course. I mean, but
Somebody who, my lord, understands this banking.
that will be held in on a holiday. Mr. Banerjee can do it. I mean,
Yes, my
His
lord.
lordship
And
will
in some matters, I personally know, my lord, he engaged by the honorable
should he appoint joint administrator,
That
or
is
one administrator will do because the president will help?
My lord, the only
It is
living
all over India, my lord. probably two persons.
Two persons should be easier. There would be many things to
Yes, my lord. To organize all.
give two names.
Yes,
Suggest
my
two names. We'll keep it. We'll pass an order, and we'll just keep it for.
From our side, my lord, I am suggesting Mr. Banerjee's name and
Give
Mr.
somebody of
Banerjee
somewhat parallel seniority. Otherwise, one is too senior, one is that won't.
contemporary.
You can't find of anyone. Think of a name.
I was
Mr.
thinking of a name, but he said no.
Mr. Parthakutim Roy with Mr. Owen Banerjee.
Yes, why not?
He said no. What was the
If he says no, we'll appoint him. All the more. No, do you want somebody from the original side, somebody from the appellate side?
No,
Do you have
not
any
because of
such?
that, my lord. The busyness of both the advocates. I know Mr.
Parthakutim Roy,
Banerjee and Mr.
Owen Banerjee,
Banerjee,
both are equally.
both should be, my lord.
The names which are coming in our mind, both from the appellate and original side, they are all busy, very busy.
Very busy. At least that.
What should be the remuneration?
That is the issue, my lord.
Issue both of you will have to pay.
Yes, that is the issue.
Both of you have to share.
Huh? That is the only difficulty. That instructions we have to take.
That my lords decide, my
Because
lord.
Acha, order to record karo. Both the appeals are together for admission hearing. First up, next para. The appeals arise out of single suit filed by the appellant. Full stop. The appellant is admittedly a member of the All India Indian Bank SC/ST Employees Welfare Council. Full stop. Next para. The grievance in the suit is primarily that the present executive committee, on whose behalf the president has issued the impugned notices for holding general body meeting, is defunct in the light of Rule 4 within bracket small b of the rules and regulations of the said council, full stop. Rule 4 within bracket small b provides that the lifetime of the executive committee সব জায়গায় caps হবে, shall ordinarily be 2 years from the date of its installation, তারপর italics এ বাকিটা, but shall not exceed 3 years by any means. Full stop. It is seen from the records, seen from the materials available before us, that it is an admitted position that the present council, present executive committee was elected on May 15, 2022, and as such, the outer limit of 3 years elapsed on May 14, 2025. Full stop. Hence, prima facie, the committee is indeed defunct. Full stop. Next para, learned counsel appearing for which of the respondents you are appearing?
My lord, I am appealing for all the respondents.
All the respondents must be. Appearing for the respondents submits.
My lord, one, my lord.
One.
President,
Respondent number 1 submits. Yes, President, there will be other difficulties. Respondent number 1 submits. Respondent number 1 hyphen counsel submits that there are other pending suits, in which the General Secretary of the Executive Committee has been restrained from operating, inter alia, the bank accounts of the Council. Full stop. Next para. On a careful scrutiny, since arguable questions of law and fact are involved, we admit both the appeals to be heard on the grounds taken in the memoranda thereof. Full stop. Next para. The conundrum which has arisen is due to a vacuum in the rules and regulations of the council as regards what would be the position if the executive committee exhausts its outer tenure of 3 years. Full stop. Next para. Since, as per Rule 4 within bracket small b, such a committee becomes automatically defunct by operation of the said rule, the functioning of the council is at present in limbo. Full stop. Since nature abhors ABHORS, a vacuum, the council apostrophe is functioning cannot come to a stalemate. Full stop. As such, upon hearing learned counsel for both the parties, comma, we are of the view that that independent administrators ought to be appointed, comma, under whose aegis the present president of the executive committee of the erstwhile executive committee can hold fresh general elections of the council. Full stop. Next para.
Lord, may I only indicate one thing? Your Lordship will kindly consider Rule 5. The method has been specified of elections. So today, my Lord, all powers were vested on the Central Executive Committee to appoint an election commissioner. So in effect, my Lord, to the administrators, my Lord, can perform that. Because since there is no Central Executive Committee, that will be apropos the rules, my Lord. First, a general body meeting will be held. A date will be fixed by the joint.
That is Oshios, because they are the Central Executive Committee is no longer there.
Yes, but my Lord, assuming, my Lord, the power.
No, we'll say that the administrators, the election will be held in terms of the rules.
In terms of the rules.
Generally, we'll say in terms of the rules, all the rules will apply.
Yes,
whatever is are the rules
the
for
method
election.
is specified, my Lord, of the election.
All methods, yes. Next para. On the suggestion of learned counsel for the parties, comma, we hereby appoint Mr. Who is senior, Parthopratim or
Mr. Roy is senior.
Mr. Parthopratim Roy. Has Mr. Roy been designated? No.
No.
Mr. Banerjee has been designated.
Both of
None of
Acha.
them.
Mr. Parthopratim Roy and Mr. Oyon Banerjee, comma, learned advocates practicing in this court, comma, as joint administrators to hold the election of the respond number 1 council with the assistance of the president of the erstwhile executive committee of the said council. Full stop. Next para. It is made clear that all arrangements for the said elections shall be made by the president, comma, in consultation with the erstwhile committee members, comma, strictly in accordance with the rules and regulations of the respond number 1 council under the aegis of the joint administrators. Full stop. Next para. It is made clear that prior sanction shall be taken from the joint administrators for all activities for the purpose of holding such elections. Full stop. It is expected that the said elections shall be held
in Kolkata. In Kolkata, because my Lord, I'm being told the registered office is in Kolkata. The difficulty is that a group of members want Hyderabad, group of members want.
administrators will decide that.
Administrators
Hold within an outer limit of what will be a reasonable outer limit. It has to go to 3 months within.
The rules even says so.
Yeah.
The rules also says 3 months prior to.
Oh, it says 3 months.
3 months notice, my lord. In
3 months
case of
notice.
my
So,
lord.
So then it has to be more than that.
My lord, 3 months. Otherwise, my lord.
Within 3 months from date. Full stop. Next para. For the purpose of holding the elections, comma, the rules and regulations of the council shall be strictly adhered to. Full stop. It will be open to the joint administrators, comma, under the aegis of whom the election shall be held, comma, to select the venue as well as the other important modalities of the election, comma, in consultation with the president of the erstwhile executive committee. Full stop. The decision of the joint administrators shall be final in that regard. Full stop. Next para. The remuneration for each of the joint administrators is hereby fixed at what should be it?
that is the most difficult.
Should be in lakhs. All over India, this is happening.
Lord, that is why, my Lord, I was suggesting that he should be in Kolkata because both the lawyers are from
No,
Kolkata.
you can
and
make
that
that
is-
submission before the administrator also.
They will consider and they
So
will decide.
2 lakh each. Rupees 2 lakh
Because
each. Full stop. Such remuneration shall be borne by the
from the funds of the, my Lord, because otherwise what happens?
And that is not operative, my lord. Now, nobody can operate. Only
Yes, post-election, my lord, the new committee will be
No,
formed.
no, no.
Before
What
that,
will
my lord,
happen?
it is
Otherwise,
required,
my
my
client,
To be reimbursed from the funds. Borne by the parties in equal share for the present, full stop, such expenses shall, comma, upon the election of the new committee, comma, be reimbursed from the funds of the council to the parties. Full stop, such remuneration shall be paid to the joint administrators within.
my lord, if I make one submission, my lord, he says that, my lord, nobody can operate the funds today. But if, my lord,
No, 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 no.
court
No,
grants
no, no, no. You'll have to pay
for the
no.
purpose of this
No.
paying the administrators.
Within a fortnight from date.
So otherwise, what happens? My lord, the burden will be on a single person, my lord, who is the appellant.
Not
Then,
single
my lord,
person.
then that power, it is, my lord,
Both of
their call, my lord.
Yes, because otherwise, my lord,
Single
president,
person, yes. You are challenging. You are the
Yes,
single person.
my lord, if it can be, my lord,
No, for the time being, no.
That-
Sorry.
They
No
have
compromise on
obtained,
that.
my lord, the injunction order.
It cannot be held up for that. So, next para. So we are disposing of the appeals. For what is the use of?
Yes, my
my
lord.
lord, 2 lakhs may be paid in tranches, my lord, because
No.
in one go, my lord,
One go.
My lord, both of them are
No.
easy, my lord.
No.
that would be a
The
practical difficulty, my lord, I am saying, my lord.
no.
Otherwise,
They
my lord,
have
what
money
happens?
for, my
My
lord,
lord,
to
I'll tell your
institute-
lordship what happens if we
to
do not.
file
If somebody
appeal, my
fails
lord,
to
before
pay,
the
my lord,
Honorable
this
High Court.
entire exercise fails.
Fails. Yes.
Then again we are at a deadlock. That is
Yes.
my appeal.
You are at a loss. No. No.
They have filed 2 suits, they have filed
No,
2
that is a-
appeals in spite of.
That is not a reason, my lord. I have
No
filed
question, sir. Then we will recall our order.
saying that, my lord.
We are not here to bargain on the remuneration of the special officers. Definitely not. Either you take it or leave it. We are recalling our order. Then you don't get an order.
I'm not saying-
2 lakh is nothing for this job.
I know.
All over India, the elections will be held. And you are bargaining for this 2 lakh. Don't pay, don't get the order.
They pay.
Ridiculous arguments, Mr. Chaudhary. Unexpected. You are going on bargaining at the instigation of a junior. Then we'll recall our order. We'll record that. After passing the order, you say that you cannot pay. And we'll recall our order. You're getting an order which you have not even expected in the suit. What sort of nonsense is this? The remuneration of the administrators, they were bargaining on that. The time. They will wait with a begging bowl for the funds to be released by the council.
Sorry.
These are senior advocates of this court. Then you just recall the order. You don't have any minimum idea of the dignity of officers of the court. That is very evident, Mr. Chaudhary. Yes. In view of the above order, comma, no useful purpose would be served in keeping the appeals pending. So accordingly, FMAT duto number দিয়ে দিও are disposed of by modifying the orders impugned therein to the above effect. No rest to cost. Can such and such are disposed of accordingly.
Extremely
Next.
grateful.
Thank you.
I'm sorry, my lord.
For it. Leaves a very bad taste.
Lord,
in
I, my lord, I tender
very,
my
very
apology, my lord.
cheap and mean mentality, Mr. Very cheap and mean mentality.
Lord, the
Please call on
decision-
the next matter.
I am only submitting on instruction. That is why, my lord.
You don't do whatever. If you are asked to, you are driving a car. You are asked to
Lord, I
hit a lamppost. You'll do that. The steering is in your hands. You are the advocate. You are the counsel. You will advise your clients. You are the creature of
I know.
instructions, not the servant of
I know
instructions.
the advocacy-
You are officers of the court.
I'm very sorry.
First, you are officers of the court. Last, you are officers of the court. You act on instructions. Yes, you are paid by the client. Yes. But you don't bargain on the remuneration of these special officers. That is not done in the court
I'm
of
very
law,
sorry.
particularly in the highest court of a state, whichever judge it may be. No, it's not done, Mr. Chair.
I'm
You
very
don't
sorry.
accept this.
I'm very sorry, my lord.
Yes, next one. This is item 11. 11, who is appearing?
I'm appearing for the respondent, my lord, in this matter.
Yes, yes.
May it please your lordship, my lord.
Yes, yes, right, Mr. Banerjee.
My lord, this is my appeal,
Yes,
my lord, from a decree of divorce
right.
passed in favor of the husband who was the petitioner before the trial court.
This is a legal that matter. Yes.
So one of the legal aid matters, my lord.
Pardon?
One of the legal aid matters, not that matter where the
Oh, not
lady-
that matter.
Not
Not
that one.
Ah,
Not
sir,
that one.
different. Very-
That has not yet come up again. But
Right.
one small request, my lord, embarrassing for me, before I start, kindly, my lord, permit me to take leave at 3:55 p.m. if possible, my lord.
3:50, some difficulty?
I have a train at 4:50. That is the only reason.
Would you like to start today? You can.
I leave it till I can continue. In case I don't finish, my lord.
Is it a longish matter? Appeal is long.
Appeal is long, yes. It's an 86-page judgment also.
Yes, Mr. Banerjee, what do you say? Should we start it and leave it? So then
yes, sir, because in any case, it will take some time to hear your lordship. So what I feel is let him complete to the extent he can, and then
no,
we can.
that will be difficult, Mr. Banerjee, because he has 50 minutes. So no useful purpose will be served. If we can take up a smaller appeal, we'll take up other matter.
And then I leave it to your lordship. But then
in view
every
of
time this matter, we could not get it heard. We
Yes.
stayed for we stayed for.
No, this is the first hearing matter. So
Yes, sir.
what is the
lordship,
matter about? What is your ground of challenge?
The decree has been granted, my lord, primarily on the ground, or rather only on the ground of irretrievable breakdown of marriage.
Only on that.
The case was tried to made out, my lord, by the petitioner of desertion and cruelty. But in my humble...
That's now a valid ground after Justice Dhulia's judgment. Have you brought all the judgments?
Yes, I've got some of the judgments, yes.
Some won't do.
The Justice Dhulia judgment. I do not...
That's the Dhulia judgment you have?
Yes, I'm aware of that. I do not have that right now.
But that refers to the previous one.
Yes. So
You have that judgment?
Not right now, my lord. I'm aware of that judgment, but I do not have it.
You have the citation?
Yes, yes.
So you can start with that. Why is it not a valid ground?
Well, that is one of the grounds, my lord. There are various other grounds also, my lord, of desertion and cruelty, my lord, which in my humble submission, my lord, the petitioner on the basis of his evidence has failed to prove the same.
Very will come back on a later date. Let us take. On the prayer of learned counsel. On the prayer of learned counsel for the appellant, let the matter stand adjourned for the day.
Grateful, my lord.
But lordship, unless this matter is fixed a particular date, every time lordship.
It's the first matter in the hearing list, Mr. Banerjee. You make us tired with these ridiculous submissions. Yes. Call on the next matter.
This is fixed and Jordan.
Maybe. Next. Yes.
Lordship. Your Lordship, I appear on behalf of IOCL in this matter, Your Lordship. On the last occasion, Your Lordship had directed us to deposit an amount of 4,82,500, Your Lordship. We have complied to the same. May I hand over the receipt, Your Lordship?
Start the matter, ma'am. We
Your
are
Lordship.
at the hearing stage.
I'm led by Mr. Nag, Your Lordship. I'm also praying for not this week. Your Lordship.
Start the matter. Some matters have to be
Your
started.
Lordship kindly fixes a date, Your Lordship, for...
What is the matter about? You have to know about the basic facts.
Your Lordship, on the last occasion, the can was heard, Your Lordship. And Your Lordship said...
Ma'am, if you are in our court, if you ask for an adjournment, you have to be posted with the basic facts. So you have to start the matter.
Your Lordship kindly passes
it over. You have to know the basic rudiments of the matter.
Your Lordship can kindly passes it over, Your Lordship.
We're passing it over for 10 minutes.
Your Lordship, Your Lordship.
Pass over for 10 minutes. Next. আধা খাঁচিটা শুরু করি আর পাঠাটা আমি জমাতে পারছি না 50 মিনিট পরে টাইম Yes, sorry. Please start.
Lord, and for the appellant.
Lord, I appear for the pro forma respondent.
Pro forma respondent, very well.
Lord, I'm led by Mr. Shakoshan.
Lord, the resolution professional, Lord, Your Lordship remembers Your Lordship's transferred me to being a pro forma respondent now.
Right. So you just watch and have the fun.
Lord,
no, Lord, Your Lordship will remember I told Your Lordships this appeal has become infructuous, practically academic, because advanced stage of insolvency is going on when they themselves, Lord, have filed given a resolution plan acknowledging all the claim of all the banks together and admitted their entire liability towards the banks and gave a resolution plan. So this has become academic, Lord. Your Lordship said perhaps wanted to still hear Mr. Sen. And importantly, Your Lordship will remember the...
Lord, I'm the appellant.
Yes, Mr. Banerjee, let them submit on that. You use the microphone properly, otherwise he won't be able to hear.
Lord,
yes.
May I just start the case, Lord? I'm led by Mr. Shakoshan. He's on his way. Lord, may I start?
No, you have to answer the question first.
Lord,
Why shouldn't we hold it to be infructuous?
Lord, that issue perhaps is completely different, Your Lordship. May I just first place it, my Lord, then I'll address whatever has fallen from my learned friend.
No, but if you have submitted a resolution plan, I mean, if you have, if it's for considered on the, this is also one of the claims you have against the company.
আমরা submit করেছি, that was not confirmed by the COC. COC has not approved the
Lord, on instruction, my Lord, I'm submitting, my Lord, that resolution plan perhaps has not been accepted by the COC, Your Lordship.
And they have to.
My Lord, may I say this? May I say this, my Lord, with Your Lordship's leave? If Your Lordship only allow me.
Yes.
My learned colleague has a copy of the resolution plan submitted by the promoters, by the appellant's hearing. Your Lordship knows he participated in the entire process. My learned colleague will hand up a copy of the resolution plan. That was voted upon. That was voted upon. Since his commercials were low, COC in its commercial was rejected.
Mr. Banerjee, these very appellants had filed that application.
Correct. Same, my Lord, resolution plan. My colleague over there will hand up a copy of the resolution plan to Your Lordship, my Lord.
My Lord, kindly for once, my Lord, kindly
Your
cease.
colleague over here doesn't have any copy whatsoever.
My Lord, I'm then very sorry, my Lord. What I'll do is, my Lord, would Your Lordships keep it tomorrow then in that case, my Lord? I will get a copy of the resolution plan and come before Your Lordship.
First.
My Lord, for one moment, my Lord.
Don't start that. We don't want to waste time. We want to answer on that first. You have to have a look at that plan also.
My Lord, may I just for once, Your Lordship, my primary prayer is against the OL, Your Lordship. It's a damage suit. My Lord, kindly sees the prayer in the plaint, Your Lordship. Kindly takes page 20.
The claim against the OL is a claim by the company on behalf of the company.
My Lord, that has
You are
been
not
amended.
doing it in your individual capacity.
Lordship, as a capacity of a guarantor, my Lord, I had instituted this suit, Your Lordship. If my Lord recalls, my Lord, at the time of
the CIRP is going on against in respect of the same company.
is the company, my Lord.
So you are at the behest of the company as well as a guarantor. You are
At present, my Lord, not perhaps at the behest of the company, my Lord, at the capacity of a guarantor.
Start it.
My Lord.
And you'll address that point also.
Lordship. My Lord, if my Lord kindly takes up, my Lord, paragraph 18, Your Lordship. My Lord, here starts my cause of action. If my Lord recalls, Your Lordship, this company, this very company, my Lord, who has been a pro forma despondent by virtue of my Lord's order, Your Lordship, this company went into liquidation by virtue of several orders passed by
Can
this
you
court.
come a bit closer to the microphone?
Lord,
Yes.
my Lord, that order of winding up, Your Lordship,
Yes.
was kept in abeyance, subject to fulfilling certain conditions. Now, my Lord, in 2016, my Lord, a division bench of this honorable court, my Lord, passed an order saying that if you fulfill this XYZ conditions, the order will be kept at abeyance. My Lord, kindly now takes up page 9, paragraph 18, my Lord.
You are there.
My Lord, here starts my cause of action. My Lord, at the time when the possession was with the official liquidator, my Lord, and the time when we got back the possession, we saw, my Lord, a large scale of theft has taken place. That's the, my Lord, my case in sum and substance. Now, my Lord, if kindly, my Lord, takes page 84, the impugned order.
Yes.
My Lord, the rejection of my plaint was on two grounds, essentially. One, my Lord, the defendants therein filed Order 7, Rule 11, saying that the suit is barred under Section 34 of SARFAESI Act. Second, my Lord, Section 80 notice has not been served since one of the defendants were official liquidator. Now, my Lord, keeping that in mind, my Lord, kindly seize the order. May I just start?
Yes.
My lord, I'm just starting from. My lord, the last paragraph I'm starting from. After filing of the suit, notices were duly served upon the defendants, and the defendant number 1 filed his written statement on such and such date, whereas defendant number 2 to 4, who are the secured creditors, filed a written statement on such and such date by denying all the allegations raised against them. The record revealed that before filing their respective written statements, the defendant number 2 to 4 filed a petition under Order 7, Rule 11, read with Section 151 CPC and also under provisions of SARFAESI Act on such and such date for rejection of the plaint of the suit. Similarly, on such and such date, the defendant number 1 filed another petition of Order 7, Rule 11, read with Section 151 for rejection of the plaint of the suit. Now, my lord, kindly takes up the next page. Page 85. In this petition dated 16th of July 2016, the defendant number 1, who is a public officer, alleged that prior to institute of this suit against him, no notice under Section 80 of the CPC was served upon him by the plaintiff, which was mandatory. Now, my lord, pausing here for a moment. In the written statement, my lord, none of the parties took this point. My lord, at least defendant
None of the parties
took this point. This service notice under Section 80, especially, my lord, the defendant number 1, who is the official liquidator.
Section 80 is a statutory mandate.
Lord,
If it
I'll-
can be shown from your
My lord, in
plaint
this-
that you have not asked for a leave, or
My lord, I'll come to that later, my lord.
it's a
That-
statutory mandate. Even if they don't take that point in the written statement, aren't you to show from the plaint at least that there is a pleading that you have complied with, or you seek a leave under Section 82?
Lord, what my case is, my lord, subject to what my senior will conclude, my lord, that
There so many subjects won't do. Subject to your senior, subject to the other side, and then subject to us, and then subject to my learned brother. No, you be firm on what you are submitting. Yes.
my lord, today, my lord, I am seeking modification or setting aside of this order to the extent, my lord, that it holds that this.
Do you say the official liquidator is not a public officer and Section
No,
80
my
is
lord,
not
I
applicable?
say that. I say.
Then how do you overcome that?
I say.
One is you say it's not taken in the written statement. What else?
Lord, I say it is a technical defect, my lord, and there is a subsequent application under Order 23, my lord, to withdraw the suit and file afresh on the self-same cause of action. My lord, let me just
Plaint was
proceed.
rightly rejected, and 711 does not debar you from filing a fresh suit.
No, my lord, may I just place.
Order 7 Rule 11 does not debar you from filing a fresh suit on the same cause of action by complying.
My lord, the order says contrary, your lordship. This particular order says contrary. May I just place it, my lord?
Don't place the entire order. What does it say to the contrary? Whatever the order says, the Order 7 Rule 11 is very clear. I mean, let us see once. Is there a bar to filing a fresh suit on the same cause of action?
Huh.
Unless it's on merits in some sense.
The lordship permits, my lord.
Yes, Mr. Sen.
But actually, my lord, there are.
Subject to her giving you permission.
No, lord, I was reluctant, my lord, to ask her because she was.
No, she was doing very well. No difficulty on that. No, but Rule 13 is there, Order 7 Rule 13.
Apart from that, my lord, your lordship says there are 2 grounds on which the Order 7 Rule 11 is. The other ground is
SARFAESI.
a more, yes, more.
That remains.
Yes, more substantial ground.
Deal with that. Yes.
So, my lord, my first point is to deal with the Section 34, whether this suit can be barred by the provisions of the SARFAESI Act or not, my lord. My lord, your lordship has been, your lordship has seen the plaint prayers.
No.
Oh, my lord. Kindly come to the prayers in the plaint, my lord.
At least today we have not seen. We have seen previously but forgot.
এইখান থেকে তোমাকে পেজ নাম্বারটা বলো আমার
Page 20.
মার্ক করা আছে এখানে kindly come to the
Page 20 of the paper.
it is essentially, my lord,
Money.
A decree for damages against official liquidator, and another prayer which is there.
Damages why? On what ground?
Because I am saying, my lord, during the period when the official liquidator was in possession of the property,
Yes.
there has been damage and destruction of this secured asset.
All right.
And by that, when he handed back possession to me, I have assessed this damage.
So reduce the valuation for which you could not meet the debt.
Yes. First is, I have suffered a damage in my, this is my asset.
Yes.
Value of the security has diminished.
Acha.
That is my principal prayer. Now, the third prayer in the suit, your lordship will see declaration, and to that extent, my lord, I am saying that my guarantees should be discharged to the extent of the diminution in the value of the securities. Declaration that the plaintiff number 2 and 3 stand discharge and absolve all guarantees, including the guarantees stated in paragraph 45 above. There has been, my lord, the securities, it was there in their custody. They were under an obligation to maintain and preserve the securities. They have allowed they have allowed the value of the securities to dissipate and diminish. To what extent I can claim or prove my damages, that's a different question. But insofar as the principal subject matter of the suit is concerned, this has no bearing. This is not a subject matter which I can raise before the appropriate forum under the Securitization Act. The Securitization Forum, where only the measures under Section 17, the validity of the measures under Section 17 will be gone into, they cannot assess my damages. Or if I
under Section 17, the infirmities in 13.4 procedure can be looked into. You are right on that, prima facie, yes.
And my lord, if that forum cannot go into my claim,
if this relief cannot be granted by that forum, then the bar does not apply. Section 34 is only dependent on Section 17 basically, and the other.
If I may just show you language once, my lord, the language of Section 34.
Whatever power can be exercised by the tribunal cannot be done by a civil court. This power cannot be exercised by the tribunal in the first place.
Yes.
And also no injunction can be granted. There is another component of Section 34, the second limb,
Yes.
that no injunction can be granted to frustrate basically a 13.4 proceeding.
These are my prime and second aspect. My lord,
This injunction, what about D? Relief D, page 21. Defense from...
This is under the bank guarantee. This has also nothing to do with, my lord, the proceedings under the Securitization Act.
Very well. And secondly, this is consequential, you may say.
Absolutely. I say first I have to prove my case of damages. If I succeed in proving my case of damages,
A is the principal relief, which cannot be granted by the tribunal. Very well. Yes.
Now, my lord, the other aspect of the matter is, my lord, if your lordship see
yes,
the reasoning of the trial court with regard to the bar under the Securitization Act. My lord, cardinal principle, my lord, only the plaint has to be considered. Averments in the plaint has to be looked into. But this aspect of the matter has been decided on the basis of the documents filed by the defendant. Your lordship will kindly see the impugned order, the relevant portion.
In your plaint, have you stated about any 13.4 proceeding?
No.
Yes.
Kindly come to page number 8. Internal page number 8 of the order. Page 91 of the paper.
And Mr. Shen, probably even if 13.4 has been initiated, now this does not preclude that proceeding from proceeding. I mean,
that is my first submission. That the reliefs claimed in the plaint are not governed.
There is no overlap between the...
Are not covered by provisions of the securitization bar contemplated under the Securitization Act.
Yes. And you'll also have to deal with Mr. Banerjee's point that in view of the CIRP you having applied there, this claim, we don't know whether this claim was there. or whether this claim could be there.
My lord, they have asked for the specific claim prayer for release of their personal guarantees, which my learned senior friend Mr. Sen is now showing as prayer C and D of the plaint. These are not bank guarantees. These are personal guarantees given by the appellant 2 and 3.
That is prayer C.
Towards
All
the
right.
banks.
Right.
To secure the debt of the company. The company was appellant 1, whom your lordship now has made it as pro forma respondent through the resolution professional.
Right.
I'm sorry,
right.
I didn't want to interrupt, but my lord, your lordship wanted
No, no, no.
to
It's,
ask.
it's all right, Mr. Banerjee. Thank you for that.
And my lord, one more thing, my lord, I'm sorry, Mr.
Yes.
Sen perhaps would also
Yes,
my lord,
yes.
indicate to your lordships. My lords, in the informal paper book, my lord, the question is whether the suit at all is maintainable because it was filed after and winding up order was passed. In light of your lordship, would your lordships kindly have your lordship's order my lord, of 16th June?
We'll
Kindly have your
look at
lordship's
that. You have
order of-
given sufficient notice. Let Mr. Sen deal with this, and then answer you.
Very well, very well. I'll answer.
Now, my lord, your lordship is hearing the appeal from the Order 7 Rule 11 application.
But it will be a futile exercise if the suit has become infructuous.
But as I said, my first prayer is for damages.
No, regarding the CIRP,
But even
if you have made the same application, same reliefs, you have asked for the same reliefs before the resolution professional.
Well, this is on not on record, but I will have to take instruction. Well, I have no.
You are supposed to have a
not
copy.
a part of the records of the.
You can
my learned friend.
whatever you can.
Can I do one thing, Mulaj? No, would your lordship's leave, can I screen share a document, the resolution plan? My friend will be able to see that on your lordship's screen also. Till the time the physical hard copies are there, I do not want to waste your lordship's time. Can I screen share that document with your
You
lordship's
can
screen?
screen share, but it has to be gone through by Mr. Sen also.
Yes, but he will be able to see that on the screen, and it is his client who has given that. But I am
Yes.
showing a document submitted by
Yes,
his
Mr.
client.
Banerjee, yes.
Cannot adjudicate upon the question of damages. It is a liquidated claim.
Yes.
Which can be assessed. I already have a claim. I have supplied some goods or services. I can make a claim before the resolution professional. This is a case where this is a damages which I have suffered because of official liquidator when he was in possession. And it is at that stage, it is a case. Therefore, there is no question. This is not a CIRP dues or pre-CIRP dues as such. I have had no transaction with the company.
All right. Very
There is no relation between me and the company. It is my, as if I am the, if I live, say, if it's the family company, I live the corporate, it is my property.
Yes. Very well.
Lord, if your lordship comes to the part of the order where first this Order 7 Rule 11 on the aspect of bar of Securitization Act has been dealt with. This has kindly take from internal page 7, which is page 90 of the paper book. Yes. And as my learned junior pointed out, we had filed an application under Order 23 Rule 1 saying that we would praying for leave to withdraw the suit because of the formal defect. Whatever it is, that application was...
It was already on board when this order was passed.
Yes, the court has taken note of that. Kindly have a look at, my lord, that...
Yes, yes. 89, 89.
I am just showing your lordship, my lord, from that part. Kindly see page number 5, that is page 88 of the paper book.
Three applications were taken up. One
Yes.
was that Order 23.
At just the above paragraph, it is a plain written statement filed by defendant survey petitions 2 for rejection of. Oh, actually, there were two defendants. Both of them filed rejection of plaint.
Oh, so 2 Order 7 Rule 11 and
one
your
Order
23 one.
Yes. So that is why, my lord, 3 application, my lord.
All right.
Now kindly see, my lord. Admittedly, the defendant number 1 of this suit of the official liquidator, the public officer under definition of public. This I will come later, my lord.
This you are placing from?
Page 88, third paragraph, admittedly.
Yes.
The defendant number 1 of this suit, that is the official liquidator, is a public officer under the definition of public officer in the Civil Procedure Code, and as such, before filing a suit against him, prior written notice under Section 80 is to be served upon the concerned secretary of the central government. I will come to this observation later, my lord. The notice can be dispensed with as per provision of Section 80, subsection 2, if a prior leave is granted by the court, but in this case, no such notice has been served before filing of the suit, and no leave was obtained by the plaintiff from any court of law. Defendants rightly said in their petition of rejection without a notice under Section 80. Now next, though this point was mentioned by the defendants in their respective petitions filed under Order 7, Rule 11, firstly on 24th May 16 by defendant number 224 and thereafter on 16 July 16 by defendant number 1, but the plaintiffs did not admit the same either in written objection filed on such and such or in rather they raised allegation regarding conduct of the defendants such and such. Next, my lord, now after passing of more than 2 years of filing of this suit, plaintiff realized suit is not maintainable as no notice under 80 was issued prior to institution. In their petition dated 5th May 18, plaintiffs did not show any cogent reason for filing the said application at a belated stage at the time of hearing. Learned counsel for the plaintiff argued that want of notice under 80 is nothing but a formal defect, and formal defect must be given a liberal meaning which connotes various kinds of defects not affecting the merits of the plea. Now, these are the submissions which are recorded. I am not going into this. Now, then, my lord, Order 22(3) Rule 1 is quoted. After that, kindly comes to page number 7, which is page 90 of the paper book.
Yes.
As per 23 Rule 1(3), suit may only be withdrawn with permission to bring a fresh suit when the court is satisfied that the suit must fail for reason of some formal defect or there are other sufficient grounds for the plaintiff to institute a fresh suit. Power to allow withdrawal is discretionary. In the application, plaintiff must make out a case in terms of Order 23(1)(3)(a) or B and must ask for leave. The court can allow the application filed under such and such for withdrawal with liberty only if the condition, that is existence of formal defect or sufficient ground. This principle is found in public policy. On perusal of Sub-Rule 3 under Order 23 makes it abundantly clear that no litigant can be allowed to file suit one after another for the same, which is only to cause harassment to the party against whom it is filed, but it gives the unnecessary impart on public exchequer and unnecessary load on the court time. Provisions are based on public policy. In the case in hand, the conduct on the part of the plaintiffs to file petition for withdrawal of the passing of 2 years since date of filing of the suit is nothing but an intentional delay. And that also filed by them when the defendants completed their arguments in respect of petition under Order 7 Rule 11 CPC and pointed out series of defects of the instant suit. Moot question is, if considering the submission of learned advocates for the plaintiffs and keeping in mind the view of the Honorable Apex Court regarding different examples of formal defect, it would be held in the instant case, non-service of notice to defendant number 1 under Section 80, the formal defect, and if the plaintiff would be allowed to file the suit on self-same cause of action after successful compliance of Section 80, even then, will the suit be maintainable in its present form? The court says that let us go into the more substantive ground. In my opinion, the answer is no. Then, my lord, Order 7 Rule 11 is quoted. Then, next page is important, my lord. 91, after the section is quoted, paragraph starts with in this suit. From the documents filed by defendant numbers 2 to 4, it is clear that notice under 13(2) was already served upon the plaintiffs and proceeding has been started against the plaintiffs under the said act. It is the case of defendant number 2 to 4 that the suit is barred on the provisions of Section 34 of the Surface Act, and accordingly the same is liable to be dismissed. So, ground of 34 is based on a pleading documents from the application under Order 7 Rule 11. Statements from the plaintiff appear to be barred. This is not their case. Then, my lord, Section 34 is quoted. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debts required tribunal or appellate tribunal is empowered by or under this act to determine. And no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuit of any power. So I have not asked for any such injunction. It is a damage suit. I cannot even ask for injunction. Then, my lord, 35 is also quoted. Then kindly comes to the last two lines of this page. Thus, the opening portion of section 34 clearly states that no civil court shall have the jurisdiction to entertain any suit or proceeding in respect of any matter which a DRT or an appellate tribunal is empowered by or under the Securitization Act to determine. Expression in respect of any matter referred to in 34 would take in the measures provided under subsection 4 of section 13. I quite agree with this. Consequently, if any aggrieved person has any grievance against any measure taken by the borrower under subsection 4 of 13, the remedy open to him to approach DRT or appellate tribunal and not the civil court. Civil court in such circumstance has no jurisdiction to entertain suit or proceeding in respect of those matters which fall under subsection 4 of section 13, because those matters fall within the jurisdiction of DRT and appellate tribunal. Further, section 535 says the Securitization Act overrides other laws if they are inconsistent with the provisions of that act, which takes in section 9 CPC as well. In this juncture, it is pertinent to mention that the plaintiffs had every opportunity to ventilate their grievance against defendant number 224 in the proceedings pending before the Honorable DRT, but they did not prefer that option. Malad, I will go to defendant number against defendant number 224 only if it is assessed that yes, by reason of the negligent acts of defendant number 1, I have suffered damage. So therefore, I cannot ventilate my grievance in the debt recovery tribunal against defendant number 224. In view of the discussion mentioned above, there is no doubt that that the instant suit not only suffers with fraud, but suit is barred by the provisions of the Securitization Act. So my first challenge would be that the substantial ground is not applicable. The subject matter of the suit is not covered by the bar envisaged under section 34. And my lord, if that is so, my lord, even then, it is not their case that it is appearing from the statements in the plaint to be barred. Court has relied upon documents other than the plaint, not even referred to the plaint at all. So, my lord, now the question is, my lord, one other thing I would also like to say, my lord, kindly see here it says last 3 lines. Plaintiffs have every opportunity to ventilate their grievance against defendant number 224 in the proceedings pending before the partial. My lord, I do not know, my lord, it is absolutely alternative argument. Suppose in a case, if it is held that 34 becomes applicable to a suit, in that case also
partial rejection
is not permissible. So, my lord, in any event, the suit could not have been partially rejected also, even if my release would have been covered by the section 34 of the Securitization Act. Therefore, my lord, I submit, my lord, that from here where the learned court below has said, from page 7, last paragraph, that there is no point in allowing the suit to be withdrawn considering it is a formal defect if otherwise the suit is not maintainable. So, my lord, if that ground your lordship says that it is not covered by the suit is not covered by section 34, then, my lord, this order should be set aside on that ground. And, my lord, then I can argue also, my lord, that
what is the premise in your suit, in your plaint? What is the premise of quantification of the damages? Let us come back to your plaint once, Mr.
Paragraph. It is the
what is the ground of? I mean, why should damages be granted?
Because of theft, lordship.
Yes, because of theft, not only theft. Because,
let us see. Let
yes,
us see.
I'll just show your lordship the relevant paragraphs.
Page 1129, I think.
Kindly come to paragraph 24 onwards. Yes.
The annexure is actually not annexed in the paperwork.
Annexure?
Annexure has to be shown.
Yes, page para 24.
Kindly come to paragraph 28 onwards. What is the paper? Page 13 of the paper book.
Yes.
At the time of obtaining possession of the factory premises on 13th March 2015, It was found that there was large-scale theft of plant, machinery, furniture, fixtures, components, and other assets lying within the factory premises. While making over possession of factory premises on 13th March, official liquidator prepared an inventory list where the official liquidator noted in detail the tool, plant, machinery, equipment, and assets that were missing from the factory premises. The plaintiffs state that not only have the plant, machinery, equipment, furniture, fixture, other assets have been stolen from the factory, in the process thereof, plant, machinery, equipment lying at the factory have been irreparably damaged, rendering the same useless and or scrap. Then thieves have removed component parts, coils, and other machinery from the plant and equipment lying thereat, rendering such plant and machinery equipment absolutely worthless. Plenty of total value of the plant and machinery which have been stolen and or damaged is approximately 60 lakhs. Particulars, sorry, 60 crores, which is particulars contained in a schedule.
But paragraph 32 connects this with the claim of the
That
defendant
is
number
the plant, machinery, equipment which have been stolen.
That
and
is the
damaged
connect between the
in excess of the purported claim of the defendant number 234 against the
in your
plaintiff.
capacity as guarantor, the company we can understand, yes, company's assets have been stolen and all. Now, as guarantor, because you said that you are filing the suit in the capacity of guarantor also.
Yes.
As guarantor, your only connect to this damages is through para 32. That the value of the plant, machinery, equipment which have been stolen is far in excess of the purported claim of the defendant. So there is a connection with the claim of the defendant, the banks. Your connection with the damages, the assets were of the company, right? You were directors and guarantors of the loan. The assets are of the company. The company is directly affected if those assets are stolen from the custody of the liquidator. But in your capacity as guarantor, which is the only thread on which your fate is hanging here, because the official liquidator has the resolution professional has distanced himself. He's a pro forma defendant. Company is no longer pursuing this. So your connection on the basis of your as a guarantor is only dependent on the claim of the bank. Because there is a claim of the bank, you are a guarantor in respect of that claim. Therefore, you suffer damages because you will have to face that claim unless because of this theft. Rather.
That is number one. But primary thing is that I have to first prove this aspect of damage having occurred.
If you win the suit, what happens? Your liability gets reduced or obliterated.
If I win the suit, I have to get a decree for the claim which I have assessed.
You win the suit means you get a decree.
And to that extent I can satisfy
that claim.
Yes. But whatever it is,
that will be a fallout of this decree, not a direct. I mean, this is not directly within the zone of the Surface Act.
Cannot.
You are not saying anything about that claim. Independently, that claim exists. You are saying that claim is there.
Claim is there.
In this suit, you are not denying the claim.
No.
You are relying on the claim. And that is the premise of your damages, rather.
Yes.
Because there is a claim,
yes.
I'm suffering.
I am suffering. And number two also,
right.
The test can be like this, Manoj. Whatever I have claimed here, could I have claimed it in the forum specified under the Securitization Act?
Yes.
If that test is satisfied, then the bar of section 34 will clearly apply.
Absolutely, yes.
So therefore, my lord, if I can show before your lordship that this assessment could not have been done by the tribunal in respect of the measures under 13.4, because I have not raising any grievance as regards the measures under 13.4.
Rather, you cite those measures as a premise of your claim for damage.
Because
I am suffering those because of
there is a sword hanging over me.
Yes.
Therefore, I need adjudication of this claim. This is not the connection which I am.
Rather, it's the other way around. You are not trying to frustrate the claim.
No.
You are citing the claim for your claim of damages.
Absolutely.
In any event, that claim remains. 13.4 is still available against you.
Yes.
But you want to reduce that or obliterate that by virtue of this.
Yes.
Very good.
So therefore, my submission is that if the substantial, the main ground of Order 7 relevant Your lordship is with me.
If you win on this ground, the other ground remains, then we should have to consider, we would consider whether you should have been permitted to withdraw the suit and file. And even if you don't permit that, if you set aside the surfacing ground,
Then I
also order 7 rule 13 is there.
Yes, that is what my submission is.
First. Secondly, the CIRP thing, it's still irking us in the back of our mind because Mr. Banerjee has taken that point, whether this. Now, what would be the effect of that CIRP? Could the resolution plan contemplate this
No, cannot.
claim also?
Cannot.
Because official liquidator is not claiming against the company. It's rather you claiming against the official liquidator.
I am
If
claiming
you in your capacity as a guarantor is claiming against the official liquidator.
Kindly see, my lord, RP is practically the representative
Company.
Yes.
It's
Not
the
only
company now.
He's the board is substituted by
Yes,
him.
also protecting the interests of the secured
So
creditors.
therefore, in all fitness of things, the RP could not have distanced itself from this appeal. It was the RP's obligation because the company has suffered.
If the damages came into the coffers of the company, then it would
Company would benefit.
Company would benefit.
And this theft has occurred or damage or destruction, whatever has occurred, when official liquidator was put in possession for a limited period of time.
But since they are not challenging, now they are rather saying that this suit is not maintainable in view of the what is the nature of the application you have filed before the CIRP that has to.
Sorry, but I did not have notice of this at all. But
in fact, Malad, it's my bad.
It is very difficult.
It's my bad.
Take an argument.
So we'll keep it parted. You answer only on that tomorrow.
If then my learned
Yeah,
friend
learned
give
friend,
me a copy
please,
of whatever
drop us
proceedings they are
airdrop or whatever the.
No, Malad, we'll give them a hard copy. I'll assure my learned friends.
Whatever
It's their document.
they have filed, let me have a look at it. Because I have
Malad, and may I indicate one thing? May I come back tomorrow, Malad? Because I'll just take 5 minutes.
Not tomorrow, Mr. Banerjee. Tomorrow we sit singly, so it has to be on Monday.
Monday.
Keep it on Monday.
Grateful.
Let us see
Very
when
much.
we can whether we can reach it at all on Monday. We may not reach it, but it will
But
be
if
in the
you're-
list.
Very well. I'll not trouble. Is it possible Monday after 2
We can
PM?
keep it next Thursday also because we take up these hearing matters on Thursdays. Mr.
Malad.
Banerjee on Thursday.
17th, Malad, 17th in that case. Your Lordship.
Thursday, 17th. Yes, 17th.
Very well, Malad, very well. Malad, if your Lordships can keep it, Malad, I'll just take 5 minutes of your Lordship's time. That's it.
I will let Mr. Shen complete his arguments on your point.
Very well.
We'll have a look at that whatever it is he has
Because
filed.
I have actually not made my point. I just made that one point because there are 2-3 more points why it has actually become academic.
You will have a full hearing, Mr. Banerjee. No difficult.
well.
No. Why 5 minutes more than that? You'll make submissions. He'll give his reply. And the defendants, the banks will also obviously be heard. They are the main.
This is our application, Lordship. Order 711 was filed by.
Yes, you obviously have to be heard. So heard in part for further hearing on July 17, 2025. In the meantime, the relevant documents relating to the connected CIRP proceedings, which are relied on by learned counsel for the resolution professional, shall be handed over by the latter to the learned advocate for the appellants.
I'm so grateful. Deeply.
Mr. Mojumdar, if you want to have a copy, any of you want to have a copy of those documents, you can also take from them.
Malaj, I'll hand it off to all the parties concerned in the this topic.
It will be circulate copies. Yes.
We'll circulate copies.
Right.
The annexures
That's
are
what
in the annex in the paperwork, Lordship. Only the
Bring the annexures, show us.
Malad, one thing, Malad, that the winding up order, which is part of the plaint, has not been in the paper book. We'll just attach with the
whatever
compilation.
Documents you want to, which are relevant, if you want to rely on them, and give copies to the learned advocate for the appellant, and
we'll do that. We'll do that.
Section 80 also in my W.
No, pass over matter.
Grateful, my lord.
Deeply appreciated.
Thank you. Who is appearing for that? Mukherjee or that? Yes. Why such a poker face?
Your Lordship,
I
kindly allow.
told her, my lord, I will, my lord.
Request your lordships, my lord, because my lord, she's really not, my lord, read the papers. And I told her, my lord, if she's interested with a case, she must read the papers.
Well, let us come back on next Thursday then. On the prayer of the appellant, let the matter stand adjourned till July 17, 2025. নামগুলো একটু রেখো।
Grateful, Your Lordship.
My lord, I'm sorry, my lord. My lord, could it be, my lord, after, my lord, recess, my lord, your lordship?
After recess?
Yes, my lord, I might have a problem in the morning. I fixed a matter.
Mr. Mukherjee, do this. We'll keep it on 17th as it is. If you have any difficulty, your junior will be there. We'll
I'm great.
consider it. No difficulty on that. Respondent,
My Lord.
what is the matter about?
My Lord, this is about a custody matter of
Custody matter.
son. The respondent.
Both of you are for the respondent.
No, my Lord, he is my.
Who is for the appellant?
My Lord, Mr. Taposh Bhattacharya generally appears.
Taposh Bhattacharya.
My Lord.
Saptangshu Basu Taposh, they were there on the last.
The mother is a judicial officer, father is an advocate, their younger.
Please send it for mediation.
My Lord, the mediation field, that is why we have.
Mediation has failed.
Yes, my Lord.
Very good.
The paper book they have given, but my
File the paper. We have given copies to the other side, paper books.
my Lord, the petitioner had filed the paper books.
They have given copies to you.
Yes, my Lord, perhaps the court doesn't have the paper books. It's there.
Amravati সবার কাছে আছে। Paper books, it will be on 17th. None appears for the appellant at the time of call, although the respondent is, you are for the respondent number 1.
My Lord, yes.
Respondent number 1 is represented through counsel. First of next para, we find that although paper books have apparently been filed, comma, those are not with the records before us. First up, let the paper books be called for and be tagged along with the main file before the next date of hearing. আগে কি বলেছি adjourn করেছি না the matter shall next be listed under the same heading on July 17 2025 17 please give your name. Yes,
I am for the respondent referring claimant land.
Respondent, catch hold of the appellant and bring him. Suman Sen
is appearing for the respondent. I am for the respondent. Therefore, perhaps he is for appellant, my lord.
Who is Suman Sengupta is for the appellant?
Yes, my lord. Suman Sengupta is my
Yes, but what can be done? He's not there.
He's on leg, my lord, in court number 35, my lord.
You are
The Sengupta is appearing.
you are so being so close to him. We thought you were with him. Yes. Maintain a distance from the other side. You start the matter.
Well, I'm not briefed in this matter, my lord.
You are not briefed in the matter.
Only he's on.
We are dismissing for default. If you are not briefed, no difficulty.
My lord, kindly.
Your stake is not there.
He
You are not in this matter. You are not. You are not in his chamber or in this matter.
Please inform me, my lord. Kindly take. Not this way, my lord. Kindly.
You are for the respondent. After ensuring that the appellant has not come, you are coming.
I was on my legs.
An adjournment is sought on behalf of the appellant. Let the matter stand adjourned.
Fifth time.
Let the matter fifth time.
My lord, kindly see.
Acha, an adjournment is sought for on behalf of the appellant. First of learned counsel for the respondent points out that this is the fifth time that an adjournment is sought at the behest of the appellant. First up, accordingly, as a last chance to the appellant to appear and argue the appeal, comma, the same is adjourned till July 17, 2025. First up, it is made clear that in the event the appellant remains unrepresented and stroke or seeks adjournment on the next occasion, comma, appropriate orders shall be passed in the absence of the appellant. Please inform him. You give your name and inform Mr. Sengupta that we have passed this order. Yes, Mr. Chattopadhyay, what is the matter about?
My lord, My client is willing to engage a senior counsel.
You are sufficient, Mr. Chattopadhyay.
No, my lord, due to I am sufficiently insult only.
You are
that-
the advocate on record. You have been.
Only that way I.
Why didn't he or she engage another advocate? It was pending for so long.
So long, my lord, due to my lord, for seven maybe.
Use the microphone, Mr. Chattopadhyay. Use the microphone.
Due to my lord some bona fide mistake
What is the bona fide mistake?
that I am not a fit for this case.
We'll dismiss it for default then.
No, my lord. Only
It has
that-
been pending for quite some time.
No, sometime not adjourned. Only, my lord.
No, not adjourned. It's in the list for quite some time. You are aware that the matter is there, quite up in the list. So why hasn't he engaged another person?
My lord, due to engage, I am not raised any objection.
No, then we'll dismiss for default.
No,
if you
my
don't have instruction to appear for the appellant, we'll dismiss it.
No, my lord, after contesting the same, only praying not.
You are the advocate on record, Mr. Chattopadhyay. Your power is still there. If you
Yes.
don't want to argue the matter, we'll dismiss for default.
No, my
Whatever your client may think, we are not at the whims and fancies of your
No,
client.
lord, that will be insult and create a breach of peace.
Breach of peace.
Yes, lord. Only that way I am not saying in this.
He approaches appropriate magistrate for that breach of peace. We'll commit that breach of peace. We'll dismiss the matter for default.
No, my lord. Only that-
Absolutely, no.
I am arguing this way.
Argue then.
প্রত্যেক দিন কিছু না কিছু একটা ছোট করে এই অনেক কোনোদিন মামলা করবেন দেখবেন পুরো রেডি আছে
Yes. What is the matter against Mr. Chattopadhyay?
This is against me in a partition suit. Partition suit.
Are you asking a question? This is 17.
17.
Yes. Yes, Mr. Chattopadhyay, not saved for the respondent. Now start the matter. You take your breath and tell us what is the matter about. Yes, Mr. Chattopadhyay.
Yes.
Why are you going in slow motion? What is the matter against? What is the appeal against? Tell us that at least, Mr. Chattopadhyay.
Due to my personal difficulty, only that way I am paying. for
Your
that.
personal difficulty.
Personal difficulty, only that way.
No. Due to our personal difficulty, we are refusing. We are very impatient and this court is,
No.
we have a great difficulty if people take adjournments and all these things. So due to our personal difficulty, we are refusing your adjournment. Move the matter. Yes.
What are preliminary?
Every time you come up with some new excuse for asking for time. We appreciate the innovation, but this time, sorry, it doesn't work. What is the impugned judgment? What is the impugned judgment?
Lord, that the indication give me the same, Lord. It is into.
Final degree of partition.
Partition.
What is your ground of challenge?
Ground was challenged, my lord, that the partition degree was made in absence of myself.
You are the plaintiff.
I am the plaintiff.
Thank God.
Yes, my lord.
In your absence, why in your absence?
Absence, my lord, there the degree.
Notice was served, you were absent, what could be done?
Yes, my lord.
That is not a good ground. What on merits, what is the difficulty? Even if it was passed in your absence, if it's a valid degree, why should you set it aside?
Not a valid degree, my lord.
Why not valid? That is our question.
Yes, my lord. Valid degree, not in this way.
What is the infirmity, illegality in the degree?
That the
Yes, you continue.
that the commissioner was appointed in my absence, and the commissioner details was made by 1/5, 2/5, 2/5, 1/5. In this way, deviation was made.
The impugned degree is in terms of the preliminary degree. You have not challenged the preliminary degree.
Preliminary degree not challenged.
Not challenged. So 1/4, this 1/4.
Among final degree was made in absence of myself.
In absence of yourself does not vitiate a degree per se. unless there is any other illegality.
Yes.
Even if it is passed in absence of somebody, if the decree is all right, otherwise legal, lawful, in consonance with law, there is no occasion just because you chose not to be present does not invalidate the decree at all.
Yes, my lord.
So, Mr. Chattopadhyay, what is the difficulty? Preliminary degree is 1/5. You are defendant number 1.
I am the defendant number 2. 2/5 share.
But the preliminary degree says you are defendant number 1.
Only that's the way the difficulty was.
Defendant number 1 was Kamal Dolui. Your
Defendant number
plaint
1.
says defendant number 1 is Kamal Dolui. Preliminary degree says defendant number 1 is Kamal Dolui. The memorandum says Kamal Dolui is the appellant. You are appearing for Kamal Dolui.
Yes.
You are saying you are not defendant number 1.
Yes, defendant number 1. Kamal Dolui, defendant number 1.
And you are appearing for the appellant.
Yes, sir.
Appellant is Kamal Dolui, defendant number 1.
Yes.
Therefore, our question was correct. You are defendant number 1.
Yes.
You are allotted to 5th chair. You have not challenged that preliminary degree.
Preliminary degree challenge.
Failed.
Yes.
Failed.
Yes, no.
So we should be consistent. We should be consistent. This should also fail.
Yes, no. That the one check was given in this way, main difficulty is that Miller only adjourn the matter.
Check regarding your fees.
Fees, no. That the valuation of the property in question. I am the owner of the land by purchase construction.
What is the illegality in the degree apart from your being absent? That is not an illegality.
Preliminary degree was made in absence of myself.
Preliminary degree was made in absence of yourself.
Yes. আমি রেডি হতে পারিনি ঝগড়া হয়েছে
25 to 20. I'm sorry, brother.
Page 24, 25.
Yes.
That has not been challenged.
Then the commissioner's report, they were present.
Commissioner's report, they were present before the commission.
Yes,
Yes. Page 36 to 44.
Commissioner report in absence of myself. That the said that is the main challenge in this matter.
Page 37. Sir, একটু দেখুন একবার।
একবার দেখবো
Page
বলতে
37.
আর কি মাথাটা ঠিক নেই।
কবে ঠিক থাকে কে জানে?
Finding on the proceeding. Page
Yes.
37.
Yes.
Kindly seize, my lord.
Writ served.
This is one. Then
The
the-
writ was served, they were not present.
Yes.
Notice was not served.
Page 38. I have read it for today. Partition suit. Paragraph 4. Kindly seize. And in the preliminary decree, lordship would find they did not dispute at all. There was an admission that I will show immediately.
Preliminary degree stands final. They have not challenged even.
And report has not been challenged, accepted.
Report-
26, Rule 13, I think.
No, they did not file any written objection.
No, nothing on record. Kindly see the final degree accepting the report, page 47 to 51. Unless the report is challenged, my lordship no set aside or carried. that has to be
Report
accepted.
was challenged.
Report challenge করেছেন?
হ্যাঁ হ্যাঁ।
কিছুই তো
What is your written objection? Which page?
Milord, today adjourn this matter.
No.
Milord. I am out of
No. Mr. Chattopadhyay,
I am out of my
you are in a habit of.
only excuse me, Milord.
Why should you excuse you?
Milord, only in chamber creating pressure, only that way I am be on that way.
No,
Milord, তুমি
No
recover.
question of.
Only Milord.
No, Mr. Chair.
Page 47.
We have never seen you do a first appeal, so we are eager to see
I
you.
am never to say in court in this way, Milord. Never.
You always say in court in this way.
No,
We have
Milord,
never
I
seen you argue a first appeal.
I never
We want
say.
to open the account now. No, Mr. Chattopadhyay. This has been appearing for quite some time, and these matters are blocking other matters. Because these matters are there, every day people are coming on the verge of crying. Please include my
No,
matter.
only
People are coming
consider
first.
today, Milord.
No, because of people like you, Mr. Chattopadhyay, the list is being held up. You have to move the matter. We'll dispose it of today itself.
Milord, I am the pointed out this
Point out.
ordered preliminary degree as per the degree of the plaintiff number 2 Nirmal Kumar Dolui has 2/5 share. Plaintiff number 3 Sundip Dolui has 1/5 share. Defendant number 1 Kamal Dolui 2/5 share.
That is the preliminary degree. In terms of that only, the final degree has been passed.
Yes, only that way. Report, Milord. Milord, share A schedule property, Jogin Mukherjee Lane. fixed 22/6/2018 for submission of partition of commissioner report. The commissioner report was also submitted. Commissioner submitted his report 4th June 2018. Commissioner submitted his report without prior scheduled date, due to which the defendant number 1 HON'BLE remained in dark about the report.
What are you reading from? Which page of the paper book?
Note I have handed.
Your note.
Yes, sir.
We are more interested in checks, which has been directed by the final degree. No notes. Read from the paper book, Mr. Chattopadhyay.
Probably, my lord, I'm sorry, in the execution also, when the bailiff went.
Only that is the main
their
detail.
articles, they appeared in the execution, all on record.
They executed already.
Yes, and I tell you, Lordship, one additional thing. If Lordship sees the application for stay, I'm sorry, my lord, on that day I pointed out, I was also.
Stay, we are hearing the appeal.
It was submitted as if the preliminary decree has been challenged.
Oh, that matter.
Yes. And I was, my lord, totally confused. And since the execution proceedings orders I have marked.
In the memo itself, it's written against the preliminary degree.
But grounds of appeal I have shown you.
That matter, Mr. Chattopadhyay, no question of further adjournment. You have been stalling the matter deliberately.
And in the execution also, my lord, I can hand up to your lordship all throughout the year. They have received the articles, recorded in the execution.
Have you got a copy of that?
Yes.
Hand over, we'll keep it on.
Just give me a minute's time, my lord.
I'm জানেন না আপনি
Yes.
সাংঘাতিক জিনিস।
My lord, I'm sorry, my lord, marked in pencil. Lord, JDR means judgment data, my lord.
Yes, that must.
I know, my lord, I'm sorry, my lord. I'm sorry.
JDR files an adjournment petition.
And not only on that day, thereafter also.
Has been executed.
We ordered
Nothing remains. Judgment defend.
And finally, they got their articles that has also been recorded in the subsequent order. Yes. Order dated.
The present appeal has been preferred against a final degree of partition. Full stop. Learned counsel for the appellant contends that the commission work was that the commissioner's report was accepted behind the back of the appellant. Full stop. Further, it is submitted that the defendant number 1 stroke appellant did not have any notice of the commission work. Full stop. Next para. Learned counsel for the respondent, plaintiffs stroke respondents vehemently opposes such contention and submits that the commissioner's report itself reflects that notice was served on the defendant at every stage. Full stop. Next para. Moreover, neither any written objection was filed to the partition commissioner's report, nor was any prayer made by the defendant to cross-examine the commissioner. Full stop. Next para. Moreover, the impugned final degree of partition has already been executed and articles have been handed over to the defendant number 1 stroke appellant. Full stop. Next para. We find from a bare perusal of the commissioner's report that notices of the commission work was served at every point of time on the learned advocate for the plaintiff as well as on the defendant. Full stop. Next para. In the event the defendant deliberately chooses to abstain from the commission work despite notice, it is not the fault of either the court or the plaintiff that the commission work has to proceed in the absence of the defendant. Full stop. Next para. Apart from such frivolous plea of non-service of notice, the appellant does not make out any other infirmity in the commissioner's report or the final decree. Full stop. Next para. It is trite law that law raises a presumption in favor of official and judicial acts having been done duly. Full stop. Next para. Thus, we do not find, in the absence of any rebuttal or cogent evidence in that regard, as to why the recording in the commissioner's reports that notices were served on the defendant number 1 stroke appellant should be disbelieved or disregarded. Full stop. Next para. On a perusal of the commissioner's report, comma, perusal of the partition commissioner's report, comma, we find that the partition commissioner dealt with the respective shares of the parties fully in adherence with the preliminary decree and allocated the property in accordance with law upon a proper valuation on valid basis BACS in respect of the shares of each of the parties in the suit property. Full stop. Next para. Furthermore, comma, since no written objection was filed to the partition commissioner's report by the defendant number 1 stroke appellant, comma, nor was any prayer made for cross-examination of the commissioner, comma, we also do not find any other ground for interference with the impugned judgment and final decree of partition. Full stop. Next para. We reiterate that a perusal of the commissioner's report and the map annexed thereto clearly demarcates the specific allotted portions of the parties fully in consonance with the preliminary decree. Full stop. Thus, comma, there is no scope of interference in the present appeal. Accordingly, FA 91 of 2022 is dismissed on contest without any order as to cost. A formal decree be drawn up accordingly. Next. Keep it with.
Only thing, my lord, pardon me, my lord, I just said JDR, my lord, it just came out from.
Oh, Mr. Dev, please.
Great.
No, sometimes we don't know the abbreviations. To me, it happens all the time, but mostly in commercial matters. The JDR
Just came out from my mouth, my lord. Grateful.
Okay. Thank you, Mr. Chattopadhyay. Yes. Next. This is the third occasion when none appears for the parties at the time of call. Accordingly, FA 141 of 2022 is dismissed for default. Interim order, if any, stands vacated. There will be no orders to cost. Next. এগুলো ইন্টারেস্টেড নয় কি আননেসেসারি লিস্ট ভরে আছে অন্য যারা সকালে কান্নাকাটি করছিল কি নিতে পারছি
90 mallet I appear for the appellant.
Yes. You are two of the most regular advocates who attend at first appeals. You are a rare species now. Yes.
At time it is correct.
So both of you, we have found you, unless extremely difficult or held up somewhere, either you or your juniors are always there. Thank you for that.
Well, this is suit
Yes,
for
Mr. Shen.
declaration and injunction, madam.
You are the defendant.
I'm the defendant number 2 in the is the appellant before your lordship, madam. Madam, there was a deed of partition between defendant number 1, plaintiff and the defendant number 1. There was a clause for preemption in the sense that if the
Mr. Chakraborty is for defendant number 1.
Defendant plaintiff, respondent number 1.
Plaintiff respondent number. I appear for the defendant. Defendant number 2 is the appellant before your lordship.
Yes, because it's described in the paper book as defendant number 1 respondent. That's why we were misled. Just see the cover. It appears that defendant number. So you are the plaintiff respondent.
Plaintiff respondent. And the other defendant, other respondent is the defendant number 1 who has not contested the suit.
Achha.
Only the defendant number 2 contested the suit.
Very good. So it's between plaintiff and defendant number 2 primary.
Plaintiff and-
Yeah, Mr. Chakraborty, please take.
Malad, the suit is for declaration and injunction. This case is that the defendant, plaintiff and the defendant number 1 had executed a deed of partition in between them for segregation of their shares. Malad. There was a clause in the deed that if any of the parties sought to transfer their property, an intimation has to be given, and accordingly the first choice to be given. Malad, in this case, an intimation was sought given, but there was an evasive reply. Upon, my lord, the passage of time, my lord, the sale took place.
In your favor?
In my favor. Subsequently, my lord, within few days of the sale, challenged.
On the ground of that
on the ground
that
of the
clause.
preemption clause. My lord will
Preemption clause was there, prior refusal clause was there in the partition deed itself.
partition deed itself. My lord will kindly come to the prayers of the plaintiff.
This is a classical civil suit. Yes.
My lord, for a declaration, page 18.
18 years.
This is the plaint of the
Clause 9.
prayer of the plaintiff.
Right.
For a declaration that the plaintiff has a right of preemption regarding the suit property premises under the contract embodied in clause 9 of the deeds, partition deed such and such. Next, declaration that the impugned sale deed number such and such registered at the office of the additional district sub-registrar Srirampur Hooghly is inoperative, not binding upon the parties, and for a declaration that the defendants are legally bound to execute and register the sale deed relating to the suit property or the premises on receipt of the consideration money from the plaintiff. Now the suit is decreed, my lord. My lord will kindly come to the ordering portion of the decree, ordering portion of the judgment. That my lord will find, my lord, judgment starts at page 106. And the ordering portion at page 131.
Yes.
The suit is same, the suit B, and the same is decreed on contest without cost. It is hereby declared that the plaintiffs have preemptive right of purchasing the suit property. The sale deed being such and such is hereby declared to be inoperative. The defendants are directed to execute a sale deed relating to the suit property in favor of the plaintiff for consideration rupees such and such to be paid by the plaintiff within a month from date in the order to and put the plaintiff in possession of the suit property. If the defendants fail to execute a sale deed of the suit property within such and such period, deed will be executed in accordance with law. Fact remains, my lord, the defendant number 1, I have paid my consideration to the defendant number 1. Defendant number 1 has not contested the suit. Prayer is for, my lord, preemption. Preemption, my lord knows, my lord, it's a substitution. Type of substitution has to be followed. Here, my lord, when the deed, my deed has been set at naught, to be said to be inoperative, I am directed to execute the sale deed. This is the short point involved so far as this matter is small and execution is concerned. An entire amount must come to me because
that is the entire amount must come to you, and you have to execute the sale deed.
You have to. I have
and
to.
And plaintiff ideally should be the defendant number 1 ideally should be a confirming party there.
Ideally should be a confirming party. Preemption means substitution. It's not.
You get the money.
No, the money, my lord, it has been directed that 12 lakhs to be paid to the defendants. Even if, my lord,
you can modify that.
But that is to be modified, my lord, if, my lord, the other points are I am unsuccessful in the other points, my lord.
So you say regarding preemption, first offer was made, there was an evasive denial. So therefore, the preemption clause has been exhausted. Not that it was not complied with.
Not that it was complied.
And secondly, this even if decreed, amount to be paid to only you.
Only.
Very well. Short and sweet.
My lord, now, my lord, I
will. First evasive denial and the offer.
My lord, now, my lord, I will come into the, my lord, the clause, my lord. My lord will kindly come to page 178, the part 2 of the paper book, my lord.
Yes. Yes.
That is the Bengali version, my lord. Page 90 is the clause. Page 190.
190
is the clause. এতদ দ্বারা আরো প্রকাশ থাকিল যে পক্ষদ্বয়ের মধ্যে যদি কোনো পক্ষ
Justice Kumar can read better than you.
তাহার অংশ চিহ্নিত নির্দিষ্ট সম্পত্তি সম্পূর্ণ বা কিয়দংশ ভবিষ্যতে বিক্রয় করিতে উদ্যত হন, তাহা হইলে অপর পক্ষ যার ওয়ারিশন ও স্থলাভিষিক্ত রেজিস্ট্রিকৃত ডাকযোগে 60 দিনের নোটিশ দ্বারা অবগত করাইবেন তৎকালীন সময়োচিত মূল্য অপর ইচ্ছুক পক্ষকে বিক্রয় করিতে বাধ্য থাকিবেন। অপর পক্ষ যার ওয়ারিশন সময়োচিত মূল্য, মানে আই এম স্ট্রেসিং অন দিস, তৎকালীন সময়োচিত মূল্যে খরিদ করিতে অস্বীকার করিলে তখন বাহিরে তৃতীয় ব্যক্তি বিক্রয় করিতে পারিবেন। My lord, this is the page 90, my lord, is the 190, and page 208, my lord, is the translation. It says সময়চিত অর্থ means proper price prevailing at that time. Proper price. My lord, on page 251, my lord, is the letter I wrote to him, my lord, before, my lord, the sale took. Page 251.
Forty-nine.
249.
49, yes.
249.
249.
But paragraph 3. That due to urgent need of money, my client desired to sell out the scheduled property to meet his necessity, and for the reason I, on behalf of my client, giving you offer to purchase the scheduled property at a present market value of rupees 12 lakhs from my above named client as per the condition laid down in the partition deed. Under the circumstances, I, on behalf of my client, request you to let me know, either me or my client, whether you are willing to purchase the scheduled property from my client at the said consideration value of rupees 12 lakhs within 7 days from the date of receipt of this notice. Otherwise, my client shall be at liberty to sell the property to any third person without any further reference to. Malad, that notice, Malad, is replied on the next page, Malad, 251. Relevant portion is 252. It says that 60 days notice has to be given. I have given 7 days. That 7 days notice that you have given on behalf of your client addressed to my client is not in accordance with the terms that set forth in the said registered deed of partition, which please note. Thereafter he says, so having instructed by my said client and his authorized agent thereof, I inform you that my client intends to purchase your client's aforesaid property at a market price prevailing at present. Kindly inform my client the breakup value as to the price that you have mentioned in your notice under reference, that is the value of the land measuring such and such, and the value of the old one-story pakka building having covered area of such and such. But this was the reply.
So this is not an evasive reply.
But evasive reply in the sense, my lord, I will show, my lord, subsequently, my lord.
He's correct on both counts, but 60 days we appreciate if you waited for 60 days before the sale,
No,
maybe you
60
can
days was
obviously.
after
But this
60 days
he accepts and says at the prevailing market price. That is সময়চ্যুত মূল্য.
মানে সময়চ্যুত মূল্য, my lord. Thereafter, my lord, I will be placing, my lord. There are other things, my lord.
Yes.
Thereafter, my lord, before selling, an insertion is made, my lord. That is, my lord, on 2nd of July 2021, 2012. My lord, first letter is in the month of February. 6th February 2012. And my lord, he gives reply on 11th of February 2012. On insertion is made, my lord, on 2nd of July 2012. This insertion, my lord, will find at, my lord, 255. 255, my lord, if there is 256 is the translated version, my lord. If there is any proper claimant of the said land, or as he or any of his family will contact in the following address with proper document by way of prima facie proof within 15 days of publication of the notice and the contentions. He gives a reply to that notice, my lord. I say, my lord, the parties were not addendum, my lord, as regards the price, my lord, throughout the process, my lord, up to sale, my lord. His letter is, my lord, he replies to the notice, my lord, at 2:58. Has entered into an agreement, 260, my lord, is the translated version. Entered into an agreement for purchasing a pakka single story covering an area of such and such, for purchasing the homeland measuring about 1 katha such and such, together with single story pakka housing having a covered area of such and such area. In this context, I inform you that purchasing the same property, the said owner, Sri Vishwajit Ray, gave me a notice through the advocate by him, Sri Shubhajit De, such and such, after I acknowledge the said acknowledging this receipt of the said notice on 11/2/2012, the lawyer appointed by me, Sri Shambhunath De, I, by sending a letter by registered post, a copy of which letter of Vishwajit De, informed that I am willing to purchase the said property from Sri Vishwajit De. Xerox copy of the letter dated such and such is annexed to this letter. In this context, I inform you that as per information of the partition suit amongst the two parties of the said deed, if anyone wants to sell his property, then one party informing this was done. My lord, this letter, my lord, reply comes on my lord 9th of July 2012. Insertion is at July 2nd July and 9th July. The reply comes. And the sale takes place. My lord, here also, my lord will find there was no categorical statement that on that amount I am ready to purchase. That is not there, my lord. Anywhere in
clarified in the very first reply, Mr. Shen.
My lord.
Very first reply, he categorically said that I would pay at the current market price. Shomoyachita mullo, what can be more appropriate than current market price?
My lord, my
He gave the offer, he received the he accepted the offer.
My lord, my offer, but he has never, my lord, during the process of communications.
This is not a negotiation or an agreement. This is his statutory right, contractual right as per the partition deed.
Partition.
And you know, Mr. Shen, that goes with the property.
My lord.
That is an encumbrance on the property. That right.
My contention is that, my lord, so far as the market price, he has stated, my lord, market price, 3 terms coming, my lord. One is proper price and the other is market price.
Shomoyachito mullo.
Market price. Shomoyachito. My lord, he says market price. I quote, my lord, 12 lakhs. He doesn't come up.
It is arbitrary. Shomoyachito mullo.
No. Ultimately, I sell at that same 12 lakhs.
Admitted. But that is a post facto event. The sale.
Right.
We have to look at the previous period, at the time of offer, because the entire matter hinges on the offer. Otherwise, the sale could not take place. At the time of offer, you said, I'll sell at 12. He says, I am willing to pay the market price. Could have been more than 12 also. We don't know.
Well,
might have been more than 12.
He did not come up with any figure.
Why should he come up with a figure?
Well,
he need not. As per 9, if he agrees, because if you see clause 9,
well, clause 9 is at page 190.
Right. তাহা হইলে বিক্রয় করিতে উদ্যত হয় তাহা হইলে অপর পক্ষকে মায় সাচ এন্ড সাচ ডাকযোগে 60 দিনের নোটিশ দ্বারা অবগত করাইয়া তৎকালীন সময়োচিত মূল্যে অপর ইচ্ছুক পক্ষকে বিক্রয় করিতে বাধ্য রইলেন। সো সময়োচিত মূল্যে and ইচ্ছুক পক্ষ, he has to just express his intention to buy and at the prevalent market price is the best definition of সময়োচিত. So he has to just express his willingness. ইচ্ছুক পক্ষকে বাধ্য রইলেন. It ends there. He said, I am Ichchuk, Somayachito Mulle, and then he exercises the right.
I quote my lord 12 lakhs, my lord. I get 12 lakhs also, my lord, from the my.
That is what we are saying. You're getting, you could have gone much more, but that would not be Somayachito Mullo.
No, Somayachito, but
Somayachito Mullo is not whatever price you show in the deed.
Malad, Somayachito Mullo, Malad, he doesn't quantify is that is the whole crux of the matter, Malad.
He does in a sense. You said 12 lakh.
Malad.
That is arbitrary. That there is nothing to show in your letter, in your offer, that it was Somayachito. Subsequently, it was validated by the purchase. But at the time of offer, 12 lakh was just an arbitrary amount. He said, I am willing to pay the market price. What can be more appropriate than market price?
Market
could have been more than 12 lakh.
Maybe, Malad, he ought to have, my contention is, Malad, he ought to have quoted an amount, Malad.
No, Mr. Shen, we could have appreciated if the clause was that you had to match your price or something like that, or the highest price which was available, or any provision of bidding. There is nothing of that sort in 9. 9 is straightforward.
9 is
You have to give an offer, 60 days notice. If he agrees to purchase at the market rate, you sell. He agreed to purchase at the market rate. You did not sell. You sold somebody else.
No, market rate, my lord. I give him a figure, my lord. If he would have said, no, this is not the market rate, I want to purchase this market rate, my lord, that would have been a different case. But he, my lord, did not quote any figure.
No obligation.
This is what I am saying, that evasive reply, my lord. He doesn't specify his amount that this is the market rate, I want to take this. But throughout the process, my lord.
It was not the clause that he has to match your figure. That you can offer to sell the property to him at any price, and he would have to match it.
No, the offer to sell at Somayachiti price, my market rate.
Somayachiti is market price.
My lord, got sold.
We have to look at the day of the offer, not the day of the sale. Sale comes later. Sale might post facto validate your market, your Somayachiti Mullo. But that Mullo was you might have purchased at higher than the market price. There was no obligation on him to purchase at higher than the market price. Not that you would fetch the most the highest amount.
My contention will be, unless, my lord, I say 12 lakhs. He says, my lord, no, he ought to have said, my lord, that this is not the market price. This is the market price. I want to pay. I can only pay you this.
He had only to convey his willingness to purchase at the market price, which is precisely what he has done. Market value price will be ascertained from the registry office. That could have been done. Probably there is something in that letter also. Let us, yes, come back to that letter, please. The letter is at page 251. He was very specific. I mean,
251. My letter.
251. Sorry. Yes, 251. He says, first of all, he points out the 60 days thing.
My lord.
So having instructed by
60 days after the 60 days had elapsed, my lord, property was.
Therefore, that we are more lenient on that. Yes, you are right. Said client, the authorization, I inform you that my client intends to purchase your client's aforesaid property at the market price prevailing at present. Kindly inform my client breakup value as to the price that you have mentioned in your notice under reference, that is value of land measuring such-as and value of fold, which is the premise of assessing the market value.
But so far as the assessment of market value, my lord, entire deed is.
You did not give him defendant number 1 did not give him that scope.
But defendant number 1, my lord, did not give any reply to this, my lord. Subsequently, my lord,
sold to you outright.
No, subsequently, my lord, there was a paper insertion on my behalf, my lord. They are.
Mr. Shen, we are modifying this decree. We will direct the amount to be paid to you.
My lord, then also, my lord, he did not come up with any figure, my lord. He ought to have.
We'll record the submission, but
he ought to have come up with any figure, my lord.
No. Mr. Shen, we have heard you, Mr.
Chopra. By the order of previous order of the court, Justice Tannan's order, I have already decree is partly executed.
You have deposited the money.
Executed, possession is not been taken.
Deposited the money.
Money has been deposited in interest-bearing deposit by the order of the court.
He will take back. We will direct him to take.
But the entire money should go to me, man.
To you.
already.
Yes, yes.
Yes, he has paid.
The present appeal has been preferred by the defendant number 2 in a declaratory suit. Full stop. The plaintiff stroke respondent number 1 filed the suit for declaration that the plaintiff has a right of preemption regarding the suit property stroke premises under the contract embodied in clause 9 of a partition deed bearing number 4637 dated June 30, 2003, registered at the office of the additional district sub-registrar, Serampur, Hooghly, and a further declaration that a sale deed dated July 16, 2012 executed in favor of the defendant number 2 stroke present appellant is inoperative and not binding on the plaintiff and for consequential reliefs. Full stop. Next para. The short point involved is whether the rigors of clause 9 of the agreement of the partition deed between the defendant number 1 and defendant number 2, stipulating that if one of the that if the defendant number 1 wanted to transfer his allotted portion of the property, that is the suit property, in favor of a third party, a prior notice of 60 days has to be given to the plaintiff, and in the event the plaintiff agrees to purchase the allotted portion of the defendant number 1, it will be incumbent upon the defendant number 1 to sell the said property at the then prevalent appropriate market price to the plaintiff. Full stop. In the event of refusal by the plaintiff to do so, however, the defendant number 1 would be at liberty to transfer the suit property in favor of third parties. Full stop. Senior counsel appearing for the appellant submits that that although a notice was given in terms of clause 9 by the defendant number 1 to the defendant number to the plaintiff, the plaintiff gave an evasive reply. Full stop. Although a specific amount of consideration was mentioned in the notice dated February 6, 2012, issued by the defendant number 1 in terms of clause 9 of the partition deed, to the tune of rupees 12 lakh, in the reply thereto dated February 11, 2012, the plaintiff, evasively, stated that he was willing to purchase the property at the prevalent market value and sought a breakup, without mentioning any amount of consideration. Full stop. Thus, it is submitted that clause 9 was duly complied with, but no specific acceptance of such offer came from the end of the defendant number 1. Full stop. Next para. Alternatively, learned counsel for the appellant argues that the impugned decree is vague as to whom the consideration amount of rupees 12 lakh should be refunded to. Full stop. It is submitted that even if a decree cancelling the sale deed in favor of the appellant was passed, the entire consideration ought to have come to the defendant number 1's 2 stroke appellant. Full stop. Next para. Learned counsel appearing for the defendant plaintiff stroke respondent number 1 controverts the allegations of the appellant and points out that the plaintiff stroke respondent number 1 specifically accepted the offer given by the defendant number 1 to purchase the property at the then prevalent market value, and for such purpose sought a breakup in his letter dated February 11, 2012. Full stop. Even subsequently, when a newspaper advertisement of the sale came out on July 2, 2012, the plaintiff stroke respondent 1 categorically wrote to the defendant number 1. You wrote to the defendant number 1, not to him.
To
The defendant number 2, intimating about the existence of clause 9 and the correspondence which had taken place between the plaintiff and the defendant number 1 in that regard. Full stop. Next para, we find from the relevant clause, that is clause 9 of the partition deed between the plaintiff and the defendant number 1, that the specific provision thereof was that a prior offer of purchase has to be given with notice of 60 days to the plaintiff before selling out the property to a third party by the defendant number 1. Full stop. In the event the plaintiff was agreeable to purchase the same at the then prevalent appropriate value, comma, it would be incumbent upon the defendant number 1 to sell the property to the plaintiff. Full stop. Only in the event of refusal on the part of the plaintiff to do so, comma, would it be open to the defendant number 1 to sell it to a third party. Full stop. Next para. In the present case, comma, by his letter dated February 11, 2012, comma, although pointing out the discrepancy in giving only 7 days prior notice, comma, the plaintiff categorically expressed his willingness to purchase the property at the then prevailing market value and sought a breakup of the components of land and structure regarding such property, comma, which in any event is the premise of the assessment of market value. Full stop. Next para. Thus, comma, we find that there was a clear expression of interest on the part of the plaintiff stroke respondent number 1 to purchase the property at the then prevalent market value. Full stop. Even subsequently, comma, by a letter dated July 9, 2012, written to the defendant number 2 stroke appellant, comma, the plaintiff reiterated such stand. Full stop. Hence, comma, there is no evasive aspect in the acceptance of the offer under clause 9 on the part of the plaintiff stroke respondent number 1. Full stop. Next para. The mere non-mention of the exact quantum of consideration by the plaintiff is immaterial, comma, since the rider in clause 9 was the agreement, the interest to purchase the property at the existing market value, which was precisely done by the plaintiff in his reply dated February 11, 2012. Full stop. Next para. Even if subsequently the property could fetch the consideration of rupees 12 lakh, comma, the said quantum, comma, fixed arbitrarily at the time of the offer by the defendant number 1, comma, could not have been a determinant of the market value. Full stop. It may very well have been that the defendant number 1 was agreeable and actually sold the property at higher or lesser amount than the market value. Full stop. The specific requirement of clause 9 was the willingness in respect of market value, which was categorically expressed by the plaintiff. Full stop. Next para. Hence, comma, there is no infirmity or illegality in the impugned judgment and decree insofar as the cancellation of the sale deed of the defendant number 2 stroke appellant is concerned, and directing a sale deed to be executed by the defendant number 2 as well as the plaintiff in favor of the defendant number 2 as well as the defendant number 1 in favor of the plaintiff. Full stop. However, comma, since it is the defendant number 2 who gets substituted by the plaintiff by virtue of exercise of the prior purchase right, comma, in all fairness, comma, it is only the defendant number 2 stroke appellant who is entitled to the consideration amount of rupees 12 lakh along with interest, comma, if any. Full stop. Next para. It is submitted by learned counsel for the plaintiff respondent number 1 that pursuant to orders of this court, comma, the amount of rupees 12 lakh has already been deposited with Registrar General.
No, my lord, interest bearing, my lord, kindly come to page 145.
With whom? Deposited to whom?
The sale deed has been
Deposited in the trial court.
Executing court.
Let it go down as executing court.
Executing
deposited
interest bearing deposit scheme in nationalized bank.
in the executing court and has since been invested in in an interest bearing account in a nationalized bank. Full stop. Next para. Accordingly, FAT 164 of 2022 is allowed in part, comma, to the limited extent that the impugned decree is modified to the effect that the amount of rupees 12 lakh, comma, which has already been deposited in the executing court by the plaintiff stroke respondent number 1 shall be released in favor of the defendant number 2 stroke appellant by the concerned department by the executing court along with interest, comma, if any accrued thereon, comma, after deduction of statutory expenses of the executing court. Full stop. Next para, it is amply clarified that insofar as the rest of the impugned judgment and decree is concerned, comma, the same is hereby affirmed. Full stop. It is expected that the sale deed as directed by the trial court shall be executed at the earliest by the defendant number 2 stroke appellant as well as the defendant number 1 stroke respondent number 2, comma, within an outer limit of 60 days from date. Full stop. No order as to cost. Interim order, if any, stands vacated. A formal degree be drawn up accordingly.
Possession pursuant to the execution of deed, possession is yet to be taken. Executive court may proceed with this. Kindly.
Next para. It is further clarified that the executing court shall thereafter proceed with the executing case. The execution case shall proceed in accordance with law in terms of the above directions.
Get full. Get full.
Thank you.